GMCPC ಎಲ್ಲ ಕೊಡಿ. Monday on seniority, give it.
Your Lordship,
All.
it was moved on 2nd June and was not.
Maybe, give it, yes. Extreme emergency, wait. Otherwise, general memos of GMCPC, please give. Vacating interim orders, I'll take, wait. Give all the memos.
Your Lordship, it was moved on 2nd June and still didn't come.
Maybe,
up
no
on
problem, give it, yes.
It's very urgent, Your Lordship.
Very urgent. 2nd June in the urgency, ivaga urgency.
Move ಮಾಡಿದ್ದು on 2nd June.
Wait. Give all the fresh matters, give. GMCPC kodi, LABDA kodi. VDA matter, give. 10 memos also, give it. LABDA will come on Thursday, give it. More memo ಹಾಕೇನೆ 5,000 ಮೆಮೊ ಆಗಿದೆ ಅಲ್ಲಿ. Wait. ಕೊಡಿ. Give it, yes. Service matters, wait, I'll take. Friday ಬರಲ್ಲ, Tuesday, next Tuesday. Wait, ಮಧ್ಯದಲ್ಲಿ ಇರಬೇಡಿ, ಎಸ್. 8th court ಅಲ್ಲಿ 8th ಯಾವ್ದು ಕೊಡ್ಬೇಡಿ ಈಗ, I'll take it, wait, ಬೇರೆ ಎಲ್ಲ ಕೊಡಿ. ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಕೊಡಿ ಸರ್. ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್ ಸರ್? ಏನ್ ಮಾಡೋದು ಸರ್? ಎಸ್, 2021 ಇಂದ ಆಗಿದೆ, ನಾನ್ ಕಾರಣ ಅಲ್ಲ ಅದಕ್ಕೆ. ವೈಟ್, ಎಸ್, ವಿಲ್ ಸಿ. ಎಸ್, ವಿ ಶುಡ್ ಹ್ಯಾವ್ ಮೂವ್ಡ್ ದ ಅರ್ಲಿಯರ್ ಬೆಂಚಸ್ ಆಲ್ಸೋ. ಮತ್ತೆ ಹಂಗೆ ಈಗಲೂ ಟ್ರೈ ಮಾಡಿ, ಕೊಡಿ. ಎಸ್, ಕೊಡಿ ಸರ್. CRP ದೆಲ್ಲ ಕೊಡಿ, ಎಲ್ಲ ಸೀನಿಯಾರಿಟಿ ಮೇಲೆ ಬರುತ್ತೆ, ಕೊಡಿ ಸರ್. ಎಸ್, ಏನದು ಏನಾಗಿದೆ? ಏನು 9 ವರ್ಷ ಆಗಿದೆ? ಯಾರಿಗೆ? ನೋಡ್, ಎಸ್. Don't think as though I am sitting in GMCPC for 10 years now. ಎಸ್, ಕೊಡಿ. ಕೈಲಿ ಏನಾಗುತ್ತೆ ಅದು ಮಾಡ್ತೀನಿ, ಕೊಡಿ. ಎಸ್. Have you filed vacating stay application? ಕೊಡಿ. No, I can't have it at your date. Next Wednesday, next Wednesday is vacating stay. If you want, take it, or take it on Wednesday after the next. Give it. Date will not be fixed according to you. Yes. Next date is on fresh matter. Friday, kodi. Vacating stays, all applications you give. That is not extreme emergency at all. Yes, next. Don't tell me all this. 6 ತಿಂಗಳಿಂದ ಸುಮ್ಮನೆ ಇದ್ದೀಗ extreme emergency ನಾ? What more for memos? Give it. ಹೌದು, seniority-ನೇ. There is some method that is being followed. ಅಂದ್ರೆ earlier advocates ಕೊಟ್ಟರೆ ಮೆಮೋಸ್ ತಗೋಬಾರ್ದಾ ಹೇಳಿ? Then what, sir? I can't take 500 memos. Yes, give it. Indiscriminate, I don't tell anything. Please give, madam. Wait. Yes. Wait. Sorry. Why are you waiting? Give it. Yes. Thursday it will come. Give it. Fresh matter. Monday. Yes. ಏನು urgency ಇದೆ ಅದ್ರಲ್ಲಿ? Extreme emergency ಇದೆ. ಸೊ ಏನಾಗ್ಬಿಡುತ್ತೆ, ನಾಳೆ ಪ್ರಾಪರ್ಟಿ ಹೋಗ್ಬಿಡುತ್ತಾ? ಮಂಡೇ ಕೊಡಿ. ಎಸ್,
Your Lordship, this.
ಗಿವ್ ಇಟ್ ಸರ್. ಎಲ್ಲೇ ಬಿಡಿ ಅದೆಲ್ಲ ಕೊಡಿ. ಗಿವ್ ಇಟ್. ಕೊಡಿ ಸರ್. ಎಸ್, ಏನ್ ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರನೇ ಬರೋದು. ಎಲ್ಲರೂ ಇರ್ಲಿ, ಯಾವ ಬ್ರಾಂಚ್ ಎಲ್ಲರೂ ಇರ್ಲಿ. ಎಸ್.
Your Lordship, this was moved on 2nd.
Wait, he is telling. Yes. Construction. Where after stay, how is construction going on? End of the list ಇಲ್ಲ ಸರ್. Tomorrow. ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ರಾತ್ರಿ ಆಗೋಗುತ್ತಾ? ಹೇಳದ್ರಲ್ಲಿ ಅರ್ಥ ಇದೆ. ನಾಳೆ. ಎಸ್.
The matter is a remanded matter, my lord. We are come to the respondent. The petitioner has challenged the 14 rule for application, my lord. The matter is coming up on the 18th, my lord.
Finally, why finally?
Evidence finally, my lord. The
18th. Yes.
Your Lordship, the memo was moved on 2nd.
Don't tell that. What is the urgency? You tell me.
Pertains to a commercial was filed after 7 years of
Give it.
termination.
Friday. Yes.
My lord,
Friday
filing
ಹಾಕಿ.
memo, my lord. Idralli now I have got interim stay, my lord.
You have got interim stay.
Interim stay, but
Thank
still
you.
the respondent is harassing me, my lord. So
File a contempt.
end of the list.
No,
I hope,
sir, nothing
End
to
of the list.
No, end of the list. I am not taking that memo at all. Stay ಇದೆ ತಾನೆ? ಇದೆ ತಾನೆ? ಇರಿ. Yes. ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ. Next.
Pending matter, my lords. In this, the trial court has
Pending
accepted-
matters, give sir, please.
Well, what has happened in this, my lords, the written statement is taken after lapse of 7 years, my lords. Well, there is a urgency now, it has come for different cross, my lords.
Which year is it matter?
2024, my lords.
If you come, give it. Yes.
Well, any date may be fixed, my lords.
Give it. Yes, if you come.
In this case, we have filed the injunction suit before the.
Fresh pending sir. Pending matter.
ಇಲ್ಲ, fresh matter.
Monday ಕೊಡಿ.
ಅಲ್ಲ, that trial court has
Monday ಬಿಟ್ರೆ ಡೇಟ್ ಇಲ್ಲ, Monday ಕೊಡಿ. No tomorrow. Yes.
that respondents are trying to.
Tomorrow there are already 180 matters. No tomorrow. Give it. Yes.
My lords,
ನೀವ್ ಯಾರು? ಏನದು? Seniority. Correct. ಕೊಡಿ. Monday ಹಾಕಿ ಮೇಡಮ್.
Respondents are trying to alienate the property, my lords. Fresh matter, kindly take.
Monday.
Tomorrow.
No tomorrow.
2007 FDP, my lords. The trial court allowed the impleading application, my lords. They are completely strangers, my lords. Now they seek for modification of preliminary.
Monday.
My lords, 19th ಇದೆ trial court.
Monday ಏನ್ ಡೇಟು? 21st. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಟೈಮ್ ತಗೊಳ್ಳಿ. ಇನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ ಎದುರ್ಕೊಂಡು ನಾನು ಡೇಟ್ ಕೊಡ್ಬೇಕಾ ಇಲ್ಲಿ?
No, my lords.
ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ ಡೇಟು. ಎಸ್.
Stay was granted, but it was not expected. Now the matter is coming up before the trial court, mildly hearing on
ಇದೇನ್ ಪೆಂಡಿಂಗಾ?
pending for extension of.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ನಾಳೆ ತಗೊಳ್ಳಿ.
I filed the petition to challenge the contempt application, which is filed to harass me, my lord.
Contempt application.
Contempt petition, which is registered as contempt petition, my lord.
Where?
in
Before
trial
the civil court?
It's in Ramnagara, my lords, Magadi.
ಅದು ಎಲ್ಲಾದ್ರೂ ಇರ್ಲಿ,
My-
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿ ಕೊಡಿ. ಎಸ್.
FIR was filed on similar grounds, which was resulted in B report.
Monday.
My lord, criminal petition 482, subsequent petition, parties have settled, my lord.
Friday.
But tomorrow, my lord, parties have settled. To
Successive
report-
petition.
Successive petition, parties have
Friday
settled.
or next Friday.
Settled, my lord.
Settlement.
Yes,
All right.
tomorrow, my lord.
Tomorrow.
Lords, vacating IA, my lords. James.
Vacating IAS ಕೊಡಿ ಅಲ್ಲ.
Suit for partition, that pleading application allowed on the ground that flat the adoption deed was.
Fresh matter.
This one.
Monday according to seniority. ಬೇರೆ ಹಳೆ ಮೆಮೋಸ್ ಇದಾವೆ. Very good sir. Good. No problem. Yes. Give it. Yes. ಮತ್ತೇನ್ ಕಾಯ್ತಾ ಇದ್ದೀರಾ ಎಲ್ಲ?
Service matter, my lords.
ಎಲ್ಲ ಸರ್ವಿಸಾ?
My lord,
ಒಂದ್ ನಿಮಿಷ. ಸರ್ವಿಸ್. GMCPC ಯಾವ್ದಾರು ಇದೆಯಾ? ಕೊಡಿ ಎಲ್ಲ.
my lord, 482.
No dates in pending matters, please give. ಎಲ್ಲರೂ. Am I not hearing there? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. CRP ಇದ್ರೆ CRP ಡೇಲ್ ಬರುತ್ತೆ, GMCPC ಬರುತ್ತೆ ಕೊಡಿ. Give it. Give it, sir. Give all the memos of GMCPC.
Madam.
ಎಲ್ಲೇ ಬಿಡಿಯನ್ನು ಕೊಡಿ. Those days will come. No dates in anything, please give. Yes. This week, no dates in anything, give. Wait. Service matter. Wait. Yes. Kodi. Give, sir. Yes. Huh? In which court? When? If you have not come, what can be done? Can't help, sir. No, there must be a reason for vacating, otherwise I would not vacate it that way. Yes. Anyway, give it. Next week, ಹಾಕಿ ಅದು.
My lords, this was settlement, my lords.
ಇನ್ಯಾವ್ದು LABDA, GMCPC, CRP ಯಾವ್ದಿದೆ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
My lord, CRPC.
LABDA, GMCPC, CRP, all you give. All you give.
My lord, CRPC 482, my lord, part-time matter before your lords.
That will come on Fridays.
My lords, 482 only, my lords.
Give it. No tomorrow, give it. Yes. No tomorrow, sir. Yes. Give it. Why are you holding the memo? Give. No dates, give it, yes. ಏನ್ urgency? Disposition na? ಏನ್ disposition?
Authorities have not passed an order. Now, my lords, because of the order of the court, I'm not challenging it.
What order they have, what order?
Associated proceedings insofar as the other concerned lands have been filed.
Huh.
Now, my lord, I have not challenged the acquisition proceedings. Now, my lord, they're trying to discuss is me.
Right, Thursday.
My lords, this was settlement, my lords. 482.
Settlement, give it, sir, Friday. Settlement ಅಂತಿದೆ. That's for settlement. ನಿಮ್ದು FR comply ಆದ್ರೆ ಮಾತ್ರ ಬರೋದು. And that too according to seniority. Yes. ಕೊಡಿ. Filed whatever, give it. Give it, sir.
CIP matter.
Pending matter. No, give it. It will come.
I entered into a joint development agreement. There
Fresh up pending, sir.
pending, my lords, for Thursday, my lords. I am unable to execute the terms of joint.
Oh, no problem, sir. No, give it.
Thursday, my lords.
No Thursday, give it. Yes. Give it, sir.
Supreme Court, it's covered by Supreme Court. Judge.
Maybe, all covered, everything, yes.
One fresh matter, there is a threat of disposition. Not commissioner's report is under challenge. Not in the commissioner's report, not it is allocated to not the respondent hearing. There is a threat of disposition.
Who is that with the cap there? What, you come for a jaunt or the court? You are not in a park. Yes.
But there is a threat of disposition. Not tomorrow.
ನಾಳೆ ಆಗಲ್ಲ ಕೊಡಿ. GMCPC ಕೊಡಿ. ನಾಳೆ ಕೊಡಿ.
Kindly, my lords. The learned trial court has permitted, the matter is set down before the learned trial court tomorrow, my lords. The,
For what?
for filing amended plaint, my lords.
ಅಷ್ಟೇನಾ? All right.
Inconsistent cause of action, inconsistent plea has been taken, my lords.
All right, yes. Take advantage of it. 2:30.
Service matter.
ಒಂದು ನಿಮಿಷ ಇದೆಲ್ಲ FR 2:30. ಬೇರೆ ಎಲ್ಲ ಆಯ್ತಾ?
Successive petition.
CPC ಕೊಟ್ಬಿಡಿ ಸರ್. No dates I'm giving. Monday. ನೀವು 10 times ಕೊಟ್ಟರು ಅಷ್ಟೇನೆ Monday. Give it, yes. CPC ಎಲ್ಲ ಮುಗಿತಾ? Yes. So,
Order where my application for production of documents has been rejected. Matter is finally set day after tomorrow for final arguments.
tomorrow. Yes. Service matter ಏನಿದೆ urgency ಕೊಡಿ.
FR numbers.
Give it. Service matters ಎಲ್ಲ tomorrow ಕೊಡಿ.
My lords.
Urgency ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ. ಇಲ್ಲ 10 weeks adjourn ಮಾಡ್ತೀನಿ.
2:30.
Only fresh matters, not pending
Fresh
matters.
matter, fresh
Don't move pending matters.
Fresh matter, 2:30.
2:30 ಯಾಕೆ?
Revision order has been passed note yesterday. 2019 notes, they already been promoted notes as an Havaldar.
Reversion order.
Reversion order.
ಕೊಡಿ. 2:30 ತಗೊಳ್ಳಿ.
My lords, I was on deputation.
ಒಂದು ನಿಮಿಷ. ಹಿಂದೇನು?
According to 482 petition, my lord, as per the circular, my lord, the co-accused matter has been already decided by this honorable court, my lord. Because of that reason, this 482 petition, my lord, which is what this petition, is matter getting decided before this honorable court, my lord.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Urgency, my lord.
ನಾಳೆಗ? ಏನ್ ಅರ್ಜೆನ್ಸಿ ನಾಳೆ ಅಂತದ್ದು?
Charge frame, my lord.
ಕೊಡಿ. ಅದು ನಾಳೆ ತಗೊಳ್ಳಿ.
That's service matter, one suspension, one is.
FR number.
ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ. ಅರೆ FR ನಂಬರ್ ತಗೊಳಕ್ಕಾಗತ್ತಾ?
Because there is a minor officer.
No, go and comply. Oh, this day has not come that I take on FR number, sir. Council submission are ಕೊಟ್ಬಿಟ್ಟು ಬನ್ನಿ. That will not happen.
So that my file is already went to board branch.
I don't know. If it is not complied, it will not come. FR number list ಮಾಡಿ, ಅದು start ಮಾಡ್ಬಿಡ್ತೀವಿ. FR number list ಮಾಡಿ. And pass orders on FR numbers, you will never comply lifetime.
Because is, we thought that matter will get listed before that on.
Maybe, sir, what to do? It will come tomorrow.
Fresh
Go and
matters-
comply. Yes.
Service fresh matter.
Fresh matter service kodi nalage.
Both matters.
Only fresh matters.
Only fresh.
Pending don't give.
No,
My
Fresh
lords.
matter, my lord, urgency for end of the list.
Then transfer,
Transfer, I'm due for retirement, aided institution, if I'm relieved.
230.
Great.
ಎಷ್ಟು memo?
ಎರಡು connected matters, both belong to the same institution.
Pending alla ತಾನೆ.
Pending alla fresh consecutive effort.
Come at 5 o'clock.
Very good,
ಬೇಡ ಬೇಡ. Come at 2:30.
very good.
My lords.
In this case,
ಯಾವ
CPC memo.
ಕೊಡಿ.
My lords.
Fresh
Both are fresh memo.
it will come according to seniority and
My lords. This is a pending matter, my lords, but.
Fresh sorry,
Pending.
service.
Please, my
No,
lords.
no, don't give. Yes.
My lords,
Pending matter.
but I'll be dispossessed, my lords.
Dispossession service.
The transfer order is being challenged here, my lords. I'm on deputation. So he'll report to my place, my lords. My original place was also gone.
Notice ಆಗಿಲ್ವಾ ಅದರಲ್ಲಿ?
Notice agi adu, my original place is been already stayed, my lords. On deputation, I've been here. My children are all shifted to,
ಅಲ್ಲೇ move ಮಾಡಿ. Pending matter move ಮಾಡಿ.
at least tomorrow,
No,
my
if I
lords.
take one pending matter, it become chaos. Only
Yes, my
fresh
lords.
matters. No, madam. Yes.
For vacating of stay, it's two review petitions, my lords.
Next week vacating stay, give it.
It's land acquisition fresh matters, my lord.
Give it.
Assistant commissioner may pass.
Give
order
it and
tomorrow, my lord.
stop the memo. ಕೊಡಿ ಇಲ್ಲ.
CPC fresh
ಕೊಡಿ
memo.
ಸಾಕು. Call the cases.
Madam,
Yes.
madam,
Lords,
the
one last,
commissioner has been appointed.
ಕೊಟ್ಟಾಯ್ತಲ್ಲ, what again?
lords, just one more memo. It's
No,
a
no.
CR.
Commission, my lords.
Girish,
submission,
no
madam.
adjournment.
Madam,
Yes.
only one submission in that fresh matter.
My lords, only statement of objection has been filed, my lords, on Friday.
Wait, sir.
During the cross examination,
My
we
lords.
had admission in respect of the shoot certificate.
ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ ತಾನೆ?
ಕೊಟ್ಟಿದ್ದೀನಿ. Urgency ಇದೆ
ಏನ್ urgency ಇದೆ?
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ವಾರೆಂಟ್ ತಗೊಂಡ್ರೆ they come for inspection.
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
ಅಲ್ಲ,
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
ಅವ್ರ ಪ್ರಾಪರ್ಟಿ
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
ಅವ್ರ ಪ್ರಾಪರ್ಟಿ
ಅಲ್ಲಿ ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ ಅಂದ್ರೆ
ಏನಂತಂದ್ರೆ
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಹೋಗಿ ಮೆಜರ್ ಮಾಡಿದ್ರೆ ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
ಮೆಜರ್ ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ ಇವಾಗ
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
ಏನಂತಂದ್ರೆ
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅರ್ಜೆನ್ಸಿ ಡೋಂಟ್ ಪ್ಲೀಡ್ ಅರ್ಜೆನ್ಸಿ ಹಿಯರ್. ಗಿವ್ ಇಟ್. ಎಸ್.
ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ
Friday.
ಅಡ್ಮಿಟೆಡ್ ಇನ್
Friday, sir. Friday.
My lords, it's a CRP. The apart.
Give it, madam. CRP next week. Yes. No adjournment. ಏನು December 2 ಯಾವುದು?
My lords.
I'll take 8th court. I'll take at 2:30.
Lordships kindly, sorry for making mention.
My lords, only one submission, my lords, that.
Girish, no, I am not granting any adjournment. I'll take it at 2:30.
My lords, statement of objection has been filed, my lords. That
so
has
what?
not been put up, my lords.
Don't
And
worry about
another
that.
one submission is that, my lords.
Don't worry
My
about
lords,
that.
another one submission is that, my lords, submission is that, my lords, ESG services has been engaged, my lords. So convenient date, my
I
lords,
told
convenient
you
to
I
the
will not
lordships.
grant 1 day's adjournment from today. I am going to hear the petitioner and pass the orders. Yes. If you are ready, be ready. Enough is enough. Yes.
Your lordships kindly, sorry for making mention.
There are
Lordships.
10 adjournments granted
My
to you,
lords,
Girish.
statement of filed, my lords, already filed, my lords. On
No
Friday it
problem.
has been filed, my lords.
No problems. Yes. 2:30, I'll take it. Whoever you want to get.
Lordships kindly,
All the cases, madam.
My
your
lords,
lordships kindly, your lordships can.
Yes. For settlement.
I represent the second respondent complainant.
Amount of 50 lakh.
I represent the second respondent.
Mike ತಗೊಳ್ಳಿ sir, Sandeep.
And we have settled the issue, my lord. Now we are filing a
Offense
joint.
ಏನು? ಓ ಇವ್ರದ್ದು ಇದು ಸೆಟ್ಲ್ ಆಗೋಯ್ತಾ?
Please, my lord. Please.
ತಮ್ಮ ಮುಂದೆ ಮುಗಿಲಿ ಅಂತ.
Yes.
But I am filing
Terms of settlement.
Please. Joint.
50 lakhs DD.
Joint. Joint.
Where the terms of settlement? Who is petitioner number 4?
Lord, she was outside, she
Not
couldn't
signed.
sign. Now she is here, my lord, she will sign it now. Will sign it, she has come.
The complainant is here.
Complaint.
Please, my lord. He is present.
You are the complainant. And what is that headgear? Huh? Yes. All cases settled, huh?
There was only one case.
Only one case. Yes. In terms of, Jivai, ಎಲ್ಲರೂ ಸೈನ್ ತಗೊಂಡ್ಬಿಡಿ.
Order sheet signatures. Number 2.
I appear for the petition, my lord. Second petition, my lord, 311. My lords were kind enough to grant me an indulgence, my lord.
ಮತ್ತೇನಾಗಿದೆ ಈಗ?
ಇಲ್ಲ, additional documents ಅಷ್ಟೇ ಕೊಟ್ರು. What is her qualm is, her character was assassinated while examination. No further, re-examination was done. She is saying she want to clarify something, that's all.
The petitioner shall serve learned.
ಅದಕ್ಕೆ ಒಂದು ಟೈಮ್ ಇರ್ಲಿ ಮಲಾಡ್ ಮತ್ತೆ ಅಲ್ಲಿ ಡ್ರೈವ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ
Any day, my lord, any day.
ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕು ತಾನೆ ರೆಸ್ಪಾಂಡೆಂಟ್. The learned HCGP is directed to accept notice for the first respondent. Time ಕೊಡದೆ ಯಾವುದು ಮಾಡದೆ ಸ್ಟೇ ಮಾಡದೆ. For the respondent, petitioner to serve on the counsel who represents the respondent complainant before the concerned court. List the matter on next Tuesday. Interim, there shall be interim mode of stay of further proceedings before the concerned court till the next date.
So great.
The password.
4.
3 she is here.
ನೀವು ಇದ್ದೀರಾ? Yes.
3.
Madam, now we have requested them to give an application. If you are willing for that, the order may be passed. With all the details, whoever are the beneficiaries who are deceased, let them give an application. We will consider accordingly.
Your lordship, if the application is allowed, then we can give a representation to the university.
What up? This application?
Please, your lordship.
Correct. This application will have to allow.
Yes.
They will have to come on record.
Yes, sir.
And then we will do it.
Yes.
The, Kodi madam. I'll close it.
Yes. Yes.
ಈ ಕಲ್ಯಾಣ್ ಶೆಟ್ಟಿ ಇದಾರ ಸದಾನಂದ?
Kalyan, Ashokar Kalyan.
You are Kalyan Shetty's colleague?
Yes.
This court on 1st July 2021 had passed the order, operative portion extract ಮಾಡಿ, had passed the following order. By the time the subject order could be passed, it transpires that few of the petitioners had died and their legal representatives had not been brought on record. In that light, the present petition is, application is preferred, seeking to allow the legal representatives of those petitioners on record. The learned counsel for the petitioner has placed on record all documents which would demonstrate that they are the legal representatives of the deceased petitioners who stood deceased as on the date of pronouncement of the order. As a matter of fact, few of the petitioners had died even before the pronouncement of, long before the pronouncement of the order. The learned AGA, Mohammad Jafar, on verification would submit that the legal heirs of these, legal representatives of the deceased petitioners, the petitioners are in fact the legal representatives of the deceased petitioners. And if they submit appropriate application enclosing all the documents in their possession of being the legal representatives and their claim for pension would be redressed. In that light, the applications so filed seeking to bring these proposed applicants, petitioners on record stands as legal representatives of the respective petitioners stands allowed. The petitioners shall now the present legal representatives of those petitioners who were deceased shall submit necessary application along with all the necessary documents to the satisfaction of the state for release of pension or pensionary benefits or the benefit of the order that is passed by this court as quoted supra. In the light of the said submission, the petition stands disposed. The state shall not brook any further delay in redressing the grievance of these petitioners. It shall be redressed as expeditiously as possible.
My lord, may I make one more submission?
ಹೇಳಿ.
My lord, the earlier petitions, my lord, they did not comply with the court order. So contempt was petition, my lord, filed. Then also
ಈಗ
they
ಫಸ್ಟ್ ನಿಮ್ದಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿ.
ಇಲ್ಲ ಅದು ಉಪಯೋಗ ಆಗಲಿಲ್ಲ, ಮತ್ತೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದೀವಿ. So my lord, your lordship may kindly add, my lord, if they don't get this thing, they are entitled to pursue the remedies as if they are on record.
The petitioners are entitled to pursue all remedies available in law in the event of non-compliance of, in the event of grievance of the petitioners being rendered, grievance of the petitioners not redressed.
Please,
In terms of the said order, in terms of subject order. Next.
Please.
ये ಹಾಕಿಲ್ವ ಅವರು ಹಾಕಿದ್ದಾರೆ ಆರ್ಡರ್ ನಯ್ಯೆ ಇದೇನಲ್ಲ ಆರ್ಡರ್ ನಯ್ಯೆ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ
For
memo for withdrawal
Hearing for petitioner, madam.
settlement
Please, madam.
only the first matter, my lord. I'm appearing for the petition and this connected matter that needs to be kept pending.
all right dealing 4.1 counsel for the petitioner submits the foral order counsel for the petitioner submits the issue has been settled between the parties and BDA then
No,
settlement
madam. During the pendency of the writ petition, the grievance of the petitioner has been redressed by the respondent number 2.
Yeah. The learned counsel for the petitioner submits that during the pendency of the petition, the grievance of the petitioner has stood redressed. In that light, the petition would not survive for consideration. Memo for withdrawal ಹಾಕಿದಾರಲ್ಲ in terms of that memo. Yes, 4.1 dealing ಮಾಡಿ.
4.1 is still pending. We have only asked for certain basic amenities to be provided to the layout.
Which layout?
Arkavati layout 19 block, my lord.
My lord,
My instructions as
Who
of
is that
this-
officer?
officer, my.
Why? Who summoned her?
My lord, she came by herself.
Then wait. After I ask something, let her talk.
No.
You
I-
have called.
I asked for instruction.
Then
She
you
might
take
have-
instructions.
No, my lord,
Yes.
by mistake she might have come.
Now, what is the matter?
My lord, this is with regard to amenities to.
Street
Arkavati
lights,
layout.
water connection, drainage
Yes, my
facilities.
lord. My lord, there was earlier direction, my lord, 6 months. Then we filed review. Because it needed cooperation from all the departments. Wherein even we had even issued direction to BWSSB and others. This is a layout where division bench of this honorable court also passed a judgment. Due to that, my lord, we Keshunar and Honorable Justice Keshunar and committee was we had referred the matter. Now it has been dealt with there also.
Correct.
Now we want to form the road, my lord. It is in the process, my lord. We have also issued tenders. That's what my officer had informed.
When do you come? When do you complete?
Now kindly give us one 2 weeks time, my lord. I'll file the status report, my lord, with regard to the.
My lord, the allotment is of 2014.
True. ಈಗ ನಾವು ಅವ್ರು ಮಾಡ್ತೀನಿ ಅಂತ ಇದ್ದಾರೆ. ಈಗ ಪಾಸ್ an order, the challenge it ಎಲ್ಲ ಸೇರಿ 6 ತಿಂಗಳು 1 ವರ್ಷ ಆಗುತ್ತೆ. So wait.
ಇಲ್ಲ ಒಂದ್ಸತಿ dispose ಆಗಿತ್ತು ಸ್ವಾಮಿ with the
ಅದಕ್ಕೆ
direction.
ತೊಂದರೆ ಇಲ್ಲ. Now 15 days time is asking to give the status report. I'll look into the status report and hold on to them.
ಆಯ್ತು.
Yes. The learned counsel Gautam Dev Ullal representing the BDA on instructions from, who is the officer? Who is the officer?
Renuka Patil, my lord. She is executive engineer.
Of designations.
Executive engineer,
The
BDA, North.
executive engineer north of the Bangalore Development Authority or the Bangalore Development Authority submits that if 2 weeks time is granted, all 2 weeks time is granted, the status report of all the grievances of the petitioners would be placed on record. List this matter on 29th. The status report with regard to all amenities, the status report with regard to efforts being initiated to redress the grievance of the petitioners be placed before the court on the next date. On 29th.
20.
Yes.
Bill number 5.
Withdrawal.
No, memo not pressing.
Memo not pressed.
ಅಲ್ಲ.
Oh, memo ಹಾಕಿದಿರಲ್ಲ. Yes. In terms of memo. Next.
My lord, scene is held up in some other court, my lord. Next week on date ತಗೋಬಹುದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ತರ ಆಯ್ತು.
ಇಲ್ಲ ಇಲ್ಲ, just next week.
ಅವರೇ ಮೂವ್ ಮಾಡಿದ್ರು.
ಇಲ್ಲ ಮಾಡಿದ್ದು ಅದಕ್ಕೆ
ನೀವೇ ಮೂವ್ ಮಾಡಿದ್ರ?
Yes, my 13 held up ಆಗಿದೆ my lord. ಅದಕ್ಕೆ just
ನೀವೇ
next
ಮೂವ್
week
ಮಾಡಿದ್ರೆ we'll remove it now.
next week ಅಂತ ತಗೋಬಹುದು.
List the matter after 4 weeks.
No, just one date ಕೊಡಬಹುದು ಅದಕ್ಕೆ next week ಅಲ್ಲ.
Yes, next. 2021 ಅಲ್ವಾ ಒಂದು ಕೊಡಿ.
Yes, my lord.
List on 29th.
Yes, my.
ಮತ್ತೆ ಮೂವ್ ಮಾಡಿ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ. Yes.
Interim order can be extended.
Interim order subsisting will continue till the next date.
21st, some inconvenience.
29th sir. 29.
Please.
2:30 ಗೆ ಹಾಕೋಬಹುದು ಸರ್. ಇದು ಸಿಂಪಲ್ ಮ್ಯಾಟರ್ ಮುಗಿಸ್ಬಿಡ್ಬೋದು.
29th ಇರ್ಲಿ, ಅವತ್ತು ಕಮ್ಮಿ ಇರುತ್ತೆ ಮುಗಿಸ್ ಅನ್ಕೊಂಡಿದೆ.
7.
Please.
for petitioner note.
ಇನ್ ಜಾಸ್ತಿ ದುಡ್ಡು ಕೊಟ್ಟಂಗಿಲ್ಲ ಸ್ಟೆಪ್ಸ್ಗೆ.
ಇಲ್ಲ, the steps here ಇಲ್ಲ. In fact, the last
Lordship,
occasion,
I filed a memo
when I
for it.
mentioned the legible copies at that, so it was accepted. but
Legible typed copy if even it
Can be dispensed from order. So supporting
office
copies are there.
objections
I am in the
stands
connected.
overruled.
Lordship, I
Lord,
appeal for the
after
respond number 3
20
and
years
4.
from the date of allotment and sale deed executed by the BDA. Lord, this site belongs to the petitioner was subjected for auction sale without even intimating the petitioner. Lord, the endorsement which was initially
intermodal ilva?
Intermodal ಇದೆ. Then despite restraint order, my lord, the private respondents have proceeded with the development of the property. And unfortunately, my lord, though contempt petition was filed.
Who are the private respondents here?
Lord,
Lordship, I appeal
they
for
are
respond number 3
they are
and
the
4.
stated to be the auction purchasers.
Stay ಯಾವಾಗ ಆಯ್ತು?
My lord, so far as
ಮಾಡ್ರಿ ಯಾವಾಗ ಸರ್?
please.
We'll post it in preliminary hearing. Wait.
Your Lordship.
List the matter on
In connected.
22nd in
Lordship.
preliminary hearing.
I have filed a memo for retirement of respond number 3 and 4, my lord.
Who has appeared, sir?
Connected matter.
21656, my lord.
Connected matter ಅಲ್ಲ.
I am representing
In fact,
petitioner in the connected matter, my lord.
Vijay
There, my
Kumar.
lord, respond number 3 and 4 have filed a memo for retirement.
3 and 4 ಯಾರಿದ್ದಾರೆ ಈಗ? ಪೃಥ್ವಿ ಒಡೆಯರ್ has filed it.
Notice has to go to the petitioner.
ಅಲ್ಲ.
Respond number 3.
ಎಲ್ಲಿ? Let somebody come on record. Where is the acknowledgement of?
That is, I have filed along with my memo.
What acknowledgement?
That he has taken.
Taken away the papers?
Please, my lord.
The
NOC.
counsel for respondents 3 and 4 have filed a memo for retirement, appending to it the acknowledgement of receipt of all papers from the hands of the petitioner.
The respondent 3 and 4.
Sorry, respondent 3 and 4. In that light, the Prithvi Wadeyar, counsel respondent for respondent 3 and 4 is permitted to retire. Issue notice to 3 and 4.
This the interim order may kind.
Interim order subsisting would continue till the next date of hearing.
A date.
ಹಂಗಾರೆ 29ಕ್ಕೆ ಬರ್ಲಿ. Yes.
Oblige.
8, no, serial number 8. I'll be filing my NOC wakalat for the petitioner.
You will be filing. What's the problem?
Malos, I'll be filing it today, Malos.
File it.
And Malos, there is one urgency in the matter, Malos.
After you're filing a retirement memo, where is the urgency in the matter?
Because it's a 1994 acquisition.
NOC ವಕಾಲತ್ ಆಗ್ತಾ ಇದ್ದೀರಾ?
Ivat wakalat.
ಆಯ್ತು ಹೇಳಿ.
A date may be fixed, my lords, next Tuesday, my lords.
Next
Because
Tuesday.
it's 1994 acquisition.
2023. Yes, list
My
on
lords, the 6th round of litigation.
22nd.
Much okay.
22nd in preliminary hearing. Rectification of office objections ಏನದು? IA for direction.
ಅದು ನಾನು ಮಾಡ್ತೀನಿ ಇವತ್ತು.
In the event, the matter be listed in the event office objections are complied with. Yes.
9.
With your lordships kindly, my lords.
IA for vacating stay.
My lords, I have not written the date of the interim order, which I'll correct, my lords. That is the objection raised on the. I'll write it. Only one date is missing, which I'll write. I checked just now. Now, my lords may permit me to please file this map. I wanted to show, my lords, that it is coming on the main road, arterial road, which enters into the layout which we are proposing to develop. Now, the whole layout is getting blocked because of that. In terms of the merits of the matter, my lords, I can argue at any. I'm ready to make some.
List on 22nd in preliminary hearing.
My lords, only that road portion we may be permitted to work on. I'll just show the road.
ಒಂದು ವಾರದಲ್ಲಿ ಏನು ಮಾಡ್ತೀವಿ? ಒಂದು ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
No, my lords.
2024 interim order ಕೊಟ್ಟಿರೋದು.
Please.
Entry model need to be extended.
ಈ ರೋಡ್ ಬ್ಲಾಕ್ ಮಾಡ್ಕೊಂಡು ಏನು ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
That's road. Actually, there is a status quo order, and we, according to us, we have taken possession. We just want to seek a clarification that will proceed with the work.
Tuesday will do it. In preliminary hearing on Tuesday.
Please, deeply obliged.
Rectify the office objections.
Right away. Thank you. Please.
The council seeks a day's time to rectify the office objections. The day's time is granted. In the event they stand rectified, list on 22nd.
Civil suit is pending, my lord. KDB is a party in that. Only prayer is if the compensation is paid, released, it may be deposited before the trial court. That is the only prayer.
FPF, WPA, R3 and 4 ಯಾರು?
Opposite parties in the civil
ಅವರು
suit.
ಕೇಳಿದ್ರೆ ಏನು ಆರ್ಡರ್ ಕೊಡಲ್ಲ.
Suit all pending ಇದೆ.
Fresh process fee. A week's time is granted to do the needful. Next.
ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲಿ OS pending ಇದೆ. ಅಲ್ಲಿ
ಇರ್ಲಿ ಅದೆಲ್ಲ ಆಮೇಲೆ ನೀವು ಆಚೆ ಕಡೆ ಮಾತಾಡ್ಕೊಂಡಿದ್ದಲ್ಲ ಇಲ್ಲೇ ಹೇಳ್ಬೇಡಿ. Yes. List on list next week. Yes.
I filed a memo for withdrawal of the matter.
Withdrawal, yes, in terms of.
12.
Petitions by me. In the last occasions, this court has granted the interim order.
Non-filing of affidavit.
Yes, my lord.
My lord, sir, affidavit, I will file the affidavit, my
On
lord, in the next day.
18/3/2025,
My lord,
interim was granted.
Where is the affidavit?
I will file that, my lord. sir.
You have filed?
No, my lord, I will file. It may be taken next week, my lord.
Counsel dare to file an affidavit in date kotilala.
No, my
Learned
lord.
counsel for the BDA seeks time, yet again to comply with the order dated 18/3/2025. In the event the affidavit is not filed in terms of the order by the next date, adverse inference would be drawn against the BDA.
The
List on
interim order
20,
may be.
list on 29th, interim order subsisting will continue to the next date.
13.
Unclaimed. R4, the postal shara is indicative of the fact.
Undertake to file wakalat for R3, my lord.
R3
This is a
ಅಲ್ಲ.
case, my lord, surface matter. Civil court
ಇಲ್ಲದ
declined.
ಇದು?
ಅದನ್ನೇದು, ಹೌದು.
S5.
But in this case, Lord, the property, the plaintiff before this honorable, the petitioner before the honorable court or the plaintiff before the trial court.
Yes, sir.
They filed the suit for partition and separate possession.
Yes, sir.
The concise fact of the case is, Lord,
Yes.
the Yatiraj Mudaliar is on the,
ಮೊದಲು ಯಾರು ನೆಕ್ಸ್ಟ್ ಯಾರು ಅಲ್ಲ, ಈಗ ಸರ್ಫೇಸಿ ಮ್ಯಾಟರ್ ಇದು.
illa surface in
Come to the prayer, sir.
that surface matter, Lord, because for his joint family property,
Yes, sir.
I have not entered this, availed any loan. Because for the joint family
Anything,
property.
it is not maintainable before the civil courts.
Like the, ಇದು partition.
ಏನಾಗಿರೋದು?
Partition.
Lord, what has happened is,
Partition suit after the
after your lordship disposed the writ.
ಕೊಡಿ.
ಇದರಲ್ಲಿ strict ಆಗಿ guideline ಕೊಟ್ಟು court DRT ಮುಂದೆ ಹೋಗಿ ಅಂತ ಇದಾದ್ಮೇಲೆ they file civil suit. Very same. Only the petitioner here is.
But I am not the party, Lord. Sorry to that.
No
submission.
He claims to be.
I am not the party. Lord, this is there. Several parties are there. It's the ancestral
Lordship may kindly see
property.
on 19th March 2025.
Ancestral property. These
19th
petitioners
March
before this honorable
ಈಗ
court.
why are you before the court? Tell me.
Lord, because for that, I have filed the suit for partition and
Civil
separate
court declined to
possession.
grant interim order.
Restrain this defendant from alienating or creating charge over this property. So the trial court has issued the emergent notice, Lord, page 17, Lord. Emergent notice ex parte, against that I
One
filed
minute,
this
sir, one
petition.
minute.
Page 17, Lord.
ಇದು ಯಾರು? ಬೇಬಿ ಅಮ್ಮ.
Baby Amma, first defendant,
Wife of Yatiraj Mudaliar.
Yatiraj Mudaliar.
All right.
The petitioner before this honorable court are the one of the son of this Baby Amma.
No problems. The petitioner is before this court.
Your lordship, I'll undertake to file wakalat, my lord, in
ಆಯ್ತು,
R3.
ಒಂದು ನಿಮಿಷ ಆಮೇಲೆ ಹೇಳ್ತೀನಿ ಅದು. The petitioner is before this court calling in question an order dated 18/3/2025 in OS 1945 of 2025 declining to grant injunction, ex parte injunction as was sought for in an application filed under order 39 rule 1 and 2 of the CPC. The heard so and so. The petitioners institute the aforesaid OS seeking partition and separate possession of the property, surprisingly making the Bangalore City Cooperative Bank as a party respondent to these proceedings. In a partition suit, it is between the family members. The bank being bought in casts that suspicion upon the very institution of the suit. A backdrop to this is the first respondent defendant and the other family members are said to have secured finance from the hands of the Bangalore City Cooperative Bank. ಎಷ್ಟು ಲಕ್ಷ?
It's more than one.
90, so secure so and so. Surface proceedings had been instituted, against the first defendant by the fifth respondent bank under the Surface Act 2002, and according to the bank, the total outstanding as on the filing of a writ petition 1208 of 2023 was at 95 lakhs. This court rejected the petition by the following order. The rejection of the petition happens on 19th March 2025, directing the petitioner to avail of the remedy of approaching the debt recovery tribunal within 10 days from the said date. After yavat hakirat suit,
3 days before the disposal of this your lordship's
the
WP.
suit is filed on
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 15/3/2025.
15/3/2025, 4 days prior to the disposal of the petition,
Lordship had warned them that we'll dismiss
albeit
the case on the next day.
albeit the petition being pending. The orders that are passed while disposing the petition would clearly indicate that last chance was granted to the petitioners to make good the payment by a previous order which was not adhered to, and therefore the petition had to be dismissed. In that light, prior to during the pendency of the petition, the partition suit is said to have been filed. While the partition suit for partition will have to be decided on its merit, there is no warrant of grant of an interim order or otherwise in the case at hand. Order of any kind that is subsisting would necessarily, and not to create respect, the order that is passed, this court, owing to the submission of the counsel for the petitioner, had passed the following order. This court, a coordinate bench of this court. On 28/3/2025, the parties were directed not to create any third party interest in respect of the petition scheduled property till the next date of hearing. The fifth respondent bank is a secured creditor. He has a statutory right under the SURFACE Act to initiate proceedings and take it to its logical conclusion. It is settled principle of law that for the proceedings against the SURFACE proceedings, no civil suit would lie. The prima facie, the petitioners, the borrower who has defaulted is wanting to achieve what could not be achieved by this court before this court in the aforesaid writ petition by filing this suit. While the suit for partition will have to be decided on its merit, there is no warrant of an interim order, as it would be stifling the statutory right of the bank to proceed further. In that light, the petition stands rejected. The interim order of any kind stands dissolved.
The petitioners before in the earlier writ petition, they are, these petitioners are not the party.
Family members. Next. ಇದು ಅಲ್ಲಿ ಸರ್ಫೇಸಿ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಇಂಡೈರೆಕ್ಟ್ ಸರ್ಫೇಸಿ ಹಾಕ್ಬಿಟ್ಟು ಅಂಡ್ ಅವ್ರ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ರೈಟ್ ಎಲ್ಲ ಹೋಯ್ತು.
Literally, I am the family member that
Correct,
right
sir.
has been there in the
ಪಾರ್ಟಿಷನ್ ಮುಂಚೆ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಅದು ಬೇರೆ ಮಾತು. ನಿಮಗೂ ಗೊತ್ತು ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ, ನೀವೇ ಹೇಳಿದ್ದೀರಾ? ಸಿವಿಲ್ ಸೂಟ್ ಯಾರು ಅಪೇರ್ ಆಗ್ತಿರೋದು? ಎಸ್.
Number 2 and 3, Lord.
Sangamesh.
Sorry.
You are Sangamesh.
Yes.
Lord,
I have challenged the tuition notification.
ಚಾಲೆಂಜ್ ಇಲ್ಲ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಏನ್ ಹೇಳಿ?
I have to serve a copy to the KIDB council.
ಯಾಕೆ ಸರ್ವ್ ಮಾಡಿಲ್ಲ?
ಅವರು ನನ್ಗೆ ನೋಟಿಸ್ ಆದ್ರೆ ಮಾತ್ರ ತಗೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾ?
Right now I'll serve, my lords. There is no, because unless it is the first time it is.
ನೀವ್ ಯಾರು?
For board, KIDB.
Name.
Swaraj Hallar.
Learned counsel so and so accepts notice for the respondent
sir.
board. Petitioner, the learned counsel serves set of papers.
Lords, in the connected matter.
Stay there.
There is an interim
Tag
order.
this petition along with so and so. The learned counsel for the petitioner submits that the companion petition has an interim order granted by the coordinate bench. In that light, there shall be an interim order in the case at hand as well. Next.
Obliged.
Objections, if any. 3 weeks time is granted to file objections. Next.
Obliged.
Patil.
15.
Non-compliance of office objections.
No.
Nimdalla sir.
Office objection, one is complied. Interim order ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, ಅವತ್ತು ಇರ್ಲಿಲ್ಲ ಅವರು. You did not even appear.
30th 6
2:30 ಮೂವ್ ಮಾಡಿ. ನೀವೇ ಸರ್, ಮುರಳಿ ಬಾಬು ನೀವೇ ತಾನೆ?
Lords, one more, R13, his brother has filed, it's 1 acre of undivided land in which he has got 23 guntas, his brother has got 23 guntas, another brother has got 23 guntas.
1 acre?
1 acre odd, my lords. 1 acre.
66 ಗುಂಟೆ 1 acre.
In R13, one of his brothers challenged the petition on the very set of grounds and it has been dismissed. R13 of the statement of objection.
ಅದಿಲ್ಲ ಕೊಡಿ.
ಇಲ್ಲ, ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಪುಟಪ್ ಆಗಿದೆ.
ಮೇಡಮ್.
ಬಂದಿದೆ, ಪುಟಪ್ ಆಗಿದೆ, ಪುಟಪ್ ಮಾಡಿಸಿದ್ವಿ.
Statement of objections and
ಈ abuse of process should stop, sir.
R13, my lords, page number 62 of my
ದೇವದಾಸ್
statement.
ಅವ್ರದ್ದಾ?
ಹೌದು.
ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿದಾರ ಇದರಲ್ಲಿ?
ಹೇಳಿಲ್ಲ.
Petition ಅಲ್ಲಿ ಹೇಳಿಲ್ವಾ?
We are not aware of that.
ಅಯ್ಯೋ ಬ್ರದರ್ ಏನಾಗಿದೆ ಅಂತ ಸೇಮ್ ಲ್ಯಾಂಡ್
Adjacent land, ಅಕ್ಕಪಕ್ಕಕ್ಕೆ.
ಓ 26 ಗುಂಟಾಸ್.
ಇದು 23 ಗುಂಟಾಸ್, ಇದು 23 ಗುಂಟಾಸ್.
Mine is 23 guntas, not this.
How different can you be with this, sir? Yes, Murali Babu.
This case.
Your brother's ಪಕ್ಕದ ಲ್ಯಾಂಡ್ಗೂ ಇದಕ್ಕೂ ನಿಮ್ಗೆ ಏನ್ ಡಿಫರೆನ್ಸ್ ಇರಕ್ ಸಾಧ್ಯ? ನಿಮ್ ಬ್ರದರ್ಗೆ ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ?
ಅಲ್ಲ ಅದು ಅದು ಗೊತ್ತಿಲ್ಲ ಅದು. Last time I kindly see Annex D. Last time I kindly see Annex D in my writ petition. The land acquisition officer had issued Annex C. Thereafter conducted inquiry.
ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರೆ ಸರ್.
ಅಲ್ಲ ಆರ್ಡರ್ ಡೇಟ್ 28/1/2019 Annex D ಮ್ಲಾಡ್. ದ್ರಾಕ್ಷ ಬೆಳೆ ಇರೋದ್ರಿಂದ ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಬರುವುದಿಲ್ಲ. There is a lot, thereafter my land was not left out.
Oh.
Left out by the acquisition officer.
ಯಾವಾಗ?
That 2019, 28/1/2019.
ಈಗ 1 acre is divided into 3 parts.
3 parts.
ಅದು ಕರೆಕ್ಟಾ? ಅದು ಕರೆಕ್ಟಾ?
ಅಲ್ಲ 1 acre 11 guntas.
ಆಯ್ತು ಪರವಾಗಿಲ್ಲ. ಅದಕ್ಕೆ 23, 23, 23. 11 ಗುಂಟಾಸ್ ಅಂದ್ರೆ ಎಷ್ಟಾಯ್ತು? 53 ಗುಂಟಾಸ್ ಆಯ್ತು. ಎಸ್.
In this case, last time
ಯಾವ್ದು R13 ಸೇಮ್? ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Please, my lords.
R13 is the same
order, my lords. R13 page number 62. Bhagwantappa is one of the petitioners.
This is P. Jairam.
Please, my lords.
that I'll go through it, I'll take instructions, submit next week.
Oh, next week, sir.
Arbitration
copy ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇವಾಗ ಕೊಟ್ರಾ?
ಹೌದು, ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ.
Friday we have emailed.
Necessary objections.
We have emailed.
Necessary objection ಇಲ್ಲ ಏನು ಇಲ್ಲ. Yes, list tomorrow.
Please.
Not objection file ಮಾಡ್ತೀನಿ.
ಎಲ್ಲ brother hides and other brother seeks. Yes, hide and seek will not permit. Yes, next.
Oblige, my lord.
List on Friday.
Please,
yes.
oblige.
In preliminary hearing.
Please, my lords, oblige.
Next.
16.
Petition, my lords. Only minimal objections, my lords. Compared to
File alli.
File illa, my lord. Minimal objection, my lord. 1 day's time, my lord.
Just after 4 weeks. Yes.
Date may fix, my lord.
Office objections to be complied with. Where is your file? You can't come like you're going to a restaurant here. Where is your file?
It's not informed, my lord, from senior, my lords.
Yes.
Last end moment was informed.
Just after 4 weeks.
17.
Lords, can I request your lords, may kindly take page 73, my lords. I'll not take.
Along with council submission, urgency idea?
Lords, there is an urgency.
Yenu?
Lords, the revenue entries are directed to be changed on the basis of a compromise entered into. Lords, without there being any basis. Kindly have a look at page 73, my lords, for a minute. This is the re-grant order. In that, page 70. Lordship gets it.
73.
73 and 74, my lord. 74 is the operative portion. Lordship may kindly see 73.
All right.
Lords, serial number 4 is Chinnappa. Serial number 5 is Uma Devi, who is my predecessor in interest. Now, there is a suit filed at page number 123. Lords, page 119. Amended print is page 119. At page 123.
ಯಾವ ಕಾಲದಿದು?
Lords, this is of the year 1998.
Then?
Lords, there is a basis. I'll just take your lordships. I'll not take more than a minute of your lordships time. In this, what they do is, kindly have a look at page 120. Chinnappa is one of the defendants, no difficulty.
Correct.
Rangrao, Uma Devi, Shant Kumar, Umapati, these are the other 4 claimants. Adra kelgade ide. Defendants 2 to 5 are represented by their GPA holder. Andre avrige yavu notice? Chinnappa. That is first defendant, who is a different person altogether.
All right.
Now, kindly have a look at page 123.
This N. Chinnappa is the first defendant.
N. Chinnappa is the first defendant.
N Chinnappa
He is
is
said to be the GPA holder of 2 to
of
5.
2 to 5. He is himself granted with 11 acres and we are granted with 3 acres, 20 guntas and other additional extents. Now, Lordship may kindly see page 123. The third line, defendants 1 to 5 sold considerable portions of the suit land, that is extent of 27 acres in favor of plaintiffs 1 to 8. And defendants 1 to 5 executed documents transferring title and ownership or possession. Notice in the bottom, they have produced a document, sale deeds is not there. We have also applied the encumbrance. There is no sale deed executed by any person at any point of time pertaining to this property. Now, between the non-family members, the relief sought for in the suit is at page 127, suit for partition. Not saying that they are entitled to 3/4 portion. This ends in a compromise which is executed by Chinnappa and the plaintiff. This compromise is kept on a hold. Nobody has disclosed this. For the first time, they come before the assistant commissioner at page number 137.
In 2022.
2022, they come before the assistant commissioner. Between this period, when the appeal is pending consideration, we had purchased the property because the entries were standing in the name of Uma Devi, my vendor. Now, kindly take page 144.
Mutation entries are directed to be changed.
Now, till date, it is standing in the name of Uma Devi. Went before the miscellaneous court and said, these are the very facts.
GMCPC. Okay.
It's a GMC because the interim order which we requested before the miscellaneous court is refused, Milords, on the ground that there is a delay. There is no delay because the first time they apply for the mutation entries is now.
When did you apply?
Pardon, Milords.
When did you apply?
This proceedings, Milords. This is applied in July 2020.
So you have filed a miscellaneous petition to recall the compromise of 1998.
Yes.
Who are the other
petition was
who are the other beneficiaries of the compromise?
It's only the plaintiff.
Who is that?
The plaintiff, Milords, is the person who claims that he's purchased the properties. Madamma, Arsamma, Netravati. Then Tejmal, Kanakmal, Premchand.
Kanakmal.
5, 6 and 7.
Alla yaar contesting defendants yaru?
Not contesting respondents.
Alli yaru represent agilva?
No, agilla. Now if the entries are changed.
And summons kodi.
I
heard the learned senior counsel, D.R. Ravi Shankar, appearing for the petitioner. The office objections be complied with by the next, along with counsel submission.
Lords, I'll get it complied within a week's time because it's clear copies.
A week's time is granted to comply with the office objections. Notwithstanding the same, the matter is taken owing to the projection of urgency by the learned senior counsel. The urgency is impending change of mutation entries that stood in the name of the vendor of the petitioner. The petitioner, who is now the subsequent purchaser from one Uma Devi, comes to know of a particular compromise said to have been entered into between the plaintiff therein and Chinnappa and others, who is said to be the power of attorney holder of defendants 2 to 5 therein. The learned senior counsel submits that the sale deeds are nowhere found. The suit is instituted in OS 20 of 1998 seeking partition of the property. The suit gets compromised. The compromise of which also did not come to light till Madamma Arsamma Auradu. Till Madamma, Arsamma or Netravati, who were the plaintiffs in the suit, file an application before the assistant commissioner for change of mutation entries. If the suit is compromised in the year 1998, the very fact that they have kept quiet for 24 years to get the mutation entries changed would prima facie cast a suspicion on what has transpired. The assistant commissioner directs change of mutation entries by the order impugned, by the order dated, what date is that?
October 24.
24th October 2024. Now a suit is filed in the subject miscellaneous petition is filed in 116 of 2025 seeking recall of the compromise that had taken place before the court, allegedly taken place before the court. The court declines to grant the order that is sought for on the score that there is delay. prima facie with what is narrated herein above, the delay appears to be explainable and is explained. Therefore, the revenue entries standing in the revenue entries as it stands agogide idu implement agide
ಆಗಿಲ್ಲ.
as it stands today shall not be altered till the next date of hearing.
Great.
18.
Next time may be granted, but
And
senior.
for the caveator, my lords, we haven't received the copy.
Lord, caveator,
KDB garu
Lord, caveator ಮೇಲೆ ನಾವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಲ್ಲ.
For the state special counsel for the nice matters.
Huh?
I'm appear for state, your lordship.
state state is a party here.
So, yes.
Yes,
For the board.
Pradeep Kumar
Lord, chartered may be accommodated.
yara
Board, I am
who
appearing for the board.
name
Sharan Sabrad, my lords.
Basaraj Sabrad appear. Counsel Sharan Sabrad accepts notice for the board. The learned counsel so and so submits that is special counsel yake
Nice matters.
ಇದು ನೈಸ್ ಇದು special counsel accepts notice for ನಿಮ್ಮ ಹೆಸರೇನು
Ravindra Veer.
so and so accepts notice for the respondent.
Lord,
Office objections ಏನು
caveat ಸರ್ವ್ ಮಾಡಿಲ್ಲ ತು. My lord,
copy serve petitioner to serve set of papers
caveator
upon
ಅದರಲ್ಲಿ
petitioner to serve set of papers upon the respondents, caveator and the aforesaid counsel forthwith.
Yes. Same, serial number 58 also, same matter.
ಅದರಲ್ಲಿ senior
ಆಚೆ
counsel engage ಮಾಡಿದ್ರು.
ಆಚೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ
Please.
ಇರಿ.
19.
Next.
For petitioners, my lord, the matter pertains to general award,
General award ಮಾಡು.
quashing of general award.
Vijay, general award. Yes.
Notice. 56
Same.
also same.
Pradeep Kumar is directed to accept notice on separate order sheet ಮಾಡಿ permitted to file ವಕಾಲತ್ in 4 weeks ಅಂತ ಮಾಡಿ ಆಮೇಲೆ
Not serial number
56 also same.
ಇರಿ ಯಾಕೆ ಎಲ್ಲರೂ ಅರ್ಜೆಂಟ್ಲಿ ಇದ್ದೀರಾ? ಎಸ್ ನೆಕ್ಸ್ಟ್ ಏನಾಯ್ತು ಸ್ಫೂರ್ತಿ ನೀವಾ ಇವ್ರಾ?
ಇದು ಬೇರೆ ಬಿಡಿ ಅದು.
ಹಾ?
ಇದು ಬೇರೆ ಬಿಡಿ ಅದು.
ಇದಲ್ವಾ?
ಇದಲ್ಲ.
ಓ ಅದು ಎಲ್ಲೇ ಅದು ಕರೆಕ್ಟ್.
My lord, brief synopsis also are filed and also citations about 6 to 7 were denotification and quashing by the sample court. This
2011 ಸಿನಾಪ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
synopsis
ಅದು
ಹಾಕಿದ್ದೀನಿ.
ಹಿಯರ್ ಮಾಡಿದ್ದೀನಲ್ಲ.
Last time ಇದೇನಂದ್ರೆ my lord, only one order passed by the sample court on 12/3/2024.
ಎಲ್ಲಿದೆ ಸಿನಾಪ್ಸಿಸ್ ನಿಮ್ದು?
Then I filed it on 1/7/2025 my lord. Synopsis ಹಾಕಿದ್ರೆ bunch of decisions ಅಲ್ಲ decisions ಅದು decisions synopsis ಬೇರೆ ಹಾಕಿದ್ದೆ.
ಮುರುಗೇಶ್ ನಿಮ್ದ ಇದು ನಿಮ್ದಾ? ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದು ನಿಮ್ದಲ್ಲಿ?
My lord, I filed it on 15/10/2024.
Additional document, judgment and denotification copies, amended petition. ಇಲ್ಲ. ಕೊಡಿ. Reserved, yes.
Once check ಮಾಡಿ. We filed.
But reserved, yes.
My lord, only date is on 12/3/2024. That portion and that specific direction, the sample court after hearing the matter.
ಇಲ್ಲಿದೆ your synopsis.
My lord, in the order sheet on
12/3/2024 ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ
ಹೌದು. ಆ ಸ್ಕೆಚ್ ಕೊಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಇದು ಎಷ್ಟು ಅಕ್ವೈರ್ ಆಗಿದೆ ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ದು ಹೇಳಿಲ್ಲ. I collected information in my brief synopsis. I said only out of 244 acres of ದೊಡ್ಡ ಕಲ್ಲಸಂದ್ರ 10 acres is only taken possession and 4.4 is the percentage wise if it is acquisition and formation of layout.
Yes, heard.
My lord.
Next.
Request for a password.
What is this? Wait.
21.
21 new paragraphs.
I appear for the fourth respondent, my lord. This is synopsis which I am furnishing before this honorable court.
Yes, sir.
Request for a password, my lord. Senior has been engaged.
ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರೆ ಕೊಡದೇ ಇರಕ್ಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಅದಕ್ಕೆ.
2021 ನಲ್ಲಿ 12 ಅಲ್ಲಿ
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Entry model ಇದೆ ಸ್ವಾಮಿ.
Then vacate it.
If it be passed over, senior has been engaged, my lords.
Lord Shivaram Karanth layout,
ಅದರ್ದ ಇದು
2012 is the agreement of sale, 2008 is the acquisition. By virtue of the agreement of sale, they want part of the compensation.
Not only that, my lord.
Suit haki, suit withdrawn, suit is returned in 2020. We present ಮಾಡಿ on August 2020.
ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಮೇಲೆ ಏನ್ ಬರಲ್ಲ.
And moreover, they have filed an impleading application stating that 14 persons have to be included. This petition is against the BDA.
We'll take it on
How can we-
Thursday, sir. List on Thursday. As a last chance, it's made clear, neither a passover nor an adjournment would be granted. Yes. Preliminary hearing.
Much obliged.
22.
Can I see the password, please? ಅದು last time to
One
get the
ನಿಮಿಷ.
original records ಅಂತ ಇತ್ತು.
1 minute. Sir.
Last occasion, my lord, your lordship, my lord, directed me to, my lord, secure original records.
Why are Anil signature?
Please.
ಇದೆ ಅವರೇ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಸೇಮ್ ಸಿಮಿಲರ್ ಸಿಗ್ನೇಚರ್ ಬಹಳಷ್ಟು ಕಡೆ.
Why are Anil ಮಾಡಿದಾರ?
ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಕೂಡ ಅದೇ ಸಿಗ್ನೇಚರ್ ಇದೆ.
ಅಂದ್ರೆ ಅದಲ್ಲ ಅಂತ, not the signature of one who has received. ಕೊಡಿ.
The annexure, my lord, affixed to the, my lord, the objection, my lord, are similar to, my lord, annexure R5.
ಇದು ರವಿಶಂಕರ್.
Please, please.
List on Friday.
Right.
ಇದೇನ್ ಬೇಡ, ಫೈಲ್ ಇಟ್ಕೊಂಡಿರಿ ನೀವು, ಫೈಲ್ ವಾಪಸ್ ಕೊಟ್ಟು. List on Friday, yes.
Obliged, please.
ನೋಡ್ರಿ.
This matter was reserved.
ಕರೆಕ್ಟ್, ಅದು ಪೈಲಪ್ ಆಗುತ್ತೆ ಅಂತ ನಾನೇ ಇಟ್ಟಿರೋದು. ಇದು ಲಿಸ್ಟ್ ಆನ್ 25th ಅವತ್ತು ರಿಸರ್ವ್ ಮಾಡಿ.
Batch, my lord.
24.
ಇವತ್ತು ಯಾರಿಲ್ಲ. ಎಸ್ಟರ್ಡೇ ಬಂದಿತ್ತಾ ಇದು?
The petition became infructuous.
Why?
LRF land reform application, the coordinate bench has been allowed on 3/7/2025.
ಹಾ.
ಅವ್ರು ನಿನ್ನೆ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಇವತ್ತಿಗೆ ಹಾಕಿದ್ರು.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
I produce along with the memo, madam.
What is the challenge here?
They challenged the order passed by the trial court stating that stay the proceedings in the FDP. But initially what happened, we filed a suit for redemption of mortgage suit came to be decreed and we filed FDP. In the FDP, they filed application for the stay the proceedings. The trial court has been declared and Disciplinary court has been granted the stay. Stating that until disposal of the 57168, it has to be.
Until disposal. ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಕೊಡಿ.
ಮೆಮೋ ಹಾಕಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲ ಆರ್ಡರ್ ಇದೆ, ಇಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದ್ದು ಯಾವತ್ತು?
ಆರ್ಡರ್ ಆಗಿ 2022 my lord. ಆ ಟ್ಯಾಗ್ ಆಯ್ತು ಮತ್ತೆ ಡಿಸ್ ಟ್ಯಾಗ್ ಆಯ್ತು.
ಡಿ ಟ್ಯಾಗ್.
ಡಿ ಟ್ಯಾಗ್ಸ್.
ಟಿಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಸೊ ಅಂಡ್ ಸೊ. ನೆನ್ನೆ ಇರಲಿಲ್ಲ ಇವರು.
ನೆನ್ನೆ ಬಂದಿದ್ರು, ಅವ್ರು ಟೈಮ್ ಕೇಳಿದ್ರು, ಇವತ್ತಿಗೆ ಹಾಕಿದ್ರು, ಇವತ್ತು ಯಾರು ಬಂದಿಲ್ಲ.
The petitioner is before this court seeking the following prayer. Without going into the merit of the matter was stayed. The proceedings before the concerned court stood stayed only on the ground that the coordinate bench was adjudicating writ petition 57168 of 2016. Adal party now, 2016.
They are the respondent.
The concerned, the order of the coordinate bench granted on 17/8/2022 reads as follows. On the score of pendency of the said petition, the interim order is extended from time to time. The learned counsel appearing for the respondent submits that the coordinate bench, in terms of its order dated 3rd July 2025, has allowed the petition in favor of the present respondents. The coordinate bench has passed the following order, para 10 in the end. In the light of the petition being filed, in the light of the order passed in 57168 of 2016, the dated 3rd July 2025, the subject petition or the order that is challenged would not merit consideration. The learned counsel for the petitioner submits that a writ appeal would be preferred against the said order. This court would, in the light of the order passed by the court granting an interim order of stay only subject to the outcome of writ petition 57168 of 2016, there is no warrant to hold on to the present proceeding. And in that light, the petition stands disposed, reserving liberty to the petitioner to avail of such remedy as is available in
I
law.
appeal for petitioners, my lords, it's serial number 24.
Yes,
We are
madam.
filing appeal, my lords.
Correct,
and
file
we
madi.
Seek for a short accommodation. my
No,
lords.
madam. Yes.
A week's accommodation, my lords.
The order was subject to the result of writ petition. Now writ petition is over. That's all. Yes.
For some time for.
No, no, madam. Yes, next.
25.
Lord, in fact, by this honorable court, there is an order passed by this honorable court to give compensation to the petitioner's land which has been acquired by the governmental authorities without the formal acquisition proceedings, my lord. Your lordship may
Yes,
kindly see
government.
annexure A.
1 minute. Yes, government.
My lord, kindly come to annexure B, my lords,
Hmm.
the order of the deputy commissioner.
Hmm.
In that page number 23.
ಈಗ acquisition ಆಗಿದೆಯೋ ಇಲ್ವೋ?
My lord, the acquisition ಅಂದ್ರೆ ಅದು
ಅಂದ್ರೆ
not like formal ಇದಾಗ
ಅಂದ್ರೆ
ಆಗಿಲ್ಲ,
ಸುಮ್ಮನೆ
but-
utilization of land without paying compensation?
But since 60 years, the land is with the government only, my lords.
How,
The
whose
school
whose
is
land was,
small.
how did you take over the land?
My lord, it was given by the ancestors of this.
Given by, yeah.
Please,
Just
my
like
lord,
this.
kindly see,
What is given by?
my lord, page number 23, my lord.
Hmm.
That the para begins with.
ಎಷ್ಟು land? 4 ಗುಂಟೆನಾ?
Lord, some 7 guntas of land, my lord.
For
There
what
is already
purpose?
an order issued by this honorable court. my lord.
Page-
Kindly
page-
see page number 20 for a moment, my lord.
20.
Just 5 lines, page number 20, my lord. There are direction issued by this honorable court to the deputy commissioner to hold an inquiry.
What happened after that?
Your lordship may kindly see the deputy.
Inquiry is held?
Inquiry is held, my lord.
Where is the report of the inquiry?
Lord, report is at annexure B, page number 21. He says, my lord, he sits over the judgment passed by this honorable court by saying that, my lord, page number 26, relevant lines, my lord. Page number 26, ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನ ಸಹ ಪರಿಶೀಲಿಸಿದ್ದು ಪ್ರಸ್ತಾಪಿತ ಸರ್ಕಾರಿ ಶಾಲೆ ನಡೆಸುತ್ತಿರುವ ಕಟ್ಟಡ 3 ಗುಂಟೆ ಹಾಗೂ ಈ ಹಿಂದಿನಿಂದಲೂ ಇರುವ ಜೂಡಿ ರಸ್ತೆಯನ್ನು ಸಾರ್ವಜನಿಕರು ಬಹಳ ಹಿಂದಿನಿಂದಲೂ ಉಪಯೋಗಿಸುತ್ತಿರುವುದರಿಂದ ಈ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಅವಶ್ಯಕತೆ ಕಂಡು ಬರುವುದಿಲ್ಲ. In fact, there is a specific direction at page number 20.
How do you demonstrate that the land belongs to you?
Lord, it is admitted fact, my lord. In this
Who
report
has
itself.
admitted it?
In this report, my lord.
Where is it?
Lord, the report itself says, my lord.
Where?
At page number 25, last para, my lord. Page number 25, last para.
ಸದರಿ
ಅರ್ಜಿದಾರರು ಪೂರ್ವಜರು ಹಾಗೂ ವಂಶಸ್ಥರು ಶಾಲೆಯನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿರುವುದಕ್ಕೆ ಹಾಗೂ ರಸ್ತೆ ನಿರ್ಮಾಣ ಮಾಡಿರುವುದಕ್ಕೆ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸದೇ ಇರುವುದರಿಂದ ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆಯಿಂದ ಸದರಿ ಶಾಲೆಯ ಕಟ್ಟಡವು ಸುಮಾರು 60-70 ವರ್ಷಗಳ ಹಿಂದೆ ನಿರ್ಮಾಣಗೊಂಡಿದ್ದು ಹಿಂದಿನ ಖಾತೆದಾರರು ಹಾಗೂ ಅವರ ಕುಟುಂಬದ ವಂಶಸ್ಥರಾಗಲಿ ಹಿಂದಿನಿಂದಲೂ ಈತಹಲ್ವರೆಗೂ ಪ್ರಸ್ತಾಪಿತ ಪ್ರದೇಶವನ್ನು ಅನುಭವ ಅಥವಾ ಅಭಿವೃದ್ಧಿಪಡಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಸದರಿ ಪ್ರಸ್ತಾಪಿತ ಪ್ರದೇಶವು ಅಂದರೆ 3 ಗುಂಟೆ ಪ್ರದೇಶ ಶಾಲಾ ಕಟ್ಟಡ ಇರುವುದು ಇದು
ಟೋಟಲ್ 7 ಗುಂಟಾಸ್.
7 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್.
Yes, madam.
Lord, since the school is there from 60
ಪ್ರೈವೇಟ್
years and
ಎನ್ಕ್ರೋಚರ್ ತರ ಆಗೋಯ್ತಲ್ಲ ಇದು. ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ನ ಯಾರು ಗೊತ್ತಿಲ್ಲದೆ ಅಡ್ವರ್ಸ್ ಇನ್ಫರೆನ್ಸ್, ಸಾರಿ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್.
And on this ground itself, my lord, there is a decision of the Supreme Court, my lord.
Yes, madam.
My lord, kindly see.
ಯಾರು ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಆಲ್ಸೋ ಎನ್ಕ್ರೋಚಸ್
No, my lord.
on private property.
Page number 2 itself, my lord. State cannot shield itself behind ground of delay and laches in such situation. There cannot be limitation for
Yes.
justice.
My lord, kindly see page number 23, my lords. Annexure B, page number 23. The para begins with ನಾಲ್ಕನೇ ಎದುರುದಾರರ ಉಪನಿರ್ದೇಶಕರು.
What are the other contempt ಯಾಕೆ ಹಾಕಿದ್ರಿ?
My lord, in fact, the order passed by the deputy commissioner in spite of clear direction by this honorable court was a clear violation of the order passed by this honorable court, my lord. I had filed a contempt petition, my lord.
But is rejected, is it?
No, my lord.
You withdrew it.
In fact, my lord, on the day when this matter was listed, my lord, I was not able to be present before the court, my lord. In my absence, my lord, the contempt proceedings were dropped, my lord. I'm sorry.
Yes, madam.
Lord, I'll file my objections in.
File your objections. ಯಾವ ವರ್ಷದಿದು?
23 to my lords.
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್.
Please.
10 opportunities have been taken for filing objections itself, my lord.
The buck stops here. Wait, it's before me, I think, first time. Yes. The petitioner is before this court seeking compensation for utilization of his 7 guntas of land by the state about 60 years ago. The This, he had approached this court in writ petition 12385 of 2016. This court, the coordinate bench of this court, directed holding of an inquiry by observing as follows. Para 6 at page 19 and 20. Subsequent to the, pursuant to the order, the Deputy Commissioner holds inquiry. The result of an inquiry is an order that is passed, which the paragraphs of which are germane read as follows. Paragraphs of which germane read as follows. Page 25, 26. A perusal at the order, at the report or the report which forms the part of the order would clearly indicate that the petitioners have, the land of the petitioners has been utilized by the state for the purpose of establishment of a school. And the observation is.
Formation of road, my lord.
And formation of road. The observation is, since the petitioners did not, the petitioners or his ancestors did not object to the said utilization, no acquisition need be made. Therefore, the land belongs to the government. The report on the face of it is contrary to law. The government prima facie cannot become an encroacher of private property. The learned HCGP seeks a week's time to file statement of objection. The objections be filed by the next date, list on 24th. In the event objections would not be filed by the next date, appropriate orders would be passed, hearing the counsel for the petitioner. Next.
26. I've challenged the
Consideration of interim prayer, madam.
The objections are already filed. It may kindly be heard, I will just take 5 minutes.
5 minutes lagogutta.
The acquisition proceedings were issued under 1894 Act. PN was in 91 and final notification was in 96. My case is only this. I'm the owner of survey number 28 measuring 1 acre. The land was acquired along with other lands for D group, formation of D group employees. Now, what has happened is I'll demonstrate that neither the position was taken nor the compensation was paid, as is a mandatory requirement under the law, under 24(2) to establish seeking quash.
You have been in possession right from that date?
Please, I'm in possession always.
Even today?
Even to this day, I'm in possession. Before that, may I please place on record certain memo of documents and the citations.
Memo of documents, copy kodi stating. ಅಲ್ಲ ಅವ್ರಿಗೆ
40 minutes. This memo citations.
ಏನು ವರದಿ ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ? You are in possession ಅಂತನಾ?
I'm in possession anta. I'll just explain. It's as regards if
Next week, my lord.
It's as regards the position. My lords may.
No, for the interim prayer you argue, because if you want on final, then he has to look into this.
I've already filed the objections.
But you're giving something new now. He has to go.
Well, that is because they have raised certain objections for which it's a reply.
No, he has to go through it at least. There's no interim order here?
There's no interim order.
Then we'll protect your possession if you are in possession today.
That's a date may kindly be
that
fixed.
I will do, yes. I heard the learned counsel, Srimati Sadhna S. Desai, appearing for the petitioner. The learned counsel, to buttress her submission, has placed on record certain judgments and a memo along with 9 documents to demonstrate that the petitioners are in possession of the property, have been in possession of the property, are in possession of the property as on today. According to the learned counsel, neither possession has been taken pursuant to the preliminary notification. Final agidya? Final notification.
Also passed. They have already received.
Final notification and the compensation is not paid. Solely on the not paid. In that light, if the petitioners are in possession today, their possession shall not be disturbed till the next date of hearing. List the matter on 24th. Reply of any kind by the state by then to the memo of documents. Reply, if any, by the state by then to the memo of documents so filed.
I'm grateful, Manoj.
29th.
29 ಬೇಡ 24th ಮುಗಿಸ್ಬಿಡು.
I'm grateful.
Yes.
27.
Number 25, it is preliminary hearing.
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಬರುತ್ತೆ.
27 for the response and.
Recovery of stamp duty, Lordship,
Ah.
on unregistered document. Lordship, kindly appreciate, Lordship, this is the OS matter, it's been stayed there.
ಅಯ್ಯೋ
Suit for
ಎಂಟ್ರಿ
specific
ಮಾಡ್ರಿ
performance.
ಇದೆಯಲ್ಲ ತಾಹಿರ್ ಒಂದ್ ನಿಮಿಷ.
But it's suit for specific performance, it is in respect of.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ
Lordship,
ಇರೋ ಕೇಸಲ್ಲಿ ಹೆಂಗ್ ಗಲಾಟೆ ಮಾಡ್ತಾ
Humble
ಇದ್ದೀರಾ?
submission is,
ಹಾ?
she is just taking time every time, she never comes forward. Give 2 week time, Lordship.
What communicate? Settlement.
But this settlement can be done in a OS suit also, this is a recovery of stamp duty on unregistered document.
At the learned counsel for the respondent seeks time, comma, yet again, which is seriously objected to by Tahir. Lest the matter finally on 22nd, on 23rd, in the event no submissions are made, appropriate orders would be passed on hearing the counsel for the petitioner. Interim orders extends till the next date of hearing. Next.
My lord, the matter was reserved for award, my lord.
Ida.
8th Zonal Award.
Date of hearing, well, it was heard. And
It was
also-
heard ashte.
Yes, my
Yes.
lord. And also I filed a memo saying that position was already taken.
Correct.
And 29(2) also. my
List
lord,
on 25th.
Much
I'll do it. Yes.
29.
This will not be. The Lord's appearing for the respondents, my senior is not well, so.
Not well.
So, you know,
I tell you,
please,
not well ಅಂದ್ರೆ,
he was
not
a
well
short
ಅಂದ್ರೆ.
estate, that's.
Synopsis ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ? In compensation.
ಇಲ್ಲ. What has happened is there's a road, my lord, which had been shown in the 2007 CDP. ಮಧ್ಯದೊಳಗೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಮಧ್ಯದಲ್ಲಿ we said, we'll give the same land, road ಅನ್ನು ಸ್ವಲ್ಪ ಶಿಫ್ಟ್ ಮಾಡಿ ಲೆಫ್ಟ್ ಗೆ ಅಂತ ಹೇಳಿ. 2007 ಇಂದ today, my lord, we are in 2025. ಆ ಮಧ್ಯದೊಳಗೆ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ಡೆವಲಪ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. Road also can't come in. So ನಮ್ದನ್ನ ನಾನು I said, please shift it. I'll whatever the expenses I'm willing to bear. ಏನ್ ಮಾಡ್ತಾರೆ?
Yeah, why do you want time?
My lords, my senior is not there.
Who
There's
is
no
your
instruction. Unni Krishnan.
ಯಾವತ್ತು ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಯಾವತ್ತು ಸರ್? Not well ಅಂತ ಅಷ್ಟೇ.
ಆಯ್ತಾಯ್ತು. No, I don't want to say, my lord, when somebody says it's not well.
Learned counsel representing M. Unni Krishnan, appearing for respondents 2 and 4, submits that he is unwell. In the light of him being indisposed today, list this matter on 24th as a last chance. In the event no submissions are made on the said date by the respondent, orders would be passed on hearing the senior counsel for the petitioner. Yes.
My lords, there's another serial number 69, so.
You're going out? Wait.
Okay.
What is this habit?
Apologies.
Yes.
Your lordships, I told it at 3:30, your lordships. Serial number 30, your lordships.
What happened?
3:30, your lordships.
3:30.
3:30, your lord. Yesterday it was
Pass over,
3:30, your lordship.
Pass over. Yes.
Much obliged.
Yes, appeal for petitioner, please, lordship. Is annexure already quashed by this honorable court.
Same. Same order.
ಅದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಮಿಸ್ಟೇಕ್ ಆಗಿ ಮೆಜರ್ಮೆಂಟ್ ಮಿಸ್ಟೇಕ್ ಆಗಿತ್ತು ಅನ್ನೋದು.
The petitioner. ಇದು.
31.
The petitioner is before this court seeking the endorsement act question ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, endorsement already quashed by this
The
honorable court.
petitioner is before this
petition.
court seeking the following prayer. This court, the coordinate bench of this court has quashed the proceedings qua the subject survey number in the page
20, in page number 29, the WP number 28,448 but 2018.
One ನಿಮಿಷ. 29.
Please, lordship.
This is Suraj Govindaraj.
Please, lordship.
Yes. The learned counsel, the coordinate bench has held as follows. The learned counsel appearing for the respondent, learned HCGP would accept the fact that the proceeding would accept the law as laid down by the coordinate bench in the aforesaid order. In that light, the petition deserves to succeed. The learned counsel for the petitioner submits that the survey numbers mentioned in the order are erroneously mentioned and and it has been correctly mentioned in the subject petition. The learned HCGP would also submit that there has been a mistake in the survey numbers mentioned in paragraph 2 of the said order. Though the order is paraphrased herein above, the survey numbers are to be read as ille correction ide. Madam, idralle correction ide. Survey numbers are to be as follows. Yes. Ordered accordingly. Same order, madam.
Grateful, Lordship.
Thanks.
32.
Petitioners, my lords. This matter I have questioned lapsing of scheme pertaining to JP Nagar 9th phase.
Yeah, yes.
They have filed their statement and in that they have said that portion of the property has
Should
been
want some
declared
time, my
as
lords.
slum.
Ah.
So I have applied for necessary
Where is,
documents.
how have you said that? Where is the notification under section 3?
Let's, insofar as.
Declaration of a slum is preceded by notification.
Please, my lords.
Where is it?
We have said that so, my lords. And
Said that, so where is the notification?
I'll produce, my lords. I've
What is
produced
this?
the notification. I'll produce it.
The council, ನೀವು ಯಾರಿಗೆ BDA ga?
PDA also.
Learned counsel Ajit Achappa appearing for the BDA takes this court to the statement of objections to contend that portion of the petitioner's property that he is now claiming is declared as a slum and has been used as a slum, though no notification as necessary under the act is produced. The learned counsel would submit that if 2 weeks' time is granted, the notification would be placed on record. In the event the petitioner would, learned counsel of the petitioner also submits that he has applied for the said notification declaring it to be a slum, and the same would be placed once it is in his possession. In that light, list the matter on 6th August. 6th, 7th August. Yes, next.
33.
Last occasion I told about the acute angle of ROB cannot be in option number 2, my lord.
Now, just now, the learned counsel has furnished a copy. And so far as on the last date appearing.
Tomorrow. Yes, tomorrow.
One submission. Last date appearing, my lord directed them to submit by way of update in respect of this Talaguppa. Now they have mixed up all the 5 projects and they have given this report. My specific case is Talaguppa. They cannot mix up all other.
It's Talaguppa itself, my lord.
Tomorrow.
It's Talaguppa.
Yes.
LC 5 ಹಾಕಿದ್ದೀರಿ.
Tomorrow, yes.
34.
But tomorrow in preliminary hearing, same stage al haki. Withdrawal of amount. What amount? Oh, idu. Yes. Close ಮಾಡೋಣ ಇದ್ದಂಗೆ.
Close ಆಗಲಿ ಸುಮ್ಮನೆ, but.
ಅವ್ರದ್ದಾಯ್ತು.
Memo calculation.
Madam ದಾಗಿದೆ.
ಅವ್ರದಿನ್ನೂ ಆರ್ಡರ್ ಆಗಲಿಲ್ಲ.
ಯಾಕೆ? ಕೊಡಿ. Withdraw. How much now? Pursuant to the directions of this court, the amount has been deposited. 25 lakhs ಎಷ್ಟು?
25 lakhs is the decree amount and
Decree
4
amount.
lakhs.
Amount that the auction purchaser would be entitled to has been deposited.
No, my lords. Decree holder.
Decree amount is deposited.
I have deposited sale amount.
ಮೇಡಮ್ ದುಡ್ಡು ನಿಮಗೆ ತಾನೇ ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದು.
ಅಲ್ಲ, ನಾವು ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ. ನಾವು ಡಿಗ್ರಿ ಹೋಲ್ಡರ್, ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್.
May I say this, my lord?
Your application is different, sir. ಈಗ auction purchaser ಗೆ ಎಷ್ಟು ಕೊಡಬೇಕಾಗಿತ್ತು?
4,60,000 ಕೊಡಬೇಕಿತ್ತು.
Deposited as on 16/10/2024, 92 lakhs.
16/10, 1 ನಿಮಿಷ. 2024.
Court sale ಆಯ್ತು.
Ah.
So on that amount, I have deposited 92 lakhs.
No,
That is not the application. The application is with the decree holder.
What have you filed?
My lords, I have filed an application to withdraw 25 lakhs which was deposited by the petitioner in view of the interim order passed by this.
Now
honorable court.
we will close the auction purchaser's problem.
Very well.
We'll keep your problem.
On top of that 92, I have paid 4,58,000.
That is 5% of.
That is
That is what.
Solatium.
Yes.
The petitioner is before this court seeking the following prayer. The issue revolves around the petitioner, the auction purchaser, and the decree holder. The petitioner is judgment debtor. The pursuant to the court sale, the auction purchaser had deposited 92 lakhs. That 90, that's ಕೊಟ್ಟಿದ್ದಾರೆ ವಾಪಸ್ ಇನ್ನೂ ಇಲ್ಲ. The deposit is lying in the concerned court. 5% solatium over the said amount which was directed by this court to be paid has now been completely paid to the auction purchaser. Therefore, the total amount that is lying before this court, ಇಲ್ಲೇ ಕಟ್ಟಿದಾರಾ?
ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರಿಗೆ
ಅಲ್ಲೇನಾ?
ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ.
So therefore, the amount that is in deposit before the concerned court, i.e.
2 lakhs.
92 lakhs shall be permitted to be withdrawn by the auction purchaser forthwith on production of adequate documents. Insofar as the application is concerned with regard to the withdrawal of 25% of the decretal amount.
No, 25 lakhs.
25 lakhs of the decretal amount, the matter would be heard. Yes.
Lord, I will file, my contention is this, my lord, whatever they have filed, the memo of calculation, they have not considered the amount I have paid before the execution court and before the execution proceeding.
I have
calculation ಇದೆಯಾ?
ಅಲ್ಲ ಅವ್ರು 40,000 ಅಷ್ಟೇ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ ಕಂಟೆನ್ಷನ್. The petitioner says she is not keeping well. We will also file our memo of calculation on
file it. The petitioner and the learned counsel for the petitioner submits that there is an error in memo of calculation by the respondent, as the amounts that are paid prior to execution and during execution are not taken note of by the respondent, and would seek a week's time to file the memo of calculation. Memo of calculation be filed by the next, by the 23rd, 25th, list the matter on 25th. ನಿಮ್ದಾಯ್ತಲ್ಲ madam?
Counsel for petitioner, my lord. Actually, ಎರಡು ಕೇಸ್
BDI ಯಾರು? ಅಜಯ್ ಕುಮಾರ್.
ಸುಮ್ಮನೆ ಎರಡನಲ್ಲಿ ಒಂದೇ ಬಂದಿದೆ, ಇನ್ನೊಂದು
ಅಜಯ್ ಕುಮಾರ್.
ಎರಡು ಪಿಟಿಷನ್ ಇತ್ತು, ಒಂದೇ ಬಂದಿದೆ.
ಏನ್ ಖಾತಾ ಯಾಕೆ?
ಖಾತಾ
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಮೇಲೆ 10 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎರಡಕ್ಕೂ ಪೂರ್ತಿ ಮಾಡಿದೀವಿ.
The petitioner shall serve set of papers. A learned counsel Ajay Kumar is directed to accept notice for the respondents. Petitioner shall serve set of papers upon the aforesaid counsel forthwith. List the matter. Next week ಹಾಕ್ತೀನಿ, ಕ್ಲೋಸ್ ಮಾಡಿ. ಮ್ಯಾಂಡಮಸ್ ಕೇಳಿದ ಅಷ್ಟೇ. List the matter on
ಸರ್ ಇನ್ನೊಂದು ಕೇಸ್ ಸೇಮ್
21st, 22nd.
ಸರ್ ಎರಡು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು, ಒಂದು ಮಾತ್ರ ಬಂದಿಲ್ಲ. ಸರ್ ನಂಬರ್ 30,186
ಬರ್ಕೊಡಿ. ನೀವು ಸರ್ಫೇಸ್ ಇಲ್ಲಿ ಅಮೌಂಟ್ ಹೇಳ್ದಂಗೆ ಹೇಳ್ಬೇಡಿ, ಬರ್ಕೊಡಿ.
Pertain to acquisition warrant, KIDP. Petitioner.
I've heard you on the last occasion.
Yes, my lord. The
challenged after 14 years.
Yes. Award is passed after 16 years. My lord has to consider both, my lord, the delay in passing the award as well as, my lord, delay on my part, delay on their part. Conditive, my lord, the fact, not award is not, my lord, for this petition property. Award is for the whole notification. My lord, kindly appreciate this.
General award.
Yes, my lord, general award. Without no issuing notice, they say in the award, my lord, oppanda. No oppanda, nothing. Everybody opposed it.
ಅದು ನೋಡಿದೆ ಒಪ್ಪಂದ ಅಂತ.
But I have been running, my lord, industry there. Rubber industry.
Rubber?
Yes, my lord.
Oh, yes, sir.
IDT, my lord, I have taken certificate also. And
why are you disturbing rubber industry?
No, we have excluded 1 acre, my lord, which covers.
For the industry.
Yes, yes.
But what is, drying rubber, it is not about small place of one building itself is runs into half acre.
1 acre.
1 acre.
1 acre.
Where to dry the rubber, my lord? Kindly appreciate, but before the government has issued a general circular to examine this question, my lord will find that circular also. Lord, this is a case, my lord, where the 28/4 notification is quashed by this court in earlier occasion with respect to very notification.
Very notification.
Very notification is quashed, not by me, my lord.
Page.
There are other, Lord, I have given the list of citation, Lord. The last judgment in the list of citation. My lord will find
2011.
Yes, my lord. One more order, my lord, in rupee number 955 of 2011. Thereafter, my lord, 28-3 order is passed. Kindly see, my lord, that order also. Though I am not a party, my lord, annexure, my lord, J3, page 111 is the endorsement issue to me.
Date.
Date is 9/9/2011. Page 111.
That
But
also,
yes, my lord.
yes, you took me to that last time, yes.
Without, my lord, after the endorsement is issued, can they, my lord, without passing 28-3 is passed in 9/9/2011, though I am not a party.
But what were you doing for 14 years?
Lord, award is passed on 18/8/22, my lord, without hearing me. 3/3/2023, my lord, award is approved, my lord. I produce all those orders before your lordship, my lord. Lord, 16 years, Lord, passed in passing the award. It is not me alone, my lord. Award is passed with respect to all land.
Correct, that you told me.
Lord, delay has to be examined in this case, my lord.
To adjacent land, Justice Ravi Hosmani ಅವರು.
Milords,
ಇದು rubber
rubber.
industry.
And Milord,
Rubber plantation.
Was plantation.
Plantation, ಇಲ್ಲಿ rubber industry. ಇಲ್ಲಿ ಲೈಸೆನ್ಸ್ ಇದೆ. But Supreme Court recently examined this question in Milord in April 25, KIDB Act. If the delay in passing award is liable to be cost, if it is developed, Milord, all land, Supreme Court said you pay the compensation in 2013 Act. Kindly see, Milord, brief facts of this case.
Which case?
This case. 16 years, kindly see, Milord, annexure P, page 133, the order of award, page 133.
Yes.
That is on 18/8/22. But this award is not produced by them in other petition, which, my lord, the order copy is given to your lordship, lord. Kindly see, the KIDB did not produce this award, even did not note the award, date of award also. They just say they pass the award, they are taking steps to, my lord, to deposit the amount in the court.
Yes, what do you
We
say?
are not parties.
My lords, at every stage of the Milord acquisition proceedings, I am passing on the synopsis and also Milord list of citations, Milord. At every stage of Milord the acquisition, petitioner was notified and heard. Milord, the first date your lordships may kindly see on page 2 of this synopsis, item number 31/10/2006, Milord, notice was issued to the petitioner under section 28(2). Petitioner received Milord, notice but did not file objections. Annexure E1 is the Milord notice issued, Milord, which is produced by himself. Then, Milord, 2/12/2006, respondent 3 held inquiry under section 28(3). Petitioner participated. Can I, Milord, point out to annexure R8 with my objection statement where he has participated in, Milord, the inquiry held under section 28(3).
But that is the order 31.
2/12/2006.
No, man, 31.
Wait, sir.
1 second. Annexure R8, your lordship may kindly take. Page number, my lords, 27. 27 of my objection statement. Additional statement. Either first objection statement. After amendment of the writ petition, we have filed one more. But
Additional.
First, Lord, objection statement.
First
filed on-
objection, yes, R8.
Yes, Lord.
Page 27.
Page number 27, your lordship may kindly see.
Yes.
ದಿನಾಂಕ 2/12/2006 ಬಡಗ ಉಳಿಪಾಡಿ ಮೊಗರು ಮತ್ತು ಟೆಂಕ ಎಡಪದವು ಗ್ರಾಮದ ಗ್ರಾಮಸ್ಥರು 28/2 ನೋಟಿಸು
ಎಲ್ಲಾರನ್ನು ಹೇರ್ ಮಾಡಿದ್ದೀರಾ?
ಎಲ್ಲಾರ್ದು ಮಾಡಿದೀವಿ. ಈ lordship may kindly come to page number.
ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ದಾರೆ.
ಇವರು ಇದ್ದಾರೆ. 29 page number, serial number 21. Right side ನಲ್ಲಿ serial number 21 Karnataka
Shetty.
Yes, he has participated.
Yes.
Then, my lords, lordship may kindly take the order passed by, my lord, the land acquisition officer, which is, my lord, at annexure F. Annexure F, my lord, page 91 of the writ petition. Page 91. Lordship may kindly See the order.
Your survey number ಎಲ್ಲಿದೆ?
Yes, yes. Your Lordship may kindly see, page number 93. 93 last paragraph. Last paragraph. ಪಡಗ ಉಳಿಪಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 164/2 ವಿಸ್ತೀರ್ಣ 4 ಎಕರೆ 4.5 ಎಕರೆ ಜಮೀನಿನ ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನನ್ನು ಈಗಾಗಲೇ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉಪಯೋಗಿಸುತ್ತಿರುವುದರಿಂದ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ಹೇಳಿ? 93
ನಂಬರ್ 93 ಲಾಸ್ಟ್ ಪ್ಯಾರಾಮೀಟರ್.
ಮೂಗೂರು ಗ್ರಾಮದ ಅದ?
ಅಲ್ಲ, ಬಡಗ ಉಳಿಪಾಡಿ ಅಂತ.
ಬಡಗ ಉಳಿಪಾಡಿ ಗ್ರಾಮದ
ಬಡಗ ಉಳಿಪಾಡಿ
ವಿಸ್ತೀರ್ಣ 32 ಗುಂಟೆ ಎಕರೆ ಜಮೀನಿನ ಭೂ ಮಾಲೀಕರದ?
ಅಲ್ಲ, ಅದೇನೋ ಪೇಜ್ ನಂಬರ್ ಮಿಸ್ ಆಗಿರ್ಬೇಕು ಸ್ವಾಮಿ. I am reading.
ಬಡಗ ಉಳಿಪಾಡಿ ಅಂತ ಇದೆ ಇಲ್ಲಿ. ಸರ್ವೆ ನಂಬರ್ 232/5 ವಿಸ್ತೀರ್ಣ
164/2 milords.
Survey number 164.
This is internal page 3 of the milord 28-3 order.
Internal page 3.
Milord, the index.
Yes, it is here. It's 91, sir.
Yes, I am sorry, milord.
Number 93.
93. ಬಡಗ ಉಳಿಪಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 164/2 ವಿಸ್ತೀರ್ಣ 4.5 ಎಕರೆ ಜಮೀನಿನ ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನನ್ನು ಈಗಾಗಲೇ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉಪಯೋಗಿಸುತ್ತಿರುವುದರಿಂದ ಹಾಗೂ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅಗತ್ಯವುಳ್ಳ ಪರವಾನಗಿಯನ್ನು ಸಂಬಂಧಪಟ್ಟ ಇಲಾಖೆಯವರು ನೀಡಿದ ಅನ್ವಯ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬಳಸುವ ಜಮೀನನ್ನು ಕೈಬಿಟ್ಟು ಖಾಲಿ ಇರುವ 3.5 ಎಕರೆ ಜಮೀನನ್ನು ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ
ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ?
ಬಿಟ್ಟಾಗಿದೆ.
ಇಂಡಸ್ಟ್ರಿ ಇರೋದನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ. You want adjacent land also?
But 31/10/2006, my lord, order is quashed by this court.
Then
Kindly appreciate, that is the order.
What is quashed?
31/10/2006. That is the order. They say.
Which order?
That is the right 1 acre which is left according to them. That order is, my lord, quashed by this court.
Where is that order?
31/10 annexure, my lord, E and E annexure F, page 89. That is the order. Page 89 order is quashed by this court in two writ petition. Because on the same day.
Annexure F, page 18 is no order, sir.
31/10/2006, my lord. That is the order leaving 1 acre.
Oh, after it is quashed, that is.
Yes, my lord.
ಆಯ್ತು.
ಈ ಆರ್ಡರ್ ಕ್ವಾಶ್ ಆಯ್ತು. ಈ ಆರ್ಡರ್ ಕ್ವಾಶ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಎಂಡೋಸ್ಮೆಂಟ್
ಲೀವಿಂಗ್ 1 acre ಕ್ವಾಶ್ ಆಯ್ತು. ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ ಎಂಡೋಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು, ನನಗೂ ಮಾಡಿದ್ರು. ದಟ್ ಇಸ್ E1, my lord. I showed you lordship. 111 ಅಲ್ಲಿ.
ಏನಾಯ್ತು?
There is the notification 28/4, my lord, thereafter.
2011.
Yes, my lord. 28/4 is quashed. After this, my lord, the law mandates that 28/3 first.
Correct.
Subject to 28/3, 28/4 should be passed. Thereafter, no other notification.
After this, what has happened?
Yes.
Lords, this was with reference to the land involved in that petition. My learned friends, Lord, petitioner's land was not there, the subject matter of that.
No, the entire, the entire circular is quashed is what he says.
No,
Only for the petitioner it is quashed, man. They made applicable to all.
Let me complete, Lord.
No, they are made applicable to all,
so that, Lord, there is clarity. Lord, I submitted that every stage of the, Lord, proceedings we have notified and, Lord, provided opportunity to the petitioner. He participated and kept quiet, my lord, for over 14 years without any reason. And your lordship may also kindly appreciate this. Arrangement was telling that there was no notice regarding award inquiry. All
so that is there. He has
not at all correct.
participated.
He himself has produced, my lord, the award notice. He has filed objections in response to award notice. No objection is taken that there is delay or something like that. And before that, my lord, in the year 2010, my lord, we had conducted, my lord, the 29(2) proceedings for determination of compensation as consent rate, my lords. In response to that notice also, he did not come and only kept on making representations, my lord. And in the meanwhile, all the proceedings have been completed and, my lords, there is no question of, my lord, the petitioner, my lord, the writ petition filed after 14 years should not be, my lord, entertained is my submission. And we have produced one order which is in respect of, my lord, the adjacent land. Last
page number.
In the, my lord, list of citations. 158 is the page number. Acquisition has been upheld there and my learned, the petitioner in that case has filed writ appeal.
Same petitioner?
No, my lord,
In
not
that-
same
in
petitioner,
that-
my lord, same senior counsel, my lord, in that.
Same senior counsel, in both the cases, same senior counsel
Oh,
appears.
this Geeta Shetty's judgment.
Yes, sir. On the ground of delay only, my lord, that has been caused, and my lord, the petitioner also similarly placed. And my lord, the grievance of the petitioner is based on Shivanna's case, which is held to be my lord, per incurium by my lord, a later decision in Anaswami's case. And my lord, the provisions of my lord, 2013 Act cannot be read into the scheme of my lord, the KID Act is the settled position. And 24 and 25 of the my lord, New Land Acquisition Act have no application is also the view taken by this honorable court and as well as my lord, the honorable apex court.
Which is that apex court judgment?
Yes. I will not read the judgment in Anand Swami's case, which refers to all Supreme Court decisions. my lord.
Page?
Page I'll. Anand Swami, your lordship may kindly take page number 168 of my compilation. Can I request my lords to kindly take paragraph 25 on page 190? Page number 190.
Yes.
The Honorable Supreme Court in Ansuya Bai, while setting aside the judgment passed by the division bench of the then my lord has held as under the division bench of the High Court by the impugned judgment, however, has quashed the acquisition proceedings itself, holding that they have lapsed. For this purpose, the High Court has taken aid of section 24 of the new LA Act in the following manner. I'll skip this reading, my lord. Your lordship may kindly come to page number, next page number 192, para number 29. This approach of the High Court we find to be totally erroneous.
Para 29 of the other quoted judgment.
The quoted judgment.
Now come to para 26 at page 196.
Yes, sir.
And 197. Accordingly
Yes, sir.
answered.
Yes, yes, it is
ಮತ್ತೆ
answered.
ಅದನ್ನ
And-
ಓದಕ್ಕೇನ್ ಬೇಡ ಬಿಡಿ. Yes.
And 47 and 48 is also important. My lord, a decision which is held to be per incurium is being, my lord, quoted before lordships to say that award should have been passed within 2 years. 47, paragraph 47 and 48. Page number 217, my lords. Yes. In view of
Offshore.
In view of the above catena of judgments of the Honorable Supreme Court in offshore holdings, reliance cannot be placed on the judgment of the division bench of this court in H.N. Shivanna to hold that in the absence of any time limit fixed under the provisions of KID Act for passing of an award, it would have to be made within a reasonable time, which is 2 years, and if the award has not been passed within the set time, it would lead to grant of declaration that the acquisition has lapsed. More pertinently, having regard to the judgments of this Honorable Supreme Court in the case of M. Nagabhushana and Ansuya Bai, which are directly under the provisions of KID Act, the judgment in Ramchand's case, which is
Yes, I've seen.
H.N. Shivanna cannot be held to be good law.
Yes.
Yes, ma'am. So, and even, my lord, in H.N. Shivanna's case, my lord, the apex court has kept the question of law open. That is also, my lord, produced at page number 224, SLP order in Shivanna's case. The Honorable Supreme Court has kept open.
Yes,
And,
sir.
my lord, absolutely there are no grounds to, my lord, to condone the delay of 14
But
years.
I'm able to satisfy your lordship. Kindly take, Lord, 4 dates, Lord.
Yes, sir.
19/8/2006 is the preliminary notification. 3/1 notification, Lord, 1/3 notification. 11/1/2010 is the final notification. But 31/10/2006, my lord, they issued notice to me. My lord will find annexure E and D1. On the same day, they passed this order. What they say is they heard me. My lord.
You're aggrieved by that order.
Yes, my lord, because industry is being run there.
Yes.
Now, my lord, what happened? This order was questioned by other parties. My lord. There are 2 orders, my lord. I showed you, Lord. One of the orders is
This order is set aside.
that is right, to pass fresh order. They made that applicable to me also. My lord will find that endorsement which I showed to your lordship, Lord, 111 page. J3.
Survey number 67.
In view of that, 111 order, Lord, unless Lord 28(4) is passed, but they cannot acquire Lord with the same notification, because Act mandates that 28(3) subject to 28(3), 28(4) shall be passed. So, my lord, they have not complied 28(4) at all. It is vitiated. Then, my lord, delay. Lord, final notification is, my lord, on 11/1/2000. Lord, 10, I don't dispute it. 11/1/2010.
11/1/2010. That notification is set aside.
No, that is set aside.
Where? In which case?
In the other cases, Lord.
28(4) set aside
Yes,
ಆಗಿದೆಯಾ?
yes, Lord, I will read that. Kindly take my list of citation. It is there. In 2 orders.
It is only in respect of the petitioner in that case.
Correct,
and,
Lord. I'm not
they
saying
had-
not my.
They had approached the court in 2011.
Sorry.
It is not, Lord, I am not saying, Lord, I approach the court, Lord. There are other persons approach the court. Lord, not only one order, Lord. Kindly see, Lord, page number 137. of
What
the order.
stopped you from approaching the court?
No, my lord is right. Rightly asked that question, I will answer it. Lord, 137, my lord will find. In the list of citation which I have given. The mere fact reference is made to the fact that, Lord, my lord got it.
Yes, sir.
Petitioner has appeared and filed objection. Otherly 31/10/2006 notice is issued to me, to others also. Cannot at all be believed in the face dates mentioned in the notices as well as the order passed on 28(3) Act. For the reasons alone, the order dated 31/10/2006 is quashed so far as the petitioner is concerned. Consequently, the final notification issued under section 28(4) of the Act so far as the petitioner is concerned is also quashed. Both are quashed. Not only this order, my lord, there are other orders.
So far as the petitioner is concerned.
Yes, there are other 2 orders.
Immediately you should have approached the court.
My lord, there are other orders, not only one. There are other orders, other person petitioner also approach the court. I have not approached. There are also 28(4). Same notification, same is. Lord, question now is before your lordship, please. Or award is not at all passed till 18/8/2000. Lord, Annexure P, page 133. 133.
Yes.
That means to say, my lord, preliminary notification 2006. 18/8/22 is the, my lord, award. They have taken, my lord, nearly, my lord, 16 years in passing the award. What their reply is, my lord, you have made them to pass on delay, you are responsible. But the question is now, my lord, 90 acres something is acquired under the notification, my lord. All 90 acres award is passed on that same day.
Yes.
Therefore, my lord, they cannot say delay is shifted on me.
Only one clarification.
1 minute. I have not completed. This award is approved in 3/1/2023. My lord, no, that is, my lord will find, I have produced that also, my lord, page 130. That means to say, approval is on 3/1/2023. Which is shown as 12/10/22, page 130, my lord, kindly take. 130. That means to till approval award will not come into effect. I have no notice, my lord. I had no notice of while passing the award. Nobody. Award is passed, my lord, passed on 18/8/3/11. Not in passing the award, if 23 is taken into account, my lord, 3 plus, my lord, 14, 17 years delay in passing the award. I have to take compensation of, my lord, as on 2006.
We'll see.
Examining this question, delay in passing award, Supreme Court recently, my lord, kindly take that. KIDB Act itself. But he says now, rated judgment is holding the field. My lord may kindly take.
Para 58 of the judgments.
But not Francis. Amele, my lord knows.
Para 54 to 58. 58 ಅಲ್ಲಿ it is a blame on the KIDB.
ಹೌದು ಇಲ್ಲಿ 16 ವರ್ಷ my lord, I have to take my lord, compensation as on the date of 2006.
Yes, sir.
But they make a false allegation that we have agreed. There was no such agreement between the parties. Admittedly, my lord,
Well,
they have no notice to me. Kindly see, my lord, 18/8/2006 award also. Nobody is issued with the notice. What they say is, we held a meeting in 2006. All of them agreed to take compensation of certain amount. Therefore, we are passing the award. But you see, I can understand when we came to know only, my lord, court issued notice to us. Look here, in the 23 end, they have deposited the amount. But I received the notice from the court. Then, my lord, immediately I approached this court.
Yes.
I have produced those records also to show that.
Annexure N is the notice under section 9 and 10 before passing the award. Annexure N3 is the, my lord, objections filed by the petitioner to the notice under 9 and 3. And my lords, Annexure Q is the notice under section 12(2) dated 24/2/2023.
Synopsis ಅಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
ಹೇಳಿದ್ದೀವಿ.
But 28,
ಆಮೇಲೆ even from that date, 1 year, 10 months delay is there in approaching, my lord, this honorable court.
That we'll see.
Yes.
My lord, annexure N ideyala?
But so and so reserved. Yes.
My lord, one minute, my lord. My lord, can reserve it. One more judgment is, my lord.
One more judgment.
Kolkata Municipal Corporation. 7 golden principles.
Delay will not come in the way, sir. Adhe Kolkata Municipal Corporation.
No, 7 golden principle is, my lord.
The golden principle.
One of the,
All steps have to be followed is what this decision says. I have
latest judgment is, my lord, of this court, my lord.
Kodi.
Delay. This is KIDB. Where, my lord, earlier notification was upheld. Subsequently, my lord, parties approached this court. This court not only quashed it, they said, no, you have earlier approached this court. Therefore, you have no locus to question it. Then, my lord, court said, taken, my lord, 23 years delay in passing the award. In that case, my lord, quashed the proceeding. Kindly see, my lord, contention of under the KIDB Act.
Yes, we'll see.
That case, no award had been passed, my lord.
But here is a case, my lord, award is passed without notice to me. It is not an award in the eye of law.
You have participated, sir.
No, my lord.
Objections ಹಾಕಿದ್ದೀರಾ?
Shila Swami, now objection has notice ಕೊಟ್ಟಿಲ್ಲ. Kindly take annexure N1 for a
ಆಯ್ತು, we'll see.
ನಮ್ಮ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. Kindly see, my lord.
Objection ಯಾಕೆ ಹಾಕಿದ್ರಿ ಮತ್ತೆ?
ಯಾವುದು?
Objection ಯಾಕೆ ಹಾಕಿದ್ರಿ?
ತಾವು
ನೋಟಿಸ್.
ಒಮ್ಮೆ 18
Objection ಯಾಕೆ ಹಾಕಿದ್ರಿ? ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ನಾವು ಎಲ್ಲರೂ ಆಗಾಗ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಯಾಕಂದ್ರೆ ನಾವು ವಿ ಆರ್ ರನ್ನಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ಅಂತ. ನಾಟ್ ಓನ್ಲಿ ಮೀ, my lord.
ಸೊ ನೀವು ಅಬ್ಜೆಕ್ಷನ್
ಅಲ್ಲ,
ಹಾಕಿದ್ರಿ.
ನಾನು ಹಾಕಿದೆ. ಬಟ್ ನಾಟ್ ಟು ನೋಟಿಸ್ ಅಲ್ಲ. ನಾಟ್ ಟು ನೋಟಿಸ್ ಆಫ್ ಅವಾರ್ಡ್. ಯಾಕಂದ್ರೆ kindly see, my lord, 18/8/2023 ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಯಾರಿಗೂ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
Yes.
Lord, may I read that, Lord? Page 134 for a moment. Because they say
We'll
they
see,
have
we'll see.
issued
Yes, heard reserved. Next.
entry model may explain.
Entry mode ಇದೆಯಾ? Entry mode stands extended till the disposal of the petition.
Lord, may grant me 4 days time, Lord, I had to file an affidavit. Lord, those documents are there, Lord, but I am told that in some of the cases they have executed the sale deed.
I appear for the
With the partial execution. The learned counsel Murugesh Charati seeks a week's time yet again
He may
to
be
file his affidavit.
Permitted to place the memo along all the affidavits
So,
executed or
affidavit.
partly.
List the matter on 22nd. In the event no affidavit comes about as directed, the order would be passed here in the council, senior counsel for the petitioner. Yes, next.
Right.
Preliminary hearing.
But on the last date, your lordship said, directed the government to place on record whether order dated 1/7/25 to place on record whether the denotification had been gazetted or not. Of course, I had mentioned, my lords, several other writs were dismissed, but only whether.
1993, they claimed that there is an unnotified gazette notification. 97 is the first writ petition. Then 2002, then a civil suit, then the third writ petition, then before the division bench. 4 rounds they have lost. 5th round, my lords, they now come back and say 1993, there was a proposal for a denotification. Lords, this ground would have been available in 93, in 2002, in 2023, in 2024.
Lords, last time itself I said there is a history. But if the fact of matter is, if there is a gazette notification of denotification, that's the issue. That's why.
No.
16(2) is there.
You said there is a history, but what about this mystery of 39/1993? Where was it?
Lords, that is what we become aware. If there is a gazette notification, my lords, that's all. That's why your lordships wanted
ಮತ್ತೆ
to
ಇದು ಫಿಫ್ತ್ ರೌಂಡ್.
Fifth round.
Absolutely. But that's why, my lords.
ಈ ಸರಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಒಂದು 10 ಲಕ್ಷ
If the-
ಕಾಸ್ಟ್ ಹಾಕಿ
Lords, if your lordship,
Yes.
if your lordship sees the order dated 1st of July,
My order.
your lordship's order.
Last occasion, my lord, this honorable court directed me to produce the records with respect to
Yeah,
gazette.
the notification is a forged document and non-existent.
That is, if it is a forged document, I'll have nothing to stand. If it is a document on record,
Gazette notification forged.
ಅಂತ ಅವ್ರ contention ತಗೊಂಡಿರೋದು in their counter.
Publish ಆಗಿಲ್ಲ. Gazette ಇದೆ.
Gazette ಆಗಿದ್ರೆ nothing more remains.
ಇದೆಯಾ?
Gazette ಎರಡು ಫೈಲ್ ನಲ್ಲೂ ಇದೆ. RD ಫೈಲ್
Gazette, Lords, Gazette ಆಗಿಲ್ಲ, notification copy ಇದೆ. Or they say that it is not gazetted, but it's there in the, Lords, 1987 possession is taken. Mandamus is filed. After that, Lords, we have come before this honorable court on 2 occasions. This is like 5+2 rounds of
I understand.
litigations.
That's why, my lords, if there is a gazette notification,
It is in the file, it's not gazette.
my lords, according to the government, it is a gazetted.
No,
Both the files it is there, but
Not
it is
not gazetted.
ಸಿಕ್ಕಿಲ್ಲ ಇನ್ನ. I have been searching for that. Both the files it is there.
We got an endorsement, my Lords, after they said
Lords,
it's not
your lordship
gazetted.
may see their counter, what they say.
In the order sheet also,
What is, I think you're flogging a dead horse.
No, that's the, my lords, that's why I said, acquisition, many challenges have gone. But today, if on record, if there is a denotification,
Where is the denotification?
it's under 48, that's annexure A. Annexure A is that
That
notification.
ground was available to you always.
97.
Lords, I understand that, my lords, but
Constructive res judicate.
lords, against a statute, my lords,
Against a statute ಅದೇ.
if it is
Oh,
a,
ಇದು estoppel ಅಲ್ಲ.
ಅಲ್ಲ, estoppel ಅಂದ್ರೆ if there is a
Not-
gazette.
It's not the plea of estoppel that you're projecting. Constructive res judicate operates even on statutes. Yes.
Lords, on facts, yes, but if on record, if there is already a statutory notification of
There is
denotification.
no statutory notification at all.
Lords, according to us, it is there. Let the government say whether it's been gazetted. That's what your lordships wanted to know.
No, that's all right, but how did you come up with this strange
Lords,
ground
that's
now?
what we realized later. That's when, my lords.
Realize later ಅಂದ್ರೆ ಏನರ್ಥ?
Lords, that's
ಏಳ್ ಸರಿ ಆದ್ಮೇಲೆ 8ನೇ ಸರ್ತಿಗೆ realization.
that's what has happened.
No, no.
Lords, but if
We'll
it is
dismiss
there
with
on
cost
record.
now.
Lords, if the matter of record, my lords, if it is there, let the government say whether it's a forged one or it's on the part of the records. Thereafter, your lordships can pass an order. I will leave it at that. I'll not trouble my lords on that. But
Yes.
it should be,
there,
that
my
should
lord,
come.
it was sent to the gazette also on, and there is also a tipney with respect to there in the order sheet of the RD, my lord. But further, I have to pursue, but searching was been there. There is no.
See, what
gazette.
would have been the effect of denotification?
Lords, then the acquisition, so far as the society is concerned, so far as my land, only my land is
Is
concerned.
concerned.
Lords, that it cannot be.
Correct?
Yes.
Your land, you did not know about denotification. Acquisition is
But I
over.
had given
Five
represent-
five
No, no.
rounds of litigation is over.
See,
Now you are putting the clock back to
Lords,
the
I'll
state
only
where
say
there
this.
must be a
No,
denotification
no,
of the
not
land.
that. Lords, I have only produced records to show I had given a representation. They have acted on that. There are records to show they have acted on that.
Yes.
If your lordship see in the writ, my lords have produced their recommendation letters which has gone from SLAO to the government.
Page
But
6.
nobody brought it on record, my lords. Even if I had not brought,
No,
unfortunately, government also didn't bring it to the notice of the court. The fact that, the factum of that, there is a,
Absolutely flogging a dead horse.
that's the only thing I can say. my
Nothing,
lords.
sir,
If there-
nothing.
Because in their counter, they say there is no such notification and that it's a forced.
Okay.
Yeah,
All
which
your
are,
lordships
which are
will have
the,
to-
which are the orders passed?
Lords, that's there in
Lords,
their
may I kindly
counter.
see, the first of the order is at page number 62 in my statement of objections.
ಇವ್ರೇನ್ ಹಾಕಿಲ್ವಾ ಅದು?
ನಾವು ಹಾಕಿಲ್ಲ.
ಅವ್ರದ್ದು
Lords,
4 round
that's why I
ಹಾಕಿದ್ದಾರೆ.
said,
They have
nothing is
filed
said.
Lords,
Page.
page number 62 is the first order, which is filed. This is by the society, page 62. Lords, yes,
62
this
is not, society, yes.
Yes, the
Ah.
reason is, kindly have a look at page number 64.
Yes.
For the benefit of the state government initiated acquisition proceedings, Land Acquisition Act, the acquisition proceedings have been completed by passing of the award and taking of the possession from the landowners interested in the land, so on and so forth. Lords, after that, they deprecate the conduct of the government. Directions are given. The court says that we are resisting ourselves from imposing costs in the matter. At page number 67, para 6.
in which I am
Then-
not a party.
Then page 68 is the 16/2 notification. The date of taking possession, my lords, is 9/1/1987.
9/1
1987.
9/11.
9/11, sorry, 9/11/1987.
possession.
Yes, 16/2 is of 9/11/1987. Lords, then your lords will see the first of the writ petitions filed by them at page 122
By the present petitioner.
by the present petitioners, claiming
120.
under the same source of title.
122.
122. Para 3 is very important. If your lords were to see
Consent award.
consent award, delay and latches, then again, my lords, suppression of material facts. On 2 grounds, it is dismissed. Then page 139. Second round of writ petition.
ಇದು ಯಾರು ಹಾಕಿದ್ದು?
Lords, same 2 acres 20 gundas, the subject matter of this.
Petitioners are different.
Father of the petitioner number 1 and 2, Hanumanta Bovi. That is also dismissed on the ground of delay and latches.
ಆಮೇಲೆ
Then suit, page 143. Lords, OS number,
how was suit maintainable?
Lords, Lords may consider OS number 17573 of 2004, Hanumanta Bovi, fourth one in
All
that
right.
list at page. Plaint is rejected. Father of petition number 1 and 2.
Not
Plaint is-
maintainable. on the-
Plaint
on the
is
spot.
correct. It was
Yes,
not
plaint
maintainable.
is rejected. Then the next round, if your lords were to see, my lord, the next round of writ petition,
Justice Anand
page
Barade
number
ಅವರು.
1, yes.
ಅಲ್ಲೂ rejected.
Again, it is rejected. Lords, this is taken up before the division bench, 174. Lords, then, if your lords were to see the operative portion of the order, which is at page number 191. Rejected. Writ appeal is also dismissed.
ಆಮೇಲೆ
Then their father filed one more writ petition, page 192. Lords, this writ petition is withdrawn after filing the present writ petition.
ಇದರಲ್ಲಿ ಆ ಗ್ರೌಂಡ್ ಇಲ್ವಾ?
ಇಲ್ಲ. Idralli, this is a replica of the writ petition which was filed, which was disposed of by His Lordship Justice Anand Barade. It's verbatim the same. They have copied the draft,
Now the present petition.
not the present writ petition. Lords, in this, if your lords were to see, lords, what is very important is the observations made at page 188 by the revision bench
In the writ petition or what?
in the writ appeal. Lords, consistently, the possession having been taken in the first writ petition itself, there is a direction which was disposed in 1993 writ petition. Lords, in the latest paragraph number 12, 16(2) is observed that there is a presumption in terms of the possession having been taken. Possession having been taken, my lords, is of the year 1987. This is a finding, my lords, which is again standing at their face.
That's become final.
That's become final.
You still want to argue, sir?
Let's please come to their counter, page 70.
Leave the counter, sir.
No, 69. What was given to them, possession?
Which counter? Illi.
In the statement of objections, page
Page
69.
69.
69, 17/195. There are conditions, my lord, subject to following conditions, handed over possession if your lordship gets that. Please turn over at 70, clause 5. Any land deleted after the approval of the award should also be excluded. Based on this, the 93 notification, there is a denotification. Now, my lords, the denotification, the society says, my lords, if your lordship sees, that there is no such denotification at all. Please see in their para, my lords, that para 28. And that is the reason, my lords, we pointed out that if there is any such notification, they say there is no such notification of 3993. And section 48, my lord, only says that if there is a notification, that's the end of the matter. Whether, my lords, it's acted upon is a different matter.
Oh, seriously.
Lords, that is how your lordships had directed the government to place. Whether there's, lords, I will only say this, your lordships are non-suiting me on the previous orders. Lords, but if the,
With costs.
lords, but the factum that there is an award, that should come on record, my lords. I would only say this.
Yes. Anything
Otherwise,
else?
my lords, the government stand, your lordships have ordered, lords, your lordships have already observed that the government should place on record whether there is such a notification.
Government is placing, there is no notification.
Lords,
It's not
I don't think,
gazetted.
my lords, let them say that. I don't think that is the stand of the government, that there is no such notification.
So another 10 years you'll litigate on this.
Lords, if the government has to take a stand whether
No
there is a
problems. We'll do
notification,
it.
they do
No,
not say there is
we'll
no.
non-suit you on constructive res judicata.
Lords, but on the point of whether the existence of a
That's all right.
notification.
That's a 1993 notification you're wanting to project in 2025 after losing 7 battles.
Absolutely.
Yes.
Lords, I had pointed out on the last occasion itself.
No problem.
But if there is such a notification, Lord, the government has to take a stand whether it's on record or not. Otherwise, it's tomorrow, my lord, what happens is
Tomorrow nothing will happen.
Lords, we will only want to say this.
Yes.
Lords, if the government takes a stand, there is such a notification or there is no such notification.
Yes. No, I will not permit the government to take any stand in this. We will not put the clock back and undo all the orders that are passed which have suffered.
Lords, that's why, my lord, the lordships only
No,
refer
sir.
to. That's why, my lords, I pointed out from the,
That if that is not projected, then cannot be projected now.
lords, they were aware, if your lordship.
Who was aware?
Lords, the society was also aware. Lords, the society was
Not
aware.
society aware. You should have been aware of it and projected that then.
Lords, I should have, but the
over.
society, lords, at page 70, I pointed out, they were aware that certain lands were deleted. At page 70, my lords, your lordship should see that there was a specific
No,
clause
sir.
mentioned.
No, we'll not do all that. We'll not put the clock back.
And even, my lords, I am told, even in that, if your lordship sees, my lord, they have also shown the deletion of the area in 84, the layout plan. That's what I'm saying, my lords.
ಎಲ್ಲಿ ಇದು? ಹ? ಹ. ಓ, ಅದ್ ವಯೋಲಿಕ ಅವಲ್ದಾ?
ಇಲ್ಲ ಇಲ್ಲ. This is Gavipuram.
Bangalore University.
One additional fact, if I can place before your lordships, what happened? There was, after these lands were notified for our benefit, BDA also parallelly notified these very lands for acquisition. We gave representation saying that this is already the subject matter of the sanction plan by the BDA, work order is issued. Thereafter, BDA issued the denotification pertaining to these lands in our favor. This is not even a whisper in the entire writ petition regarding any of the earlier proceedings. Lords, may I just pass on this file, my lords, this notings in the file from page para 282.
All earlier orders ಎಲ್ಲ ಹೇಳಿಲ್ವಾ ಏನು?
No, not even a whisper.
ಹೌದಾ?
Please say, that's why last time itself I
ಅದಕ್ಕೆ I'm
started.
asking whether you still want to argue this matter.
My lords, that's why I only
So
said.
whatever be the ground, if you still want to argue this matter, exemplary costs for misleading this court without, not you, without,
Lords,
no,
when I
I'm not on
pointed
you,
out-
I'm not on you. On the pleading, without any pleading of the earlier proceedings, the present petition being filed,
Absolutely. There is
10
no,
ಲಕ್ಷ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ.
lords, there is no pleading.
Definitely, I'm going to impose 10 lakhs costs. You have suppressed all the 7 orders that are passed against you and filed the subject petition. You are joining the breed of people who are wanting to take this court for a ride. I'm not on you, sir. You're a senior counsel. I'm not on you.
Because last time I
Yes, Bharat
pointed
Kumar,
out.
you have drafted this. Why? You're not aware. Let the petitioner become aware of all these things. 10 ಲಕ್ಷ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ಇಲ್ಲರೆ ಇನ್ನೊಂದು 4 petition ಎಲ್ಲ ಸಪ್ರೆಸ್ ಮಾಡಿ ಮತ್ತೆ ಬರುತ್ತೆ. Yes. Anything else, sir?
Beyond that,
Heard
my lords.
reserved.
Lordships.
Panindra sir, not on you.
No, no,
On
I
him, I am, not even on him, on his
In
client.
fact, last time I pointed out, but only because. it
Either on
was-
Bharat Kumar nor on Panindra sir. It is on the petitioner. Yes.
39.
My lords, my name is not reflected in the cause list because of the reason that I filed power on 5/6.
Velmane ಅಂತ ಏನೋ ಇದೆ.
5/6 I filed power.
Learned counsel B.B. Patil submits that he has entered appearance in place of Gopal Velmane. List registry to print the name of BB Patil in place of so and so.
My lords, they have filed the statement of objections.
Let him get ready, sir. Yes.
So we have filed, my lords. We had moved a memo, so my lords may please connect this
Urgent.
along with serial number 15.
1-5.
Please.
Attack this petition along with 1-5. ಯಾವತ್ತು ಹೋಗಿದ್ದು?
Tuesday, my lords.
Next Tuesday.
Friday or Tuesday? 9th is on, my lords, it may be connected with 9th.
Serial number 9 is it?
9.
Tag
Next
the
Tuesday.
petition along with 9. ಅವತ್ತೇ ಬರುತ್ತೆ ಬಿಡಿ.
Please,
Yes.
oblige.
Deeply.
40.
I'm for the respondent. My lords, I would like to place my statement on record. Signatures ಹೋಗಿದೆ. Last week I had sought time to file it, but signatures ಹೋಗಿದೆ. Can we have it
Council Vinayak seeks a week's time. ಒಂದು ವಾರ ಸಾಕಾ?
next Tuesday?
List the matter on Tuesday, the next at the request of the council for the respondent BDA.
I'll place that on record. Much so.
41.
It's 41 is that Torino factory.
Torino.
Lords, where the, Lords, this many number of times your lordships have adjourned it, where this court has already held that the layout has been, the scheme has lapsed at page 49.
My lords, I'm sorry. My lord, some difficulty in getting the original file. My request, lordships, as a final in just 10 days time, my lords, I'll file my objections.
The problem is, my lords, please see from when
It
it's
has
been
lapsed,
adjourned.
but what I'm informed.
You are in
my lords,
possession? You are in possession?
We are in possession, my lords. What happens is
You don't disturb the possession.
No,
till
no,
you
they
file
are
your
not
objection.
disturbed. They are not disturbed, my lords. We are in dirt of funds because we need to set up something. We have found a purchaser now. Now we are stuck with this, and because of this litigation, somebody else is trying to trespass into this property. And if it's only matter of record, my lords, whether that layout, I have not heard of that Venkateshwara layout. The BDA can't trace this, my lords.
Lords, there is some.
I think you file your objections.
File my objections.
We'll grant the interim order till then. The learned counsel B. Vachan seeks 2 more weeks' time to file statement of objections. In the light of the time being sought and the position of the petitioner, being put to jeopardy, I deem it appropriate to grant the interim order as spread for. ಏನ್ ಬೇಕಾಗಿಲ್ವಾ ಅದು?
ಸ್ವಲ್ಪ urgency, because we have. only because-
24th.
Oblige.
Yes, by then haki. Objections by then. Next.
42.
Memo for withdrawal.
Withdrawal.
Yes.
In terms of memo. Yes, next.
43.
Restricting my prayer only to 38D, my lord.
Yes, 4,000 square feet.
That's not a standard measurement which is to be given. They need.
What,
show-
then you need.
But they will have to, my lords, it is so far as the construction which is in existence. That is the maximum limit that's been prescribed. It is not-
Maximum limit ಅಷ್ಟೇ, not.
Not.
ಅಲ್ಲ, statute ಪ್ರಕಾರ ಎಷ್ಟಿದೆ sir?
I'll just.
38D ಪ್ರಕಾರ ಎಷ್ಟಿದೆ?
Please, I'll take.
38D ನಲ್ಲಿ
They can make that application.
extent of land with building,
Please.
up to corner site ಆದ್ರೆ up to 2030 ಅಂದ್ರೆ 38D my lord has a table. More than 60 by 40 and up to 50-80 my lord is the maximum. Up to
That is 4,000 square feet.
ಹೌದು. Maximum is 50-80 my lord, I fall below
Full
that.
site.
ಹೌದು, full site.
Lords, they need to satisfy the
Iವ್ರದ್ದು
conditions. They have
ಎಷ್ಟು?
to file. Lords, they are making statement, my lords, as per the petition. There are totally 4 sites which are being
ಅಲ್ಲ
prescribed.
ನಮ್ದೇನೇ ಇರ್ಲಿ my lord, I forego all that.
Lords, it would be. It
Let
would
them
certainly be a
consider it, my
consideration.
lord.
ಅಲ್ಲ, he is saying he is
And a measurement.
foregoing all other prayers. He will given a representation or give?
We have given my lord, it's there.
Then
I was not able to secure any such.
then secure instructions. Don't take anything on you. Yes.
My lord, may I just place this, my lord? The
Representative.
previous, my lord, your lordships had particularly directed me last time that have you made periodical, this, my lord, we have in fact made periodical representations.
Oh, ಇದು 230 move ಮಾಡಿ JCB matter.
ಅದೇ
yes,
same, my
sir.
lord, bulldozer matter. Bulldozer matter.
Yes.
I'm good with my lord, whatever your lord says.
Sashinagar.
Bhupasandra, my lord.
ಅದೇ ಗೊತ್ತಾಯ್ತು, yes.
My lords, so kindly note the document which the senior counsel just placed. Page number, ink page number 5.
No, this you secure instructions and accept.
They are expanding
38D also you accept. But electricity bill ತೋರಿಸ್ಬಿಟ್ಟು 38D ಅಂತ ಇದ್ದಾರೆ.
ಅಲ್ಲ, let there be an inspection, my lord.
Yes.
Let there be an inspection, my lord. Let them find what exactly is the ground situation, my lord. I'll cooperate.
They will have to file
Let
an
them draw an
application under
independent
the
report, my lord, as regards to the
You,
exact
in
position.
support of your representation, you produce everything before them.
Greatly.
They have to
They
file
will
application, my lords. They have
That's
to
what,
file
in
necessary
accordance with
application.
law.
Yes.
You file whatever you want to
Definitive
file before them.
application, yes.
They will consider and pass orders.
I'll file a definitive.
But not today, after he
I'll-
seeks instructions.
Greatly obliged.
Yes.
Please.
I'll take it on Friday, ಆಗತ್ತಾ ಇಲ್ಲ next Tuesday.
22nd.
List on 22nd in preliminary hearing.
Interim protection may kindly be continued, my lord.
No JCB shall be taken into
I
the,
am greatly obliged.
taken before the house of the petitioner.
In fact, my lord, that JCB, my lord, has become so colloquial, my lord, it's a brand actually.
I know it's a brand.
ಹೌದು, ಅದು ಅರ್ಥ ಮೂವರ್ಗೆ synonym has become JCB.
JCB is the company name.
Company.
It's a company name.
So great.
It's in the UK.
ಹೌದು, it's in UK. We envy your lordships, my lord.
It's in Manchester. It's in UK.
Greatly obliged, greatly obliged.
44.
Lordship had issued. Lordships had
Bill
issued
number?
a 44, my lords.
Inspection report.
On 11th, my lord, inspection was conducted.
Ah.
And my lord, we have prepared a report along with the CD report, current dimension report. Now we have, the allotment section will have to now proceed forward with the balance formalities, my lord. The relief, my lord, that has been sought is that sale deed has to be executed after the completion of the lease term.
Sale deed has to be executed after completion of the
Lease term.
Lease
The
term?
lease, my lord, may I submit this?
It's completed.
May I submit this? The allotment initially was made in the name of the father of the petitioner, my lord.
Correct.
Father passed away.
Yes.
Succeeded by 3 legal heirs, mother and a sister. The petition claims, my lord, that by way of an affidavit, they say that no objections has been given
Then
for the
victim,
transfer.
what else you want?
It has to be by way of a registered instrument, my lord. Either they let them be made a
So that
party.
he will
Without-
comply with all what is
You
necessary.
have tried
them
that
be-
also, without
let them-
e-khata, they are not registering any document.
Let them be made a party to the petition so
Idit
that, my
bada,
lord,
they will give you, see, don't expand the scope of this petition.
they have
Whatever you want from them, you will get it.
My request, my lord, to come to and page number 6, my lord, petition.
ದುಡ್ಡೆಲ್ಲ ತಗೊಂಡು ಅವ್ರ ತಂದೆ ಹತ್ರ ನೀವು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಲ್ಲ.
We can give the other legal heirs ಇದಾರೆ ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
He will give you all the necessities that you have to execute the sale deed in accordance with law, including the registered document of relinquishment. ಇದು ಕೊಡ್ತಾರ ಅದು?
ಈ-ಖಾತಾ ಇಲ್ದೆಲ್ಲ ಕೊಡಲ್ಲ ಸ್ವಾಮಿ, ಅದೇ.
ಅದಲ್ಲ ಸರ್, ನಿಮ್ಮ ಅದರ್ ಲೀಗಲ್ ಹೇರ್ಸ್
They will give, but the
ಅದೆಲ್ಲ
problem is-
ಕೊಟ್ಮೇಲೆ ಅವ್ರು ಕೊಡ್ತಾರೆ.
The problem is they cannot register relinquished deed before the sub-register without e-khata.
That e-khata, my lord, BBMP has to give the e-khata. ಅದಕ್ಕೆ ನಾನು may I
ಅಲ್ಲ,
suggest
ನೀವು
this-
ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ಮೇಲೆ ಅವ್ರಿಗೆ ಖಾತಾ
ನಾನು
ಎಲ್ಲ ಇಟ್ ಇಸ್ ಅ ಸೈಕಲ್.
May I suggest this, my lord? Let them be made a party here. The event of there being a direction by your lordships, we will execute the deed in favor of all the 3 people, my lords.
That is also, ಬೇರೆ ಆಪ್ಷನ್ ಇಲ್ದಿರ, that is correct.
Then they get
They'll
the
be bound by this.
ಅಲ್ಲ, it may be ordered in the same way.
Party petitioners.
Only son is made a party. ಅದಕ್ಕೆ.
And peculiar facts will permit him to plead them as petitioners.
Please, my lord, I have no objection.
ಮಾಡಿ. The petitioner is the son of one late Chandrasekhar BC, who was allotted a site
May I request? I'm sorry, my lord. Is my lord proceeding to pass final order, my lord?
No.
Please, my lord.
ಅದು ಆರ್ಡರ್ ಬರೀಬೇಕಲ್ಲ ಅದಕ್ಕೆ.
Please, my lord.
Allotted a site in terms of the Bangalore Development Authority within bracket allotment of site rules 1984. Dimension ಏನು?
30-40.
Measuring 13 to 40. The father, after complying with all the statutory requirements of allotment, dies. The petitioner then knocks at the doors of the BDA, seeking registration of the sale deed on account of the allotment. The sale deed is not executed on generation of certain obfuscation. This court directed inspection to be conducted in the presence of the petitioner with regard to existence of the property or otherwise. The report indicates that the property is in existence. The submission of the learned counsel now is that there are two other legal heirs of Chandrasekhar BC who could be claimants. The learned counsel for the petitioner submits that they be permitted to be impleaded as petitioners in the peculiar facts of this case into these proceedings to avoid multiplicity of proceedings. In that light, the petitioner shall implead the sister and mother as party respondents to these proceedings.
Next week.
List the matter on 22nd. ಈಗಲೇ ಮಾಡಿ ಅದು. ಅವರೇ ತಗೊಂಡು ಅವರೇ ಹಾಕ್ತಾರೆ ಅದಕ್ಕೂ.
Please, my lord.
Next week close ಮಾಡೋಣ.
Please.
Please, my lords. Last occasion, my lords, learned friend referred to the judgment of the division bench, my lords. So I request my lords to just refer to para 29 there.
Yes, sir.
May I read that portion?
Land grabbing court ಹೋಗ್ಬೇಕು ಬೇಡವಾ?
Yes.
Division bench judgment ಇದೆ.
Please, my lords. In fact, division bench judgment, lords, they make the statement to that. If I just can read that portion.
Really?
I'll read that portion, lords, how it is to be considered. 29 para reading.
Yes.
Thus necessarily, if a person is claiming a right by way of lawful entitlement through any valid document issued or granted in favor of such person, which though disputed by the authorities concerned, on the ground that such a grant, allotment or the like could not have been made in favor of such persons, so long as the said document relied upon by the plaintiff is not countered or negated on the basis of fraud or forgery, and the claim of the plaintiff being one of the lawful entitlement, such proceedings pending before the competent civil court cannot be transferred under the act. In this case, my lords, we have taken up very specifically in the written statement.
ಏನಂತ?
I'll just read that also. In the written statement, my lords, we have taken very specific plea, my lords, that page 38, my lords, of the written petition. The last paragraph after para number 14. The defendant submits that the aforesaid S. Shankarappa along with one S.R. Narsimurthy have forged, fabricated, manipulated and created bogus documents, that is possession certificate dated 22/5/1971 and sale deed dated 21/10/1989, and also the aforesaid persons with the collusion of the officials of the defendant authority have tampered with the BDA ledgers and entered the name of S. Shankarappa in the ledger of this defendant authority, and hence have the said alleged ledger entry alone cannot be considered for having as
Yes,
a
sir.
please. Therefore, my lords, the requirement to show that whether such a condition exists in this has been pointed out. Therefore, even as per para 27, my lords, the court has to record a reason finding whether the act is attracted to the situation or not. The trial court in this case has said that this is not the stage at which it can do it. Lords, if a full-fledged trial is to be conducted by the civil court itself, my lords, then purpose of having a special court wouldn't arise. The civil court, my lords, would be required to draw a prima facie consideration looking into the affirmance which have been made in the plaint and the defendant in the written statement, my lords, and would have to pass necessary orders.
Yes, Manja.
My lord.
How did you come in possession of the land?
My lord, it is the specific case of the plaintiff before the trial court that BD has allotted this property. Then
When?
the CITB in the
Page-
year 1971, page number 20.
Page 20 na?
Yes, my lord. Para number 4. May I read, my lord? The plaintiff submits that originally suit schedule property was owned by one Shankarappa, to whom suit schedule property was allotted by the then CITB Bangalore, and possession certificate was also issued to him on 22/5/1971. Thereafterwards, he has put up 6 squares residential house in the said property. Thereafterwards, he sold the property to my father, parents.
When was the sale?
Sale is in the year 1991, para number 5,
Yes.
4th line. Here, my lord, the honorable trial court has held that the trial is required, and section 20 requirement, the satisfaction of the court is also to be recorded before sending the matter to the land grabbing court. Here, it is the case of the BDA that it has not allotted.
Now, this is a sale deed. Pursuant to sale deed, you come into the possession.
Yes. And my land may kindly point to the page number 21, where also we have stated that 2 suits have been decreed, and that is RFA is also pending, para number 7 and 8. OS number.
2 suits are decreed in whose favor?
Our favor only.
BDA was the defendant there?
BDA was the defendant. And this is a matter of trial, where we are relaying the sale deed and all the documents. And BD allotment book also, we have related this RTA copy, where it is shown that allotment was made to Shankarappa.
Yes, sir. What is the order under challenge now?
The additional issue as I answered in negative, and one more application is filed after the additional issues order, sir. Very same.
What, order 14 rule 5?
Alla, first,
When the written statement was filed, Lords, the court considered whether it needs to frame the additional issue, Lords, page 49.
With regard to?
Lords, with regard to, I'll just read that, Lords, whether the defendant proves that as per section 10A of Karnataka Land Grabbing Prohibition Act, this court, there is bar of jurisdictional civil court to try the suit. Lords, that was the order which was considered.
Yes,
Thereafter, Lords, we filed an application for transfer. That was rejected in view of the particular order.
It has to be tried.
Lords,
More so in the light of the fact that you have suffered to decrease. It may be pending here, but
Lords, it's not
it
a,
has to be tried.
not a decree of on declaration.
Injunction.
Now the suit which has been
Injunction.
filed, now the suit which has been filed is for declaration.
Correct. Our injunction ಹಾಕಿ ಎರಡು ಡಿಗ್ರಿ ತಗೊಂಡ್ರೆ ನೀವು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾನೆ ಇದ್ರೆ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಬೇಕು. ಇನ್ನೇನು? What else is there? Only then you will keep quiet. ಇಲ್ದರೆ ಬೇರೆ ಇಂಜಂಕ್ಷನ್ ಅಂದ್ಬಿಟ್ಟು ಮತ್ತೆ ಮಾಡ್ತಾನೆ ಇರ್ತೀರ. Yes, you have suffered to decrease. It can't be transferred to the land grabbing court for the mere asking. Nothing wrong in the order. Anything else? The petitioner, Bangalore Development Authority, is at the doors of this court calling in question an order dated, both same, Allah?
Yes.
Additional issues.
Calling in question orders dated 30th September 2024 and ಇನ್ನೊಂದ್ರಲ್ಲೇನು?
The date is
24 to 2025.
24 to 2024.
25.
24 to 2025, by which the concerned court declines to transfer the pending suit to the court, to the land grabbing so and so court, court constituted under section 10 of the Land Grabbing Act. Heard so and so. The petitioner, the respondent is the plaintiff. The plaintiff institutes a suit in OS 26968 of 2022 seeking declaration, injunction, again restraining the respondent BDA from interfering with the possession of the petitioner. The plaintiff comes into possession of the property from on a purchase from one Shankarappa who had been allotted the site from the erstwhile City Improvement Trust Board. City Improvement Trust Board, the CITB. It transpires that after the sale on in terms of two sale deeds on 21/10/1989 and 16/12/1991, the Bangalore Development Authority began to interfere with the possession of the petitioner. The petitioner therefore had to institute suit in OS 3128 of 2003 and OS 7106 of 2005, both of which have been decreed in favor of the petitioner and against the Bangalore Development Authority. The Bangalore Development Authority is said to have preferred regular first appeal before this court and is pending adjudication. The present suit comes about for seeking relief of declaration and mandatory injunction in the light of the persistent interference of the BDA with the possession of the plaintiff. In the said proceeding, the BDA files application seeking transfer of the suit to the court of the land grabbing on the score that the plaintiff is a land grabber and the land belongs to BDA, and seeks to produce it in documents and hakidra illa so and so, and seeks to frame an additional issue which should be treated as a preliminary issue as to whether the suit by a land grabber is maintainable or the matter has to be transferred to the court of so and so created under the Land Grabbing Act. The concerned court rejects the applications on this score that it is not the stage at which it can be decided, and as it would require a matter of trial, as it could require evidence and it is a matter of trial. The BDA being aggrieved by the said order is at the doors of this court. The learned counsel appearing for the Ajay Kumar appearing for the BDA would vehemently contend that the issue is question of jurisdiction of the concerned court, as the plaintiff is a land grabber, and therefore the matter should be tried only before the land grabbing court and not before the civil court. It may be that the application is preferred at the fag end of the trial, but it does not, since it is the issue with concerning jurisdiction, the court ought to have answered it in favor of the BDA. He would seek the orders be set aside and the matter be placed before the land grabbing court. The learned counsel appearing for the respondent would vehemently refute the submission, reiterating the plain governments, contending that he is in lawful possession for the last 37 years, having purchased it from an allottee from the City Improvement Trust Board. He would submit that it is a matter of trial. The concerned court has appropriately held that it is a matter of trial and not transfer simpliciter to the court of the BDA, a court of the land grabbing. In that light, he would seek dismissal of the petitions. I have given my anxious consideration, so the afore narrated facts are a matter of record. It is the plain government. It is a matter of record. It is not in dispute that the petitioner is comes in possession of the property pursuant to two sale deeds dated 21/10/1989 and 6/12/1991 from an allottee from the City Improvement Trust Board, which allotment is said to have been made on 22/5/1971, and the petitioner has put up a residential house in the said place. The petitioner was the plaintiff was constrained to institute two suits as observed herein above, seeking injunction against the BDA from interfering with his possession. Both the suits are decreed, which would prima facie indicate that the petitioner is in possession of the property, as those were suits for injunction. The BDA does not stop but interferes with the possession of the plaintiff, and therefore the subject suit comes about. In this suit comes the application filed by the BDA seeking transfer of the matter to the hands of the land grabbing court by framing an additional issue to be treated as a preliminary issue, whether the suit was maintainable or otherwise. The division bench of this court in ILR 2021-385, while answering an identical circumstance as to when the civil suit should be transferred to the land grabbing court, has elucidated as follows. Para 29 to 37. The division bench holds that if someone is in lawful possession and that possession has been interfered with, it is not that the matter should be transferred to the land grabbing court unless the concerned civil court comes to a conclusion on its satisfaction that the matter that the plaintiff therein is a land grabber and the matter has to be transferred to the land grabbing court. Identical order was passed by a learned single judge directing transfer of the suit to a land grabbing court. This comes to be upturned by the division bench in writ petition 4410 of 2020 on 15th by its order dated 15th March 2022, whereby the order of the land grabbing court entertaining the issue was set aside and the suit in OS 301 of 2010 stood restored. The division bench has again elucidated the principles of such transfer in the order para 6 to end. In the light of the aforesaid orders of the division bench and the factum of the plaintiff coming into possession of the property through the two sale deeds as quoted herein above, and the Bangalore Development Authority suffering two orders of injunction against in suits instituted by the plaintiff, the present respondent, it would not lie with the BDA to now contend, but now contend that the matter should be transferred to the land grabbing court at their asking. The law is very clear, as is elucidated herein above. Therefore, there is no warrant of interference to the order passed by the concerned court, which only directs that it is a matter of evidence as to whether the petitioner is a plaintiff is a land grabber or otherwise. In that light, finding no merit, petition stands rejected. Petitions stand rejected.
Yes. Serial number 44.
Whether petitioner has to be impleted or a respondent.
ಪೆಟಿಷನರ್ ಆಗಿ ಮಾಡಿ.
ಅದೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಬಂದಿದೆ.
ಇಲ್ಲ ಪೆಕ್ಯುಲಿಯರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಲ್ಲಿ ಪರ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳದ್ನಲ್ಲ.
ಅಲ್ಲ ಡಿಕ್ಟೇಷನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಬಂದಿದೆ.
ಇಲ್ಲ ಹೌದಾ ನೋಡ್ತಿದ್ದೆ ಪೆಟಿಷನರ್ ಆಗಿ ಮಾಡಿ. ಎಸ್ ಜನರಲಿ ಇಟ್ಸ್ ನಾಟ್ ಪರ್ಮಿಟೆಡ್ ಬಟ್ ಬಿಕಾಸ್ ಟು ರಿಸಾಲ್ವ್ ದಿ ಇಶ್ಯೂ.
46.
Preliminary notification is under challenge, my lord. This court already quashed the preliminary notification. I served copy to GB Sharat Gowda.
My lord,
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
GB Sharat Gowda.
I am appearing on behalf of GB Sharat Gowda, my lord.
Annexure P, my lord.
Learned counsel GB Sharat Gowda accepts notice for respondent vide na?
Muda.
Muda.
2 and 3.
ಅವರು GB Sharat Gowda ಇದ್ದಾರಾ?
Yes, ma'am.
2 and 3 state first respondent.
Annexure F series, my lord, it can be disposed.
Correct. List the matter on 29th.
Okay.
In preliminary.
Petitions if any by then. Next.
It is in preliminary.
Preliminary.
Please.
Dispose ಮಾಡಬಲ್ಲ preliminary.
47.
Petition. The commercial court, my lord, after noticing the fact that I have filed the petition before the Kanpur court,
ಈಗ
passed an order to release.
You are wanting to withdraw the deposit.
And to put it in Kanpur court ಅಷ್ಟೇ.
ನೀವು ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ.
We'll give an undertaking.
We'll direct the court itself to transfer.
That exercise is also permissible, okay.
1 minute, sir.
Both.
Now, as far as the execution petition being instituted here, it is permissible. No problem at all. Sundaram Finance
Yes.
clears the
Settled
air. Clears the air on that. So you continue the execution petition. But 34, if he has to file an appeal under 34, it has to be with 75% deposit. Correct. If the appeal is not entertained there and the deposit lies here, he will be put to jeopardy.
With respect to that, there have been duplicity of proceedings all the way through. The facts
What can
of the
be done?
case-
Now we are concerned with the present proceeding.
No, my lords, what I'm trying to put before this honorable court is, my lords, a coordinate bench of this honorable court had also heard the matter. With my writ petition, my lords, itself, last this thing, they sought the appointment of the arbitrator here. Then itself it was decided that Kanpur would be the place. They still end up filing it here. My lords, now the issue is that they want to bear the benefits but not bear the burden of their own deeds.
I can't direct Kanpur court to do something. All right.
My lords, at
Your
least-
execution petition will permit it to
At least
continue.
the condition stipulating, my
What
lords,
conditions?
which is submitted there within time.
That I
My
will
lords,
do.
this writ
I will not,
petition, my
I will not
lords,
direct the judgment debtor. I will direct the court to transmit it.
My lords, the other issue which I want to highlight before this honorable court, my lords, my execution is pending for the past 9 months.
That
Rahul
we-
Shah's
we
judgment
will-
clearly says it needs
we
to be
will
wrapped
direct-
within
we
6
will
months.
direct conclusion of
My
that
lords,
also.
this particular writ petition also, which is filed by the JD, my lords, when is it filed? A opportune moment once the bailiff report comes in.
All right.
They are not digging all these
They
matters.
have
Everybody-
sought the stay,
No,
my
no,
lords,
that's all
what
right.
they weren't able to
No,
do
that
it
is-
directly.
that is the only thing that can be done if you are on this side also. Nothing else, nothing.
My lords, I do not
Telecast,
deny,
yes.
my lords, that
No,
aspect.
they are not naive. Who said judgment debtor is not naive?
My lords, at least the execution may be made time on, my
That we will
lords.
do. But
Because
the
it's a very
court-
opportune
Now
moment.
the
They
amount-
say that the amount is deposited, it is accessible to us, so therefore they won't give us
You forget
anything.
the reasons,
Is
sir.
what their stand is.
You forget the reasons. Now the amount that is in deposit, will direct the concerned court to transmit it to the court at Kanpur, which is that court.
Please, I
So
have filed a
that
memo.
will be neither with you nor with him. The court will decide. We will direct execution proceedings to be concluded within a time frame.
Please.
That's all.
Till the Kanpur court decides his application.
No, no,
for
that,
stay.
that rider I cannot. Whose application?
36.
Your application.
Yes.
So you move then you will never move it.
No, it's moved and it is posted to
You,
today.
you move the matter before the Kanpur.
Yes, I have
court.
already moved.
The execution proceedings will.
No, the Kanpur court,
it is
just 1 minute. The Kanpur court has posted the matter to today to deposit 75% for the purpose of granting interim order of stay. I could not make the deposit since it is lying here.
Where is that?
Petition I have.
Kanpur court.
No, they have placed on record.
Where have you placed on?
I have placed it on record.
Memo code.
It is in Hindi. I have translated it and filed it.
ಎಲ್ಲಿದೆ?
I have got a copy.
ಕೊಡಿ.
Translate.
ಎರಡು
My lords,
Sorry, my lords.
I have translated it.
Oh,
It's
why?
a type fair
Translation problem
version.
ಇದೆಯಾ?
No, my lords, I was brought up in Delhi, so I perhaps studied Hindi.
Heard and observed the arguments of learned counsel since the petition is being filed by the applicant.
Direct to deposit said amount the court by advance due to the hearing should be on 15/7.
Yes,
It's today.
ಇವತ್ತಿದೆ.
We will direct transmission of the amount immediately.
Yes, my lords.
Yes.
My lords, and meanwhile, the point of law is also settled, I believe, my lords. 36(2) does not bar the execution proceedings to continue here.
No, that is.
I will proceed with the execution
proceed with the
proceedings. My lords
execution.
may just make it time bound for me.
May respect.
Sundaram Finance is,
Because-
Sundaram.
Not only Rahul Shah, my lords, I have
Rahul
submitted.
Shah is with regard to time limit.
Yes.
Rahul Shah, 5-6
From
postulates,
finances, yes.
postulates are laid down how it should be
I
concluded.
don't
That's all
say
right.
that the execution is not maintainable here. My only
No, that
request
is not your submission also.
That is not my submission.
My lords,
My respectful submission is, till the amount is transmitted there, you will have an opportunity to withdraw the amount. I may not have any objection. Till such time, let him not execute it. ಅಷ್ಟೇ.
ಅಲ್ಲ, let
my
it-
lords, that
ಒಂದು
would
ವಾರ
be.
ನೋ 10 days,
my lords,
some
I
protection.
ಈಗ
Got this case.
Aditya.
Yes, my lords.
will grant him 3 weeks time. After 3 weeks, if no order is passed by that court, you
Let him
can proceed with the execution or amount, whatever.
The issue is certainly no notices have been issued to me till date.
ಯಾವ್ದ್ರಲ್ಲಿ?
Kanpuralli.
Correct,
Agreed.
that is not happened.
The other
No,
aspect,
that
my
is
lords,
why
my
we
lords,
will
may
fix-
just see the translation once.
File
Lords,
was
They are
presented and
still
all.
dealing with office objections. This is number third.
That they will do.
That they will
The
do.
problem
That is
is, my
why I will-
lords,
I
it's a
will-
question of admission is still pending.
No, I will
Today.
grant them only 3 weeks time. If in 3 weeks they don't secure an order at the Kanpur court, you can proceed here and take its law to its logical conclusion. All right? That should be balancing both ways.
My lords, the only issue is they deposit the 75% there. The court will grant
may
automatically, they
succeed
will stay the execution.
134.
That's the
Right,
right.
that is the difficulty that I would
But
face.
True, that's
My
the right.
lords, now the issue is,
See,
my lords may just take a
34 is a right.
Unfettered right.
glance at the
That is not the
bailiff
submission to be
report.
made
my
here.
lords.
No, that's all
The
right.
issue,
That
perhaps
34 is-
the reason, my lords, why I had laid down my submissions is with regard to their prayer.
These are not
They
the
have
submissions.
sought to
Once-
challenge the
The
award
short
which
question is
rejected
involved
my
is-
withdrawal.
Don't worry about all that. Now we will only deal it in a manner that is
I'll
necessary
just
to be dealt with
conclude
in law.
this
Yes.
one point with my lord's permission. My lords, their prayer is challenging my order which rejected my request for withdrawal. The warrant was issued pursuant to the fact that the court actually took a concurrent view that it neither shall be released
Ramesh,
to us,
no,
neither shall be
withdrawal-
released to the JD.
The withdrawal of the amount would defeat his right completely in 34.
My lords,
That is not correct.
the second aspect is with respect to the application which they had moved subsequently after seeking the stay from here. My lords, their second prayer is directing the release of the amounts. My lords, but they go back to the commercial courts.
No,
They again say
directing
that
the
now
release-
there is a
release of the
direction.
amount in what proceeding?
In 84, my lords, they
In
again
in
refile
34
it.
proceeding, right?
They refile it.
No, why Kanpur mein puchiye? Yes.
Yes, my lords, certainly.
The petitioner, these, what are the other petition?
My lords, there was the other one.
Application seeking to withdraw that amount is rejected by the commercial.
Oh, that is challenged there. ನೀವೇನ್ challenge ಮಾಡಿದ್ದೀರಾ?
They challenge ಮಾಡಿದ್ದಾರೆ.
Same order.
They have challenged the same thing.
Same
They are
order.
challenging an order which is against me.
No, what
Same
what
order is challenged.
what-
Denies me the benefit
One
of the
ನಿಮಿಷ.
deposit.
The commercial court, after having rejected my application, has ordered for issuance of warrant. That is the
ಅದನ್ನ
order.
challenge ಮಾಡಿದ್ದೀರಾ?
I've been challenged, but inter-alia, I have also made an application for amendment for rejection of my application for withdrawing the amount. Thereafter, my lord, the commercial court rejected my application and promised that no proof of the petition being filed before the Kanpur court. Subsequently, I made an application
All
with
right.
the proof.
The petitioner, these petitions call in question a solitary order or its aftermath. Writ petition 17879 of 2025 is preferred by the judgment debtor. Writ petition 19971 of 2025 is preferred by the decree holder. The parties to the list had the transaction agreement,
Service.
The parties to the list were parties to a service agreement, and the dispute arose about the said service agreement, and the petitioner had filed a petition under section 19 of the MSMED 2006 at the full haki.
Malad, section 18, 19 is the appeal provision. Malad.
Section 8, that's what. Section 18 of the MSMED 2006 challenging the, in which an award is passed in, what is this, commercial API?
Malad, it's claim petition 86 of.
Claim petition 84 of 2024. Is that the one?
Malad, the original award is passed under claim petition 86.
Claim petition 86 of 2024. That is called in question where? That's under 34?
Yes.
The said award is called in question invoking section 34 of the, invoking section 19 read with 34 of the Arbitration and Conciliation Act, challenging the award so passed by, award is passed in Kanpur.
My lords, it is claim petition 86 of 2022. This is for delayed payments, my lords. The issue was they have actually held my GST amount.
No, let's not get into the facts.
I'm not going into the merits of that matter.
Then I'll be nowhere.
But,
I'm only trying to gather the facts only to a
claim
preamble.
petition 86 of 2022.
That's only preamble, yes.
Yes. The decree holder is registered office for the partnership is in Kanpur. So therefore it came before the MSFEC Kanpur.
The
MSCFC.
MSMEC Kanpur had passed an order of deposit of, what is the award passed?
The entire award.
41 lakh 60,000.
30 lakhs 50,000 is the principal amount, along with interest is 10 lakh 10,693.
Total
4160 693.
That's what I'm asking. The
along with
amount of 41 lakh 60,000 693. The issue is not with regard to the merit of the claim. The petitioner files an appeal under section 34 before the court at Bangalore. The court, realizing the fact that it does not have jurisdiction, directs the petitioner to file the same before the competent court at Kanpur.
In such order, there is an order of stay with a condition to deposit.
So and so. While granting stay kotidra illi, while granting stay in a petition in the said petition, deposit of 75% of the amount, i.e. 75% of 41 lakh 60,000 693 was made pursuant to a direction of the concerned court. In the light of the amount being, in the light of the case being transferred to a competent court, directed to present it before the competent court at Kanpur, what happens to the deposit led to these proceedings. The deposit was directed to be withdrawn, was sought to be withdrawn by the judgment debtor and the decree holder both. The applications come to be rejected. After rejection of the application, the concerned court issues a warrant against the judgment debtor, and therefore the judgment debtor is at the doors of this court. The issue now would be, the proceedings are now pending before the Kanpur court. The Kanpur court, to entertain the petition, the petitioner judgment debtor has to deposit 75% of the amount, which is a statutory requirement. Therefore, the amount lying before this court is sought to be withdrawn by the judgment debtor and to be deposited before the concerned court at Kanpur. The counsel for the respondent, the counsel for the decree holder submits that in the event the deposit would not be made, my execution would be put to jeopardy, and the court would not continue the execution proceedings if the Kanpur court would not pass any order. In that light, to resolve the issue, I deem it appropriate to direct the concerned court, registry of the concerned court, to transmit the amount that is in deposit, i.e. 75%, to the registry of the court at Kanpur. The court anta barthkodi. To the court at Kanpur. Kanpur, without broking any delay. The learned counsel for the petitioner submits that the matter is listed today for such deposit before the court at Kanpur and places on record the evidence of such listing. In that light, the registry so and so of the concerned court shall forthwith transmit the amount in deposit in the to the concerned court in the number in the aforesaid number commercial appeal adu.
Illa, my lords. It is miscellaneous civil cases, and the registration number on it is 18 of 2025.
ತಗೊಂಡ್ರದ ಅದು ಬರ್ದು ಕೊಟ್ಬಿಡಿ ಅದಕ್ಕೆ.
Sure, my lords.
Yes. So and so. In the light of the said transmission and the interim order subsisting today, I deem it appropriate to extend the same for a period of 3 weeks, so as to enable the petitioner so as to enable the registry to transmit the amount and the petitioner seek appropriate order before the concerned court. The learned counsel for the respondent decree holder submits that the execution is pending for the last 9 months, and there should be a direction at the hands of this court to infuse finality into the execution in terms of the judgment of the apex court in the case of Rahul Shah. The submission would merit acceptance, but the issue is that should not come in the way of the concerned court at Kanpur passing any orders on its merit on the claim made by the judgment debtor or the defense of the decree holder. Since the matter is at large before the court at Kanpur filed under section 34 of the Arbitration Conciliation Act, the 3 weeks time would be the time in which the petitioner judgment debtor will have to secure appropriate orders before the concerned court. Subject to the aforesaid, the execution proceedings shall continue. Yes.
Subject to the transmission of the amount from the concerned.
ಅದು ಗೊತ್ತದ ಮುಂಚೆನೆ ಹೇಳಿದ್ದೀನಿ ಅದನ್ನ. Yes.
ಈ ಅಮೌಂಟ್ ಅಲ್ಲಿ ಹೋಗದೆ ಇದ್ರೆ ಇವ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡ್ ಮಾಡೋದು ಕಷ್ಟ ಆಗುತ್ತೆ.
ರಿಜಿಸ್ಟರ್ forthwith transfer ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದೀನಿ.
Much obliged, my lords.
Then it is electronic transfer, it won't take time. Yes.
For the petitioner.
Compensation.
Compensation, subject matter of the Milord's acquisition property, it is pending before the civil court. Milords, we have filed objections. The first respondent, Milords,
ನೀವಿದ್ದೀರಾ madam? For whom?
Caveat, but that is filed in morning, Your Lordship.
Caveat.
For the private respondents.
Caveat ಹಾಕಿದ್ದೀರಾ?
Yeah, but there was some difficulty, but it's in the filed in the office.
Mandamus directing respondent not to disperse compensation. Who are you?
Milords, we are the plaintiff, Milords, the petitioner is the plaintiff before the trial court.
ಈಗ
Milords, this property. Milords,
plaintiff
earlier-
who is the plaintiff in relation to the defendants?
Milords, the defendants, defendant number 1 is the defendant number 2 to.
What is the suit for, sir?
Suit for partition and separate possession.
When was it instituted?
Milords, instituted.
2003.
2003, mother and plaintiff. Subsequently, Milords, there was a compromise. Milords, one property has been given, though there are so many properties, Milords suppressed all the properties, including this property. Subsequently, Milords, after the compromise decree, we came to the knowledge that we are entitled for, Milords, the whatever the property that has been given.
Let them
Subsequently,
let
Milords,
them
an
file their
application has been
objections.
filed.
File your objections. Ready ಇದೆಯಾ? Copy ಕೊಡಿ.
I appear for first respondent.
Registry to print the name of Ashok Naik as appearing for respondent, first respondent. ಎಲ್ಲರಿಗೂ ನೀವಾ ಮೇಡಮ್? Whom are you appearing? 2, 3, 4, 9 and 10. Oh, I forget his name. Anatraj, yes, so and so. Registry to print the name of so and so is appearing for 2, 3, 9 and 10. Learned senior counsel Srimati Lakshmi Iyengar submits. What did you submit?
They have in fact suppressed the fact that the compromise petition had details of the entire schedule, all schedules. They have taken their money, subsequently sold those properties. Now, after exhausting everything, coming in second round of litigation.
The
and-
learned senior counsel Srimati Lakshmi Iyengar submits that objection, files her statement of objection, files the statement of objections. The same is taken on record. The learned senior counsel taking this court through the documents in the statement of objections would contend that the petitioners are in abuse of the process of the law as having taken all the amount compensation.
No.
Compromise petition.
All the amount pursuant to the compromise have now sought to bring about, have now sought to file the subject petition, stalling the compensation that is entitled to be granted to the respondents. list the matter.
Let's
ಓದ್
copy.
ನೋಡಿ ಇದು ಸ್ವಲ್ಪ.
Yes, minutes. Copy minutes, copy is not.
Copy.
finished.
ಕೊಡಿ ಅವ್ರಿಗೆ.
Your lordship,
List the
taken
matter
all the
on
amount
22nd.
instead of amount, the properties, your lordship.
Properties, all right.
Please. Obliged.
Having taken the amount from the compromise, alla, properties in terms of the compromise, yes. Next.
49.
Till then. chip minutes.
Till then,
Alla,
not
minutes,
till then.
alla, till 22 minutes, the compensation in case minutes, if the first respondent is released, again minutes it, not to release the compensation. Now the legal opinion has been minutes received by the first respondent, sitting in a minutes, the civil court exercising the jurisdiction of partition court and one.
Compromise ಆಗಿದೆ ತಾನೆ?
ಇಲ್ಲ, compromise not in respect of these properties. Only in respect of.
That we'll see, we'll
I
hear.
will
Yes.
explain minutes.
No worries, they will refund.
In case entire amount has. been
Court ಅಲ್ಲಿ
released.
ಇದೆ. Any amount of compensation, any benefit of compensation will be subject to the result of the petition.
Please.
Appeal for
Subject to the
petitioner.
result of this petition.
Shall not be any implement release, my lord.
Your lord-
They may use it, the order not against.
Subject, ಅಲೋ ಎಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? Compensation ಸಿಕ್ತು ಅಂತ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? Yes.
My lord, one submission, now it is a premature writ petition. They have not yet passed any order. There is a hearing before both the parties have
Your
heard.
lordship, let
No,
there be
already,
no
let's-
such observation, your
So
lordship.
many, so many objections we have filed, the land minutes, the first respondent has conducted minutes, the all the.
ಎಷ್ಟು compensation amount?
Minutes,
Your lordship,
more
this-
than,
there are more
nearly
than,
4 crores minutes.
ಅದಕ್ಕೆ ಇದೆ.
no, it is more than 10 people on this side. Whereas there, the mother is no more, one single lady takes two properties, sells it,
In-
makes her money, and then now again coming in
Then no
from
order,
two.
is 22nd. Yes.
Please, your lordship.
Minutes.
Your lordship, that last line,
Compens-
your lordship.
ಏನಿಲ್ಲ, nothing.
Please.
Only 22nd.
Please.
Minutes till then lordship, otherwise
no.
minutes, compensation is.
ಸಾಕ್
concerned.
ಸಾಕ್. ತಗೊಂಡಿದ್ದಲ್ಲ ಪ್ರಾಪರ್ಟೀಸ್.
No, minutes, I will explain minutes, no, absolutely minutes, no, first time that property has been acquired, earlier no properties have been acquired.
Well said,
Minutes, one
yes.
property has been given earlier. Minutes, I will explain with regard to how that property has been given to these plaintiffs and minutes subsequently whether the same property has been purchased by them. Then minutes, all the property, though they are entitled for option.
You are the sole plaintiff.
It's not, my mother was the plaintiff, mother and this plaintiff was represented as the minor as on
No,
the
no,
date
she
of
wasn't.
filing of the suit.
No,
Oh, correct, yes. Fine, fine.
Subsequently, minutes, the defendants are concerned, they are the second wife children. Now, minutes, all the properties they have retained,
First wife, second wife problem.
how the minutes?
the problem was
Then
sorted in
minutes,
the compromise.
now,
The more
minutes,
than enough was
22 year
given.
2022, this property has been acquired. Now, minutes, we have filed the application before the civil court.
Take this tomorrow or tomorrow. Yes.
Not tomorrow, minutes, I will
Nale,
verify the
if you
documents.
want an order, tomorrow. Yes.
Minutes, sir, 17th, minutes, sir.
Then no order. Yes, list on 18th. Yes.
Please,
Please.
obliged.
49.
Appeal for petitioner in this case, my lord.
Consider representation. Pradeep Kumar.
My lord, petitioners are seeking for.
ನೋಡಿದ್ದೀರಾ? Learned counsel Pradeep Kumar is directed to accept notice for the respondent 3, 4, learned HCGP 1 and 2, petitioner to serve set of papers upon the aforesaid counsel. List on 22nd.
My lord, meanwhile, I'm seeking for.
Nothing, no meanwhile. Yes, 22nd. Next.
50.
Hiram Karan.
ಕೇವಿಟ್ ಇದೆ, ನನ್ನ ಹೆಸರು ತೋರಿಸಲ್ಲ, ಕೇವಿಟ್ ನಾನು ರಿಟ್ ಹಾಕಿದ್ಮೇಲೆ ಹಾಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ,
ತೊಂದ್ರೆ ಇಲ್ಲ. Learned counsel Pradeep Kumar is directed to accept notice for the
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು.
respondent board.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿದೆ.
Oh, ಈಗ?
Yes,
Yes,
today they said that they want 1 week time, more than 1 week, my lord granted them. They have to file a statement, my lord. My lord, this
Then
is the-
event of need, liberty and ಬಂದಿಲ್ವಲ್ಲ. The learned counsel Pradeep Kumar, registry to print the name of Pradeep Kumar is appearing for the respondent board. He would seek 10 days time, 2 more weeks time to file statement of objections. 2 weeks time is granted. The order dated 1/7/2025 shall continue.
my lord,
In the event of need. ಅದೇ ಹೇಳಿದ್ದೀನಿ. Move ಮಾಡಿ. Yes.
51.
Please. My lord, seeking writ of mandamus without there being any notice and notification, my residential house has
Yes,
been.
Ajay Kumar. First time.
House on, first time.
Learned counsel Ajay Kumar seeks 2 weeks time to file statement of objections. Objections, if any, in the next 2 weeks. Interim order subsisting would continue to the next date. Next.
Interim order today, where?
Continue ಮಾಡದ್ನಲ್ಲ.
What's?
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಕೊಡ್ತೀನಿ.
Yes, next. HCGP 1, 2 and 3. Murugesh Charati is directed to accept notice. Petitioner to serve.
Sir, 51 is.
52.
1878.
52.
One which my learned friend just appeared, my lords.
51 ಆಯ್ತು.
Lords, it doesn't pertain to any residential house.
There is an interim order
As the
granted.
interim order, lords, it's a gas station. And the property which they're talking
Residential
about
house
is
ಬಗ್ಗೆ
different.
ಎಲ್ಲಿ ಬರ್ದೆ ನಾನು?
Look, they made a statement, lords, that it's a
51
residential
is
house.
confusing,
ಅಲ್ಲ,
51
no.
is Sridhar Milord is appearing.
ಶ್ರೀಧರ್ ನೀವಾ?
ಇಲ್ಲ, ಅವರು is instructed me to get date.
That's
ಅದು
a completely different
interim order
property.
already granted.
The interim order granted, lords, we are seeking for vacating of the hot.
ಎಲ್ಲಿದೆ ಹಾಕಿ application? Yes.
We taken up on 24th. minutes.
We'll take it on 24th, yes.
Please.
List on
I'll file
24th.
application.
51, 24th.
Please.
Yes. 52, Nagesh.
Yes.
Ah.
They are try to demolish my house, a portion of house without there being any notice and notification. Therefore,
Yaar, who is demolition?
BDM laws. Therefore, we have given
Yes,
representation by annexure E.
Wait. Learned Counsel Murugesh Charati is directed to accept notice. Pradeep Kumar, ನೀವು ಬಿಡಿ ಇದ್ದೀರಾ? Vasant. Counsel Vasant is directed to accept notice for K. Krishna, no Vasant? Directed to accept notice for the respondent BDA, HCGP 1 and 2. 1, 2 and 3 ಅವರು. 2 is BDA, 3 is BBMP. Counsel ಯಾರು ಮೇಡಮ್? BBMP. BBMP ಇದ್ದಾರೆ. ಇದು ಬೋರ್ಡ್ BBMP. ಅಲ್ಲ ಯಾರು? Pawan Kumar. Counsel Pawan Kumar is directed to accept notice for the third respondent. Petitioner to serve set of papers upon all the aforesaid counsel. List on 22nd.
My lords, interim order maybe.
ಏನು interim order?
Not to take coercive steps regarding.
What coercive steps?
My lords, they have demarked my.
ನಿಮ್ದೇನ್ ತೊಂದ್ರೆ ಕೊಡ್ತಾನೆ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ನನ್ನ ಮನೆ ಹಿಂಭಾಗದಕ್ಕೆ ಈಗ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಫೋಟೋಗ್ರಾಫ್ಸ್ ಮೇ ಕೈಂಡ್ಲಿ.
ಕರೆಕ್ಟ್, ನಿಮ್ ಮನೆ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಅವ್ರು ಮಾಡ್ಕೊಂತ ಇರ್ತಾರೆ, ನಿಮ್ಗೇನ್ ತೊಂದ್ರೆ ಅದು?
ಈಗ ನನ್ನ ಮನೆಯನ್ನ ಡಿಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ತಾವು ಗಮನಿಸಬಹುದು, ಅಲ್ಲಿ ಡಿಮಾರ್ಕ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ನನ್ನ ಮನೆ ಹಿಂಭಾಗ ಏನು.
No precipitative action shall be taken quay the property of the petitioner till the next date. List on 22nd in preliminary hearing. ಇದು ಬೋಪಾಯ ಕಮಿಟಿ ಕಳಿಸ್ಬಿಡದ? ನೀವ್ ಯಾರಿಗೆ
ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ
ಕೊಟ್ಟಿದ್ದೀನಿ ಬಿಡಿ.
That's the will mandamus ತಾನೆ.
Page 49.
The identical orders we have passed.
Yes, ma'am.
Same order, page 49.
Annexures B and C and D, my lord.
ಏನ್ C and D?
That is the applications. That has to be transmitted to the Bhopal committee.
ಅಷ್ಟೇ. ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರೆ ಅದ್ ಮಾಡಿ. Annexure C and D ಅಲ್ಲಿ ಏನಿದೆ annexure change ಮಾಡ್ಕೊಳ್ಳಿ. Dispose next.
Seeking direction to the respondents. Or the lands are subjected for acquisition.
No, ಇದರಲ್ಲಿ already determined compensation ಎಲ್ಲಿದೆ? Your prayer, come to your prayer.
No,
Respond communication dated 8/11/2022.
It is yet to be paid.
ಇಲ್ಲ sir, determination ಎಲ್ಲಿದೆ? Which is that page?
Please.
Yet to be paid ಅಂತ ಗೊತ್ತು.
Please.
1
At page 173 in the communication sent by the respondent number 6.
Yes, sir. Why is it not paid despite determination? The learned HCGP is directed to accept notice for respondents, all respondents?
All respondents.
Respondents 1 to 6. The learned counsel MH Prakash appearing for the petitioner submits that the concerned court has already determined the award amount in terms of its, the amount of compensation to be paid to the land losers in ಯಾವ್ದಿದು 116 ಏನದು proceeding?
ಇಲ್ಲ, it is the communication made by the
Where
respondent.
is the communication?
160 annexure D. 166, it commences from 166, wherein
The special LAO has
Once,
determined.
in terms of the communication dated 8/11/2022.
Please.
The allegation is, despite the said determination, even till date, not a rupee of compensation is paid to these petitioners. Therefore, the state shall explain as to why, despite the usage of the land of these petitioners, compensation is yet to be paid to them by the next date of hearing. List the matter on 22nd. Yes. Instructions be sought by then. Next.
If I have served copy to Vasant Milad, 38D applications, similar.
Covered, notice ಈಗ ಬಂದಿದ್ಯಾ? Same, learned registry to print the name of Vasant as learned counsel Vasant accepts notice for the BDA. Registry to print the name of so and so is appearing for the BDA. Copy ಇದೆಯಾ? ಅವ್ರಿಗೆ copy.
I already served.
22nd, yes. And preliminary hearing. General award. Disposed.
ಅದರಲ್ಲಿ
ಡೆವಲಪ್ಡ್ ಲ್ಯಾಂಡ್ ಕೇಳಿದ್ರೆ
ಪೇಜ್ 51 ಪ್ರಕಾರ ಆಗುತ್ತೆ ಸರ್. ಡೆವಲಪ್ ಈ ಸೀಕಿಂಗ್ ಪೇಜ್ 51 ಅಲ್ಲಿ
ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರು ಯಾವ 51?
ಅದು
ಅದೇ ಪೇಜ್ ದಟ್ ಇಸ್ ಜಸ್ಟ್ ದೀಕ್ಷಿತ್ ಅವರು.
ಅದರಲ್ಲಿ ಜನರಲ್ ಅವಾರ್ಡ್ ಅಂತ ಕ್ವಾಶ್ ಇಲ್ಲ ಬರ್ದಿಲ್ಲ, ಅದೊಂಚೂರು ಬರ್ದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಈ ಮಿಲಾಡ್ ವಾಂಟ್ಸ್ ಮಿಲಾಡ್ ದ ಡೆವಲಪ್ಡ್ ಲ್ಯಾಂಡ್ ಇನ್ ವ್ಯೂ ಆಫ್ ಮಾನಿಟರಿ ಕಾಂಪನ್ಸೇಷನ್.
ವಿಲ್ ಸಿ.
ಅದರಲ್ಲಿ
ಜನರಲ್ ಅವಾರ್ಡ್ ಆರ್ಡರ್ ಜೊತೆ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಇದ್ರ ಎಂಡ್ಗೆ ಅದನ್ನ ಹಾಕಿ ನಾ ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು.
ಜನರಲ್ ಅವಾರ್ಡ್ ಕ್ವಾಶ್ ಅಂತ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಜನರಲ್ ಅವಾರ್ಡ್ ಕ್ವಾಶ್ ಆಗ್ಬೇಕು. ಕರೆಕ್ಟ್. ಜಸ್ಟಿಸ್ ಇಂದ್ರೇಶ್ ಅವರೆಲ್ಲ ಕ್ವಾಶ್ ಆಗಿದೆ.
ಹೌದು
ಕರೆಕ್ಟ್. ಇದ್ಯಾಕೆ ಮತ್ತೆ
ಬರ್ದಿಲ್ಲ
ನೀವು ಅದನ್ನೇ ಮಾಡಿ. ಎಸ್, ಜಸ್ಟಿಸ್ ಇಂದ್ರೇಶ್ ಅವ್ರದ್ದು ಫಾಲೋ ಮಾಡಿ. ಅರ್ಲಿಯರ್ ಜನರಲ್ ಅವಾರ್ಡ್ ಇದೆಯಲ್ಲ ಅದು. ನೆಕ್ಸ್ಟ್.
Grateful, my lord. For the petitioner, respondent 5 to 7 are co-defendants. Notice may be dispensed with.
Memo ಕೊಡಿ.
Plaintiff is on record.
We'll take it in the afternoon. Yes.
Very well. Interim order may be extended.
We'll take it in the afternoon, sir.
Very well.
Yes. Afternoon work entry order extend.
I heard it as after, day after.
Yes.
Grateful.
ಮುಗಿಸ್ಕೊಡಿ, 4 ಇದೆ.
Kindly pass over the matter, my lord.
My lord, serial number 18 connected matter.
18 ಏನಾಗಿದೆ?
ಅದು ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ ಇನ್ನು.
My lord, ಅದರಲ್ಲಿ interim stay ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅದರಲ್ಲಿ.
Then we'll hear it. We'll come back then. Yes. 145. Yes. Which one? Oh, yes, yes. We'll give it.
My lords, a small submission, 69 serial number, could you please?
Seriously, ಅಲ್ಲೇ ಬರ್ತೀನಿ ಬಿಡಿ.
Serial number 44. Serial number 40.
ಬೆಳಗ್ಗೆ ತಾನೇ ಆಗಿದೆ.
Total 8. And ಇಬ್ಬರಿದ್ದಾರೆ ನೋಡಿ.
Serial number 33.
Yes, Prasanna.
Kind permission notes to move matter for clarification in the judgment, my lords, there was a precondition to raise a defense, my lords. And deposit was within 6 weeks, but the time period has been extended, my lords, in the judgment. So that clarification.
8 weeks ಮಾಡಿದೀನಾ?
8 weeks agide Swami, but the precondition is not specified, my lords. It only says 40% deposit, that's it. But the right to raise a defense is subject to the deposit, my lords, that is not.
No, that may run counter to so many judgments. Because you can't make payment a condition for examination or cross examination. That's why I have consciously corrected it.
It is so, my lords, but the stage was, he has placed ex parte, my lords. That's all I would like to.
No, true. I've consciously corrected that. 6 to 8 weeks, Pekar, we can do it.
Please, that's all,
But
my lords.
insofar as the defense being shut off for non-payment, then that's a little, that's on a separate application that you will have to prefer.
I quite see, my lords, only for the period, time period. Obliged.
Total 8 matters ತಗೊಂಬಿಡಿ.
Serial number 33 in quotal number 8 ಅಲ್ಲಿ
ತಗೊಂತಾ ಇದ್ದೀನಿ.
ನೆನ್ನೆ ಕೇಳ್ಬಿಟ್ಟು ನಾಳೆಗೆ ಹಾಕೊಂಡ್ರಿ 2 ಮ್ಯಾಟರ್ ಕನೆಕ್ಟ್
ಗೊತ್ತಿಲ್ಲ, ನೋಡ್ತೀನಿ. Total 8 ಲಿಸ್ಟ್ ಇದೆ. ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್, ಒಂದು ನಿಮಿಷ. Yes.
Order.
Appearing for the
appear for
respondent.
RFA. Next week ಬರ್ಲಿ. ಹಾಕೊಡಿ.
Lordship, a short date.
No short date. Next week. Yes. List next week.
Number 2.
Consideration of I8 1 of 23. This next week. 6th time. Next week. Yes.
Number 3.
Bhargav.
Appearing for petition. Minutes as per order dated 29/4/2025. Respondents had to file compliance report.
What compliance?
Regarding the subsistence allowance matters, the calculation with respect to payment of subsistence allowance.
Yes, for your order.
Milord, kindly have it on Monday, Milord. It's on the process, it's under process, Milord, as per the instruction.
No, ಇಲ್ಲೇ ಬರುತ್ತೆ ಮತ್ತೆ. Lordship is not there the whole week and next week also. So you can't escape.
By Monday, I'll place it on record, Milord.
ಏನ್ subsistence allowance ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ minutes, so calculation ಕೊಡ್ಬೇಕು.
ಕೊಟ್ಟೇ ಇಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ minutes, but it's with respect to 50% subsistence allowance ಕೊಟ್ಟಿದ್ದಾರೆ. 75% according ಕೊಡ್ಬೇಕಿತ್ತಲ್ಲ, ಅದಕ್ಕೆ ಅವರು they had to file calculation.
This court on which, what is the date of the order?
29/4/2025.
This court on 29/4/2025 had passed the following order. The direction was to file an affidavit ಏನಿದೆ? File a memo of calculation with regard to the entitlement of the petitioner qua subsistence allowance at 75%. The state has not yet complied with it. Therefore, list this matter on next Tuesday. In the event the state would not comply with it, this court would be constrained to direct payment of 75% according to the memo of calculation filed by the petitioner. Yes.
Number 4.
Post immediately after service of notice upon respondents 3 to 5 entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ.
5.
Same order.
One submission in serial number
In which
5.
matter, madam?
Serial number 5. Your
Yes.
Lordship. Your Lordship, there is some urgency in this matter.
What urgency?
Your Lordship, the payments have been already deducted as far as the petitioner is concerned from the monthly salary. Your Lordship, 19,000 something is deducted from
On
the
what
monthly
ground?
salary. Your Lordship, the respondent number 2 has passed an order contrary to the earlier order passed by himself on the same subject matter, Your Lordship.
What is the recovery from pension or what?
Your Lordship, from the salary, Your Lordship, from the salary of
Why?
the petitioner. There
Why?
was an allegation that there's a dereliction of duty as far as payment of
Inquiry
salary.
was conducted.
Your Lordship, departmental inquiry was
Loss is
conducted.
determined.
Loss determined in the sense, Your Lordship, but Annexure D, the
Madam,
respondent.
is the recovery being effected pursuant to the order of penalty?
Yes, Your Lordship.
Then you can't, only subject.
Your Lordship, one submission, the penalty was proposed by respondent number 2, subject to outcome of the criminal proceedings. Contrary
What has
to
happened to the criminal proceedings?
It's still pending, Your Lordship.
Where is the order?
Your Lordship, the order
Page.
at 42, Your Lordship.
Where is the order of penalty, madam?
Your Lordship, I kindly come to page number 42, Annexure D.
Yes, I am there.
Your Lordship, the para number 15.
ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಅಂತ್ಯ ತೀರ್ಪು ನೀಡಿರುವ ನಿರ್ದೇಶನವನ್ನು ಒಳಪಟ್ಟು
Your Lordship, may come to
No, your 5 increments are cut
Yes, your lordship, subject to
with
outcome of the-
cumulative effect.
Yes.
Cumulative effect. ಮುಂದುವರೆದು ನೀವು ಹಾಗೂ you are what? Nagesh SG.
Subject to outcome of
So
the criminal
ಈಗಾಗಲೇ
proceedings.
Where is the order of recovery here?
Page
Your
number-
lordship-
Page number
Yes, sir.
51. Page number 51 is a review order, my lord.
What review order?
There is no contrariness between order dated 16/9/2020, 2001 and
Who appears for Kaveri Niravari Nigam? No, notice not order.
no, not notice not order.
Your lordship, one submission. At annexure K, the respondent number 2 himself passes an order contrary to the order dated 16/9/2020, wherein the respondent number 2 orders that a loss of rupees 48 lakhs will be recovered from the petitioner from the salary of the petitioner.
That's what I'm
50%.
asking. Did they hold an inquiry against you?
Yes.
Where is the report of the inquiry?
Your
Because
lordship,
in
the
page
proceed-
42, there is no finding against you. It is only subject to the outcome of the criminal proceedings.
Yes, your lordship.
Correct.
Thereafter, at annexure.
Yes, Bojawala.
My lord,
Again,
annexure
respondent
K
number
is,
2
annexure D is the penalty order, my lord.
Annexure D is the penalty order of reduction of withholding of 5 increments with cumulative effect.
Yes, no, annexure
Correct.
K. Yes, yes. Annexure K is the recovery order, my lord.
Separate order.
Separate order, my lord. Annexure K, page number 51, my lord.
Recovery now against whom?
Against the petitioner, my lord.
Then when the penalty itself is imposed subject to the outcome of the criminal proceedings, where is the question of recovery now?
My lord, it is the.
From out of the salary?
My lord, the amount is more than 48 lakhs, my lord. There is a misappropriation.
Where is the finding of misappropriation?
It is proved in the criminal case, my lord.
Proved in a civil case.
Criminal case.
Sir, that is still pending.
Still pending.
Let's tomorrow and preliminary hearing.
Please.
Nodkom bani. Okay. Yes, in there I'm going to stay tomorrow.
Please.
Yes.
So blessed.
Next.
Next.
And you make detailed notes and yav page alli enide anta banni. Yes. Non-compliance of office objections. ಏನ್ ಟ್ರಾನ್ಸ್ಫರ್
Waiting for respondent, bro.
ಕೇವೇಟ್ ಇದ್ದಾಗಲೇ ಗೊತ್ತಾಯ್ತು ಸರ್ವಿಸ್ ಮೆಟಲ್ ಕೇವೇಟ್ ಅಂದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, court has initially I was there for about one and a half years. I have been removed from that place, premature transfer. But
when did you join, sir?
Join 23.
ಅಂದ್ರೆ ಯಾವ 23?
2000.
Date, month, time?
1/8/23.
1/8/2023.
Yes. And 21/6/25 I have been removed.
21/6/25.
And then that order has been cancelled.
ಆಮೇಲೆ
they in turn moved the honorable court and got a stay of that order.
Which
So the
order? Cancellation order.
Cancellation order. So the
Withdrawal
transfer order.
withdrawal
revived.
of transfer, my lord. Withdrawal of transfer after 4 days.
Withdrawal of transfer.
Please,
Now
on the ground
21/6/25 you were posted there.
Please, my lord.
That was withdrawn.
It was withdrawn on 25/6.
25/6.
25/6.
So that is
stayed.
That is stayed. So he continues to work in your place.
He continues to work in my place. Therefore, Lord, it may be.
ಯಾವ cadre ನಿಮ್ದು?
I'm not.
Which cadre are you in?
ಇದು BWSSP.
Assistant executive engineer.
Executive engineer. 2 ವರ್ಷ. Yes.
ಇಲ್ಲ, assistant executive. 3 years.
Assistant engineer 3 years.
Assistant executive.
In group C na ನೀವು?
Group C.
No. No, no, no.
ಅವ್ರದೇ ರೂಲ್ಸ್ ಪ್ರಕಾರ 3 years. BWSSB ರೂಲ್ಸ್ ಪ್ರಕಾರ
3 years ಇದೆಯಾ?
3 years.
ಯಾವಾಗಿಂದ ರೂಲ್ಸ್ ಅದು? You have separate rules or you have adopted the guidelines of the government?
15/6/17 separate rules ಇದೆ, ಅದು ಇಲ್ಲ.
Separate rules is there.
Rules ಪ್ರಕಾರ ಏನು?
3 years, my lord.
3 years.
Then
premature.
My lord, withdrawal of
you are the beneficiary of an illegal order.
Yes. And their ground is, my lord, in 4 days, I have been transferred. In 4 days, it has been
after
cancelled.
implementation of the transfer order, my lord, it has been withdrawn. That is challenge, my lord.
ಈ withdrawal
Lordship may
stay
call
ಆಗಿದೆಯಾ?
both the matter together, my lord.
ಈಗ withdrawal stay ಆಗಿದೆಯಾ?
Please, my lord, withdrawal.
Which is that number ಕೊಡಿ?
WP 18588.
Vivek sir will take both together.
Yes.
Please, my lord.
List the matter on Friday. Along with heard the learned senior counsel Vivek Reddy appearing for the petition.
May request for Thursday, my lord.
No, sir, Friday. List the matter on Friday and preliminary hearing along with ನಂಬರ್ ಬರ್ಕೊಡಿ.
18588
ಅವತ್ತು ನೋಡೋಣ.
of 25.
But prima facie you are the beneficiary of an illegal order.
Page 22 is that 3 years. No, it says 3 years.
Yes.
Their case
Try
is
to convince.
personal.
I'll try to convince. Lord.
ವಾಪಸ್ ಹೋಗಿ ಅಷ್ಟೇ.
I'll try to convince.
All right. Yes. Friday, madam.
7.
Mandamus.
Consider
Yes.
presentation.
Ojegodre.
No, this is the regularization case, no, I'll take notice and instructions. No. For 1 to.
Learned
1 to 4.
HCGP, AGA, sorry. Learned AGA is directed to accept notice for
1 to 4. No.
respondents 1 to 4. 5 ಯಾರು? KPSC. KPSC ಯಾಕೆ?
ಇದು ಬಂದಿದೆ ಸುಮ್ಮನೆ.
KPSC ಹಾಕ್ಬೇಕು. Notice need not be issued to the fifth respondent for the present. They learned AGA to secure instructions and make his submissions. Mandamus ಅಷ್ಟೇ. Next Thursday.
Next Thursday.
24th.
24.
24th. List on 24th. Madam.
That's petition. Petitioners are seeking retirement benefits of a deceased employee of Mysore City Corporation, my lords.
Deceased employee.
Yes.
ನೀವು ಯಾರು?
ನಾವು ಅವರ ಮಕ್ಕಳು.
ಮಕ್ಕಳು?
1, 2, 3 and.
Ikkalingaya dies, is it?
Yes, my lords.
Why retirement benefits are not paid? Why?
On the count that he is a daily wage employee, but similarly placed, they have been regularized. Therefore, I am asking.
He did he die pending consideration of regularization?
Yes, my lords.
Where is the recommendation?
My lords, he was agitating his claim before this.
He may be agitating, sir. Is there any recommendation?
There is.
At the time of his death?
There is a recommendation, my lords, wide annexure. J. Page 147. And he was put into.
First time ಬರ್ತಾ ಇರೋದಾ?
First time. First time.
Learned AGA. State ಯಾರು ಶರತ್?
State, my lords, 1, 2, 3 and 5 state.
1, 2, 3, 5 state.
4, my lords, Geeta Devi Papanna, my lords.
Learned counsel Srimati Geeta Devi Papanna is directed to accept notice for the fourth respondent. Less than 2 weeks?
2 weeks.
Less the matter of 2 weeks. Objections, if any, by then. Next. Petitioner to serve set of papers on Geeta Devi Papanna.
In fact, covered, my lord. Similarly placed employees, this court has already directed and they have dispersed also.
Close. Yes.
9.
Selection to the post of Malad, assistant professor in Malad, in the fifth respondent aided institution. Malad, I am PhD in Malad agricultural economics. Malad, no Malad, my selection, which has been made by the selection committee, has been Malad turned down on the Malad letter of the Malad honorable minister. Malad, on the ground that agricultural economics is not equivalent to economics.
2 dates. When was your selection? When is the recommendation of the minister?
Malad, 8/3/10/2022 is my selection, my lord. And minister's now tippani is 15/3/2025, annexure AB.
3 years ಏನಾಯ್ತು?
3 years, my lord, I was running around between, my lord, to the various authorities, including the principal secretary.
You did not run around in Vidhan Soda?
And refer to, my lord, refer to the.
No, you did not run around in Vidhan Soda.
Refer to, my lord, refer to the, my lord, principal secretary and refer to the council. Council stated it's the equivalent to, my lord, the agriculture economics is equal to economics. 2H notification ಆಗೋಗಿದೆ.
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
ಈಗ next ಕೊಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
That is endorsement, my lord. They asked to operate the additional list annexure A.
Page,
my lord. Typed page at page 36, my lord. And annexure B.
ಈಗ agricultural economics is not the discipline ಅಂತ ಹೇಳಿದ್ರಲ್ಲ?
It is equivalent as declared under 2H of the general equipment in subject of the government order dated, my lord, 18/11/2021.
Page,
my lord. Page annexure T, page 70. Page 71, serial number 7, my lord.
70
annexure T, my lord. Relevant at page 71, serial number 7. It is under the notification under 2H of the general recruitment rules.
Agricultural economics. Yes, Pujol.
Yeah, I'll take notice. See, that is reconciliation.
The petitioner is qualified in the discipline of agriculture economics, participates in the selection process for appointment to the post of assistant professor in a notification issued by yaudidu
Fifth respondent,
fifth respondent, the National Education Society na
it's a society, it's an aided institution.
fifth respondent institution ಮಾಡಬೇಕು ತಾನೆ party.
ಮಾಡಿದೀನಿ, I fifth respondent.
Fifth respondent society ಏನು ಮಾಡಿದಿರಾ? Yes, in the institution run by the fifth respondent. The selection of the petitioner comes about on 3/8/2022. This is stonewalled allegedly by the recommendation of a minister who opines that agriculture economics is not equivalent to economics for the post that is notified. The learned counsel Raghavendra Gayatri takes this quote through the documents appended to the petition to demonstrate that a notification is issued by the state under section 2 within bracket H of the Karnataka Civil Service General Recruitment rules that holding that agriculture economics is a post that is equivalent, that which can be considered for appointment of assistant professor in the discipline of
economics.
In the discipline of economics. In that light, the selection of the petitioner could not have been trampled down for the last 3 years. The learned counsel further submits that the efforts are now being made to operate the waiting list to render the selection to the candidate in the waiting list. In that light, the said waiting list shall not be operated without the leave of the court. The AGA 1, 2, 3, 4 emergent notice to the fifth respondent returnable by the 30th.
Much
obliged. Yes. ಅಷ್ಟೇ ಬಿ ಗ್ರೂಪ್ ಕರಿಬೇಡಿ, ಎಲ್ಲ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಬಿ ಗ್ರೂಪ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕಿರ್ತೀನಿ ಮೇಡಮ್. ಆಲ್ ಅದರ್ ಮ್ಯಾಟರ್ಸ್
ಬಿ ಗ್ರೂಪ್
ಬಿ ಗ್ರೂಪ್ ಯಾವುದು ಇಲ್ಲ, ಎಲ್ಲ ಆ ಕೋರ್ಟ್.
It has to be listed in interim application list.
ಯಾವ interim application?
ಅದು it is covered by judgment 27. I have mentioned, let it come in.
ಇಲ್ಲ, Monday you mentioned before the regular court.
21 this is the case.
Interim orders will continue wherever.
21 this is the case of subsistence allowances. 21
What?
similar subsistence payment of subsistence allowance
ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಕನೆಕ್ಟ್ ಬೇರೆ ಕೇಸ್ ಮಂಗಳವಾರಕ್ಕೆ ಹಾಕೊಂಡಿರ್ತಾವ. ಇದನ್ನು ಒಂದು
ಯಾವ್ದದು?
ಸೀರಿಯಲ್ ನಂಬರ್ 21, ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಲ್ಲಿ this is also
ಬೇಡ, ಅದು ಮೂವ್ ಮಾಡಿ ಬೇಕಾದ್ರೆ we'll see.
27 ಈಗಿದೆ ಸುಮ್ಮನೆ, ನಂದು 21 ಸೀರಿಯಲ್ ನಂಬರ್ 21 may be mentioned as 27. let it come on Monday.
It will come, I'll mention ಮಾಡಿ.
Serial number
Monday
33,
21 serial number because payment of subsistence allowance.
Try to understand, this is not my court list.
serial number 33.
ಸಾಹೇಬ್ರು ಇಲ್ಲ ಅಂತಂದ್ರೆ ಮಂಡೇ ಮೂವ್ ಮಾಡಿ ಅದ್ರ ಜೊತೆ ತಗೋ.
ಆಮೇಲೆ serial number 33 yesterday connected ಆಗಿ ನಾಳೆಗೆ ಹಾಕ್ಬೇಕು.
ಯಾವ್ದದು?
serial number 33 yesterday matter 20693 of 24
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್. ಅದು ನಾಳೆಗೆ ಹಾಕಿದ್ದೆ ಮೇಡಮ್.
in the fresh matters list madam.
ಇದು 33 ನ ನಿನ್ನೆ
33
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹಾಕಿದ್ದೆ, ಅದನ್ನ ನಾಳೆಗೆ ಹಾಕಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗೆ. ಇದು ಯಾವ್ದ್ರ ಜೊತೆಗೆ?
20693 of 24 please.
ಇದು ನಾಳೆ serial number 33 ಮಾತ್ರ ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್.
Your Lordship, serial number 7.
Order may be extended in this.
Interim orders will be extended.
Your Lordship, serial number 17 and 20, Your Lordship. Kindly 24th, Your Lordship.
ಡೇಟ್ ಅಲ್ಲಿ ಕೇಳ್ಕೊಡಿ.
24 ಅಲ್ಲ ಇದರಲ್ಲಿ
ಎಲ್ಲ ಯಾಕೆ ಸಬ್ಸ್ಟೆನ್ಸ್ ಅಲೈನ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ? ವೈ ಇಸ್ ದ ಸ್ಟೇಟ್ ಬಿಹೇವಿಂಗ್ ಲೈಕ್ ದಿಸ್? ಯಾಕೆ ಸಬ್ಸ್ಟೆನ್ಸ್ ಅಲೈನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಸಸ್ಪೆನ್ಷನ್ ಅಂತ? PC error, please wait. First of all, you are appearing from your office. Yes. ಮಠ ಯಾವ ಮಠ? ಮಂಡ್ಯದ
ಸಿದ್ಧಗಂಗಾ ಮಠ
ಏಡೆಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಒಂದ್ ನಿಮಿಷ, ಗವರ್ಮೆಂಟ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದೆ ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಕ್ ಮುಂಚೆ?
ಅವ್ರು ತಗೊಂಡಿದ್ರು
ತಗೊಂಡಿದಾರಾ ಇಲ್ವಾ?
ತಗೊಂಡಿದ್ರು. ಗೌರ್ಮೆಂಟ್ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ 9 months ಆದ್ಮೇಲೆ ನೀವು ಕೊಡ್ಬೇಕು, ಇಲ್ಲದೆ ಕೆಲ್ಸಕ್ಕೆ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಕೆಲ್ಸಕ್ಕೆ ತಗೊಳ್ತಾ ಇಲ್ಲ. ಸಬ್ಸಿಡೆನ್ಸ್ ಕೊಡಿ ಅಂತಂದ್ರೆ ಮಠದವರು ಸರ್ಕಾರದ ಮೇಲೆ ಹೇಳ್ತಾರೆ, ಅದು ಎಜುಕೇಶನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಗ್ರಾಂಟ್ ಸ್ಟಾಪ್ ಮಾಡಿ ಫಸ್ಟ್, ವಾಪಸ್ ತಗೊಂತಾರೆ.
ಕರೆಕ್ಟ್.
ಕೊಡ್ತಾ ಇರೋ ಗ್ರಾಂಟ್ ನ 1-2 ತಿಂಗಳು ಡಿಲೇ ಮಾಡಿ ಎಲ್ಲ ಕೊಡ್ತಾರೆ, ಅವರೇ ಮಾಡ್ತಾರೆ. ಇಲ್ಲಾರೆ ನೀವು ಕೊಡಿ. You can't have the luxury of placing the employee under suspension and not paying subsistence allowance. Who is not taking them back to duty?
ಅವರೇ ತಗೋಬೇಕು. ಬಟ್ ಅವ್ರು ತಗೋಬೇಕು.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಟೇಕ್.
ನಾನು ಕೇಳೋ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಟ್ರೆ ಸರಿ. ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಆಗಿದೆಯಾ?
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಲೇ ಇಲ್ಲ.
9 ತಿಂಗಳಿಂದ ಸುಮ್ಮನೆ ಇಟ್ಟಿದಾರಾ?
ಸುಮ್ಮನೆ ಇದ್ದಾರೆ. ಒಂದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇತ್ತು ಅಂತ ಅದು ಸ್ಟೇ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಅವ್ರು ತಗೋ ಮ್ಯಾನೇಜ್ಮೆಂಟ್.
1 minute.
Yes.
ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ were you in custody for 48 hours?
48 hours.
ಏನು ಮಾಡ್ಬೇಡಿ, ಆರಾಮ.
ಆಫೀಸಿನಲ್ಲೇ ನಾವು ಸಸ್ಪೆಂಡ್
ನೀವು ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕಾಗಿಲ್ಲ, ಏನು ಮಾಡಬೇಕಾಗಿಲ್ಲ. 48 hours if you are under in custody, you are deemed to be suspended, no order need be passed. Yes.
What I am my submission is only your ask. When that being the case your ask. Criminal proceedings have been said by this honorable court. Why I am submitting? ಕೊಡ್ಲಿ ಅಂತ ನನಗೆ
ಸಬ್ಸ್ಟೆನ್ಸ್ ಅಲೈನ್ಸ್ ಕೊಡ್ಬೇಕು, ಅದು ಬೇರೆ.
ನಾನು ಕೇಳ್ತಾರೆ, ಬೇರೆ ಏನೂ ಇಲ್ಲ.
We'll see. Yes. ಬರ್ಲಿ ಆ ಕೋರ್ಟಲ್ಲೇ ಕೇಳಿ. ರೆಗ್ಯುಲರ್ ಸರ್ವಿಸ್ ಆದ್ರೆ ತಗೊಂತೀನಿ. ನಮ್ಗೆ ಒಂದ್ ಕಡೆ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್, ಒಂದ್ ಕಡೆ CPC, ಒಂದ್ ಕಡೆ CRP, ಒಂದ್ ಕಡೆ ಸರ್ವಿಸ್. ಯಾರು ಕೊಟ್ಟಿಲ್ಲ? ಯಾರು ಕೊಟ್ಟಿಲ್ಲ? ಹೂ ಹ್ಯಾಸ್ ಟು ಗಿವ್? ನಿಮ್ದು ಎರಡು ಒಂದೇನಾ?
ಅವರೇ ಕೊಡ್ಬೇಕು. ನಾನು ನೋಡ್ತೀನಿ.
ಎಸ್ ಅಹಮದ್ ಸರ್,
ಕೇಳ್ತೀನಿ.
ಸಬ್ಸಿಡೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ ಕೇಳ್ಕೊತೀವಿ.
ಕಾಸ್ಟ್, ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಕೇಳ್ಕೊಂಡ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ಯು ಕಾಂಟ್ ಹ್ಯಾವ್ ದಿ ಲಕ್ಸುರಿ ಆಫ್ ಪ್ಲೇಸಿಂಗ್ ಸಮನ್ ಅಂಡರ್ ಸಸ್ಪೆನ್ಷನ್. ಇಲ್ಲಿ ಲಕ್ಸುರಿ ಅಲ್ಲ, ಯು ಹ್ಯಾವ್ ಇನ್ಕರ್ಡ್ ಸಸ್ಪೆನ್ಷನ್. ವಿಲ್ ಸಿ. ಎಸ್, ಡೇಟ್ ಇಲ್ಲ, ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ, ಆ ಕೋರ್ಟ್ ಮೂವ್ ಮಾಡಿ. ಎಸ್,
24 ಮೇಲೆ 10 days ಟೈಮ್
ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಗ್ತದೆ, ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಲ್ಲೇ ಕೇಳ್ಕೊಳ್ಳಿ. ಎಸ್, ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಎಲ್ಲೆಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
24 my lord pertains to my lord that compassionate appointment.
24
second list ಅಲ್ಲಿ ಅದರಲ್ಲಿ we both have been directed to not file a memo. The dispute between my lord the son of the first wife and the second wife in the so far as compassionate appointment. We say that Lord, we ready to not give up not all the monetary benefits in so far as my son is concerned. We want to take up my lord that my lord the compassion appointment. So therefore my lord we have been directed to file a memo so that it can be closed.
Joint memo ಹಾಕಿದಿರಾ ಈಗ?
ಅಲ್ಲ ಹಾಕ್ಲಿಲ್ಲ.
We are having discussions madam. Some
discussion.
ಅದಕ್ಕೊಂದು ಡೇಟ್ ಅಲ್ಲ, ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಪಾರ್ಟಿ ಹ್ಯಾಸ್ ಟು ಕಮ್. ದಟ್ಸ್
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 25th ಆಗ್ಬೋದು. ಎಸ್, ಲಿಸ್ಟ್ ಆನ್ 25th. ಅದು ಒಂದು ಮಾತ್ರ 25th ಮೇಡಮ್ ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕ್ತಾರೆ ಅಂತ ಹೇಳಿ.
entry matter to
ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಎಂಟ್ರಿ ಮಾಡಿ. ಎಸ್, ಕಮ್ ಟು ದಿ ಧಾರವಾಡ ಲಿಸ್ಟ್ ಹೋಗಿ.
My lord, serial number 31. I'm appearing serial number 31.
14%?
Yes, I'm appearing. So kindly fix a date.
PCL ಸುಮ್ಮನೆ ಇರ್ತೀರಾ? Yes.
Kindly fix a date, my lord.
ಯಾವುದು ಮೇಡಮ್?
Serial number 31. My lord, and serial number 31 I have.
ಮತ್ತೆ ಮ್ಯೂಟ್ ಮಾಡಿ ಅವರು.
I have to travel from Mysore, so.
No, that's all right. What is the matter, madam?
It's a service matter, my lord.
That I know. What is the matter?
I mean, there was an interim order by the honorable court. I appeal for the respondent in this
Mysore
matter.
University.
Please, ma'am.
The problem?
The problem is the university was orally asking me to restrain from coming to work on the pretext of a strike conducted by some students. And when I approached the court, the honorable court has granted interim relief to continue the services.
So
despite there being a stay.
service?
No, my lord. Despite there being a stay, they haven't paid me salary. And they claim that I have not come to
Since
college.
how many months salary is not?
3 months.
My lord, the matter becomes infructuous simply because first of all, my lord, the academic year ends on 30th June, which
Yes,
we will.
lecturer.
Please.
Yes.
Now, the question of.
June is a different thing, but salary?
My lord, we've placed evidence on material on record to show that first of all, my lord, there was no notice or any order from the university for the petitioner not to come and teach. She's the guest lecturer, so the petitioner is supposed to be present in college 12 hours.
That's all right. Now, when the court has stayed it.
No, now the interim order is vacated on because the academic.
Vacated?
Yes, it's.
Vacated, is it?
My lord, order was vacated on the 2nd of this month.
It's vacated. All right.
But
fine.
from April 17th to.
At the time of final hearing, when do you want?
My lord, anytime this week.
My
next
lord,
week.
we only.
Sakla?
Sir,
No, my lord, your lordships may dispose of the
Yes,
matter
ma'am.
with the direction that let an appropriate representation be placed before the registrar. Now, the representation was never placed before the registrar at all. With these grievances, my lord, how can the court now look into, my lord, evidence with respect
Court will
to?
look into. Don't-
my lord,
My lord-
there has been representations. It is annexure
25th.
HG.
25th Hakla?
Yes, yes. Yes,
List
my
on
lord.
25th.
Thank you so much, my lord.
Yes. But you, whatever you said, you
Please, my
file
lord.
it.
We've already placed it on record.
Already
my lord.
placed, is it? Yes.
Please.
Anyway, I have not taken the matter, I have not seen it.
Please, my lord.
Like 25th.
Yes, my lord. Yes, my lord.
14% and the 25th date ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ.
Yes, my lord. Thank you so much, my lord.
Matters pertaining to Dharwad bench. Still number 1.
Appearing for the petition. CBI has to reply. Matter pertaining to MSK.
ಎಲ್ಲಿ CBI?
That 19650. So we file an objection
ಯಾವ್ದ್ರಲ್ಲಿ ಮೇಡಮ್?
MS.
representing CBI. I file my
No,
memo.
this is Rahul had to reply, it's already over. Argument conclude ಆಗ್ತಾ ಇದೆ. ಧಾರವಾಡ bench.
Dharwad.
You appear for the CBI, is it?
Yes.
Oh, in the other matter where I have directed, that is not taken up. Wait, yes. Pass over. Yes, Girish. ಅವರನ್ನ ಬೆಳಗ್ಗೆಯಿಂದ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಇವತ್ತೊಂದು
Still number 2.
Shudha sir is there? In which matter?
In 2.1, I'm in 2 and 2.2, my lord.
Oh, yes. Yes, Girish. Is not that ಬೆಳಗ್ಗೆನೆ he made a mention that ASG wanted to appear ಅಂತ. So we'll take it on Friday. Objections ನೋಡಿದ್ದೀರಾ? We'll take it on Friday. At the request of the learned counsel Girish Ulmani, who seeks adjournment on the score that the learned ASG would appear in the matter, list the matter on Friday as a last chance. It's made clear no further adjournment on the aforesaid ground would be granted. Interim order subsisting would continue till the next date of hearing. Same 2:30.
Number 3.
Serial number 3, my lord, I appear for the petitioner, my lord.
3.
My lord, the impugned order has already been set aside, my lord, insofar as the other candidate, my lord.
Why is it before me?
Lord, it's a Dharwad bench matter, my lord, service matter.
Service matter.
ಹೌದು ಹೌದು.
ಅಲ್ಲೇ ಬರ್ಲಿ ಬಿಡಿ.
My lord. No, my lord, it's a judicial officer's matter.
It's an high court matter, my lord. It's because this is an high court matter, special roster is there. Quotal 8, it will come, my lord. Now it is listed before your lordship.
So,
The impugned order, my lord, at
let
page
it come on,
51.
list on 25th before the appropriate bench. Yes.
Lord, already, my lord, it has been set aside insofar as the other
All right, ಅಲ್ಲೇ ಕೇಳಿ ಸರ್.
Covered by.
ಅಲ್ಲಿಗೆ ಬರ್ಬೇಕು. Covered against you.
Yes.
Covered against you ಅಂದ್ರೆ ಹೇಳಿ, be fair. You are
ನನ್ನ
always
against
fair.
ಇದೆ.
Yes. ನಿಮ್ಮ against
Yes.
Close ಮಾಡಾಗಾರೆ.
Discharge, my lord, discharge of the petitioner. Rule 6(1), my lord, requires it should be given effect only after the, my lord, submitted to the higher authority and take permission.
ಹೌದು.
It has not been taken. I have last occasions in the other case I have stated, may be set aside, liberty may be granted to pass appropriate orders in accordance.
Like ಹೇಳಿ. Yes. List
Lord,
before post before.
number 10395.
Now come back to our list. Madam, ಇದು 25th list on 25th. ಅಲ್ಲೇ.
Next one continue. 57.
File my objections for short accommodation.
ಹಾ.
File my objections short accommodation worship.
Objections ಹಾಕ್ಬೇಕಾ?
ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
Insofar as 5 to 9 are concerned, I filed a memo for dispensation.
Learned counsel for
Co-defendants.
already dispensed?
ಇಲ್ಲ, ಇವತ್ತು ಫೈಲ್ ಮಾಡಿ.
Learned counsel for the petitioner files a memo seeking dispensation of issuance of notice to respondents 5 to 9. The memo is taken on record at the risk of the petitioner. They stand issuance of notice stands dispensed with. Yes, sir.
Please.
What is the challenge?
Malad, this is a defendant's writ, Malad. It's an order closing the stage for further evidence only on the ground that the witness who was summoned to give.
This, yes.
Please.
Yes, sir. Witness ಕರೆಸಬೇಕು ಬರಕ್ಕಾಗಲಿಲ್ಲ ನಮ್ಗೆ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
Lordship, his witness, your lordship, is the will. I'll have to next.
No, no, that witness whom he wants to summon is a signatory as a witness to the will.
Will, yes.
He has to prove the will. If he has to prove the will, he has to come as witness. If he is not coming in court close, ಬರ್ತಾ ಇಲ್ಲ ಏನ್ ಮಾಡೋಣ? ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
Warrant has been issued.
ಅದನ್ನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಸ್ಬೇಕಾಗಿತ್ತು.
It comes back as door closed. If it is issued by hand, I will take assistance of the jurisdictional
As simple
police.
as that.
Next week.
Why next week?
Get some instructions.
ಇದ್ರಲ್ಲಿ ಏನಿದೆ? We'll close it. Yes, sir.
What observes your lordship? Earlier also warrant has been issued that they also, then also it was not executed. It's second time you are doing so.
Yes, kindly see page 21.
I am there only.
On top, my lords, the court notes. Witness warrant not
executed.
Hence further, on the next day I filed recall application. That recall application is also dismissed.
Yes, Harish Bandara, will close it. ಏನಿದೆ? ನಿಮಗೇನು ತೊಂದರೆ ಆಗುತ್ತೆ? Yes, the petitioner is defendant number 2. Is at the doors of this court calling in question an order dated 26/6/2025 passed in OS 419 of 2008, whereby the warrant that is issued to summon witness who was a signatory to a particular will comes to be declined and the evidence is observed as stood closed. Facts in brief heard so and so. A suit is instituted for partition in OS 419 of 2008 against the petitioner and another late Srimati Manikyamma. The petitioner is the second defendant, enters the witness box and exhibits a registered will dated 24/12/2007. The will is permitted to be marked as Exhibit D1, subject to obviously subject to its proof. In order to prove the registered will, the petitioner files an application for issuance of summons to the witness of the will 1D Kumar, to the attesting witness of the will 1D Kumar. The court allows the application and issues summons to the said witness D Kumar. Later, the concerned court records that the witness summons is served upon D Kumar but remains absent. Issues a warrant. The warrant is not executed. The court ought to have reissued the warrant to be executed by the jurisdictional police. That does not happen. But what comes about is the closure of the evidence of the petitioner on the said will. The petitioner then immediately files an application seeking recall of the order and reopen the case from the stage for further evidence on another application to issue arrest warrant against the witness D Kumar. The concerned court rejects the said application as well. It is therefore the petitioner is before this court in the subject petition. The order that drives him to this court reads as follows, page 21 and 22. The concerned court notices that the warrant is not executed. Therefore, further evidence on behalf of the petitioner is taken as closed. The order shocks. This is the order that shocks the court. If the warrant is not executed, a further warrant ought to have been reissued for it to be executed through the assistance of the jurisdictional police. As the witness, after receipt of summons, could not have abstained from appearance before the court, as he is the attesting witness to the will that is now put forth as evidence by the petitioner. Registered will put forth by the petitioner. In that light, the order dated so and so is on the face of it contrary to law and is to be obliterated. For the aforesaid reasons, the following order: the petition is allowed, so and so stands quashed. The application so filed by the petitioner to seeking recall hakidra.
Recall of stage as well as reissue of warrant.
The application filed by the petitioner for reissuance of a warrant is allowed. The warrant, if not executed, the assistance of the jurisdictional police shall be taken to execute the said warrant. Further proceedings be regulated by the concerned court after the witness appears as evidence. Ordered accordingly.
Execution proceedings of
Lapsed,
2003, lapsed, no award.
Lordship, in
No
this
award has been
matter,
passed.
ನೀವು ಯಾರು sir?
I'm for the state, Lordship.
First time ಬರ್ತಾ ಇರೋದಲ್ಲ?
First time.
You are for the state special counsel. Yes. ನಿಮ್ಮ ಹೆಸರು ಮರ್ತೋಯ್ತು.
Ravindra V. Reddy.
ರವೀಂದ್ರ ರೆಡ್ಡಿ. All right. Learned special counsel ರವೀಂದ್ರ ರೆಡ್ಡಿ. ಇದು ನೈಸ್ ಆ?
Please.
ಇಲ್ಲ, nice ಅಲ್ಲ.
ಮತ್ತೆ?
I am not
Nice ಅಲ್ಲ,
in a
nice
state,
ಅಲ್ಲ.
for the state, Your Lordship.
For the state
They have
only.
acquired for the state.
These cases.
Please.
ಓ ಇದು ಗೊತ್ತಿಲ್ಲ. ಬರೀ ನೈಸ್ ಅಂದ್ರಿ ಮತ್ತೆ ಬೆಳಗ್ಗೆ.
No, my lord, that is nice, nice is fourth response.
Anyway, not so nice. The learned counsel Ravindra Reddy, special counsel Ravindra Reddy accepts notice for the respondent. ಯಾರಿಗೆ? ಎಲ್ಲರಿಗೆ?
State, only state.
One KIDB.
I am appearing for KIDB. Sharan Sabrat.
Counsel Sharan Sabrat accepts notice for respondent 2 and 3. Nice ಇದನ್ನು. Respondent is nice. ಅವ್ರಿಗೆ ಯಾರು?
Nice ಇದೆ.
Nice, Nitin.
Yes,
Nitin.
nice is there.
Nitin.
Prasad. Counsel Nitin Prasad is directed to accept notice for the fourth respondent.
Yes, Lord. Status quo.
ಯಾವ ಕೋ?
For possession.
ಯಾಕೆ?
Award ಮಾಡಿಲ್ಲ.
Possession ಇದ್ದೀರಾ?
ಇದೀವಿ. RTC ಇದೆ.
Lordship, as per our, this one, land has been utilized for the, some purpose, nice purpose.
Nice purpose.
ಅಲ್ಲ,
Nice in
award
the
ಮಾಡಿಲ್ಲ.
some ramp or something they would have utilized it.
Land is not utilized at all. They want to.
What ramp?
If it is not utilized already, Your Lordship knows that all the notifications have been passed in other matters.
Correct. Status quo not regarding position because no award is passed.
Learned senior counsel Vivek Reddy appearing for the petitioner would submit that despite passage of 22 years, no award is passed nor compensation is paid to these landowners. He would submit that the acquisition is said to be lapsed on the ground that the award is not passed. He would further submit that the petitioners are in possession of the property. The respondent should not now try to dispossess the petitioners. The petitioners, if they are in possession of the property as on today, the same shall not be disturbed till the next date of hearing. Yes.
Obliged.
List on 31st.
Please.
Objections, if any, by then. Next.
59.
For the petitioner, Your Lordship. Your Lordship, the prayer is to set aside the order at Annexure A, Your Lordship. The prayer is to set aside the order at Annexure A, Your Lordship. So the respondent BDA had rejected my change of land use application, citing the 109 permission order given to my vendor in 2003, Your Lordship. And this impugned order has been given subsequent to the amendment under 2020, Your Lordship.
I will issue notice.
Your Lordship.
You sought for consideration of your
Application is also sought for, Your Lordship.
direct application.
Application and quashing
Let's
the order,
see,
Your Lordship.
The BDIR 1 HCGP 2 and 3. Ajay Kumar is directed to accept notice for respondents 2 and 3. Petitioner to serve set of papers upon the aforesaid counsel forthwith.
Same stage, Your Lordship.
Huh?
Same stage, Your Lordship.
It will come list on 31st, same stage.
Yes,
Yes.
Your Lordship.
Plenary hearing.
60.
Lord, for the petitioner, Lord, the pursuant to Lord final notification.
If not already dispossessed, just
The structure is already there. Photographs are produced.
correct. If not,
Money, there's residential house. I understand.
the learned counsel PV Chandrasekhar is directed to accept notice for the respondent. ನೀವು ಬಿಡಿಯಾಗಿಲ್ವಾ? Respondent 2 and 3, learned HCGP 1. The status quo as obtaining today, the property be maintained till the next date of hearing.
Scheduled property.
Scheduled property.
Please.
Subject property.
Please, Lord.
Yes.
61.
Compensation ಕೊಟ್ಟಿಲ್ವಾ?
No.
ನಿಮ್ಗಲ್ಲ ಸರ್, next matter.
Nothing, my lord. From 2012, they've utilized and they've made it as a road, my lord. The property is being used as a road by BPM.
BBMP.
But, consequent to Annexure A, my lord, Annexure A
No,
is
the
the,
respondents are all BBMP.
my lord, the first respondent is the state, my lord.
Town planning.
Town planning, my lord.
Acquiring authority ಯಾರಿಲ್ಲಿ?
Acquiring authority is town planning, Annexure A, my lord.
Town planning.
My lord, that is, in terms of the, my lord, under section 14B of the Karnataka Town and Country Planning Act, my lord.
Where is the acquisition notification?
My lord, Annexure A,
Annexure page?
page number 16, my lord, 16.
16. ಇದು BBMP.
That is, it says, my lord, in exercise of the powers conferred under section 14B of the Karnataka Town and Country Planning Act and as per the terms and conditions of the government notification.
ಇಲ್ಲ ಸ್ಟೇಟ್ ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಯ್ತು ಮೇಡಮ್. ಸ್ಟೇಟ್ ಪಾರ್ಟಿ ಇಲ್ಲದೆ ಆಗದೇ ಇಲ್ಲ.
My lord, if I'm permitted, my lord, I'll include.
4 and 5 maybe.
4 and 5.
Maybe included.
ಸ್ಟೇಟ್ ಪಾರ್ಟಿ ಮಾಡಿ.
Yes. If I'm permitted, my lord.
The counsel for this. Learned counsel Srimati H.R. Renuka appearing for the petitioner submits that no compensation is paid pursuant to the acquisition nor the rights as obtaining in terms of the application filed which is appended to the petition as Annexure B is granted to the petitioner. The petitioner shall implead the state as a party respondent to these proceedings. State in the Urban Development Department ಯಾವ್ದು ನೋಡ್ಕೊಂಡು ಈಗಲೇ ಮಾಡಿ. Learned HCGP is directed to accept notice for respondents 4 and 5. 4 ನಾ ಇಬ್ರು ಯಾರು?
State Urban Development Department and
respond number 4. In ಮಿಕ್ಕವ್ರಿಗೆ Pawan Kumar is directed to accept notice for respondents 1 to 3. Yes, next.
Admission 52. Speak for a date.
Take it on 31st. List on 31st.
Appear on behalf of the petition.
RP.
Review petition, my lord, of 12 years delay in filing the review petition.
ನಿಮ್ದ?
ಹೌದು. ಅಲ್ಲ delay.
ಯಾರ್ permission ಕೊಟ್ರು review ಹಾಕಕ್ಕೆ?
ಅಲ್ಲ delay has been condoned by a very detailed order, my lord. 103 pages order, my lord. Delay has been
103 pages order, delay condonation.
ಹೌದು. ಯಾಕಂದ್ರೆ because of the fraud and all that, my lord, that is the reason why when we had brought it to the notice of the court, my lord, that is the reason why the delay has been condoned. Though, my lord, the learned single judge says that the observations made by him will not come in the way and we'll have to argue on the merits. It's only to show, my lord, that there is something in the matter, my lord. That is the reason why delay of 12 years has been condoned.
ಇಂದ್ರೇಶ್ ಅವರದಾ?
ಹೌದು.
103 ಪೇಜ್.
ಹೌದು.
Yes, sir. Come on, merits.
Yes, ma'am. Now, my lord, this land which we have utilized for the formation of road, my lord, for which the petitioner, the respondent before your lordship, my lord, he claimed compensation.
Claimed?
Oh, that his land has been utilized. In fact, my lord, we had given him 50% of the developed land. He then filed a writ petition claiming that 50% is not right and another 50% has to be given. That's how, my lord, he came before this honorable court. This honorable court, my lord, then passed an order.
Which is the order under review?
My lord, that is at Annexure A. May I, my lord, at the outset, may I make this submission, my lord?
You want to withdraw the petition?
That there is nothing wrong with the order passed by the learned single judge, which I can say that this is the error committed by the learned single judge. But ಏನಂತಂದ್ರೆ, the only question is why the delay was condoned or why we are before this court is the day on which, my lord, he made a claim and he filed a writ petition. He had already sold the land. The land did not belong to him at all. That is our case.
Oh, preliminary notification ends.
They are not notified. This was for the formation of road. We had utilized his land. So,
utilization of land.
Utilization of land, which we have already given him now almost close to 100% of developed land. We have given it to him. So it is not as though we have not given it to him. But now subsequently we came to know that he had actually vide sale deeds dated 27/2/2004, 13/9/2005, 27/4/2004, 4/5/2006. He had sold these lands and the writ petition was filed in the year 2011. So these lands
by the person who had already sold the lands.
Yes. So he claims compensation. We have produced these sale deeds. In fact, subsequently, we had, my lord, issued notices to him for against which, my lord, he has filed a writ petition. Writ petition is pending consideration. That writ petition number is 3336 of 2022. And, my lord, an FIR was registered. He has, my lord, filed a petition and it has been stayed by this honorable court. So, my lord, the only thing to be considered in before this honorable court is, I do, my lord, accept that there may have been lapses on the part of the BDA, that that they should have been
This order condoning the delay has become final?
Yes, no, and even stay has been granted because there was a contempt. So stay has been granted and contempt has been, my lord, closed.
Filed against that.
Against his order condoning the delay. What has happened?
They are
to the
not
appeal?
pressing that writ appeal, my lord. In
How
fact,
do you know?
Allah, we had told, my lord, on the last two occasions, they were ready to argue the matter. In fact, when we said that, my lord, when we said that the writ appeal, my lord, they have not moved. In fact, it is our thing. So I cannot, my lord, if they want to move the writ appeal, my lord, then this we can wait for that matter, my lord. In fact, on the last two occasions, once, my lord, when it was mentioned that writ appeal, my lord, they didn't say anything about it. My lord, they want to, my lord, probably weigh in that whichever court is in whichever favor, my lord, so they're keeping both pending.
Oh.
Allah, that is what I feel. That may not be so, my lord, but that is my apprehension.
Yes.
So, my lord, now they may have been lapses on the part of BDA, my lord, that they should have seen it before giving that. But now, my lord, once we bring it to the notice of this honorable court, my lord,
No,
that it has been sold and that
even according to you, there is no error in this order.
Error.
This order has become final?
Yes, my lord, this order has become final.
Yes. So there is no error in this order.
Error only to the extent that the learned single judge on the premise, on the averments of the petitioner that he is the owner of the land. That is his
You
averment.
should have filed an appeal.
My lord, what happened is we did not know till, my lord, we issued him notices.
Notice issue madilwa ಇದರಲ್ಲಿ.
Yadrali. Just after hearing both the sides.
Then
Yeah.
after hearing the BDA, this order is passed.
Houdu.
Correct.
After hearing only. My lord,
Then where is the question of review?
My lord, the review, my lord, is
That's
for,
why I asked if you have filed an appeal, an SLP,
appeal,
sought liberty to
ಅಲ್ಲಲ್ಲ,
file a
ಈಗ
review.
appeal ಯಾಕೆ ಹಾಕಕ್ ಬರಲ್ಲ ಅಂತಂದ್ರೆ, why, my lord? Because the reason is we cannot really challenge that order in appeal saying that this order that they could not have been passed. We subsequently came to know that, my lord, it is only
Subsequently
recently.
came to know.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ when there was a special task force of BDA.
ಈ ಆರ್ಡರ್ ಗೊತ್ತಿರ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ?
ಯಾವುದು?
BDA ಇದು ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಆಗಿರೋ ಆರ್ಡರ್.
ಸೇಲ್ ಡೀಡ್ ಆಗಿರೋದು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ನಮಗೆ. My lord, even as on today, my lord, even for the objections, they do not say that, my lord, that they had not sold these lands. If, my lord, they have not sold these lands, my lord, I have no case. I am out of this court. My lord, but the only question is this, my lord, whether fraud has been played or not. Only for that limited question is that when he claims to be the owner of the land.
One moment, sir. What has become of this order?
My lord, it has been to that extent implemented also. We have also paid the amount, but they again go ahead, they again file a contempt.
I said, what happened to this order?
What has been
what has become of this order? It is implemented.
Yes.
All right. Implement ಎಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ ಏನ್ ರಿವ್ಯೂ?
ಇಲ್ಲ, ಯಾಕೆಂದ್ರೆ
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಂಪನ್ಸೇಷನ್?
ಕಾಂಪನ್ಸೇಷನ್ ಅಲ್ಲಿ ಪೆಟಿಷನರ್ಗೆ ಅವ್ರಿಗೆ ಜಾಗ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ. ದಟ್ ಆಲ್ಸೋ ಇಸ್ ಆಕ್ಚುಲಿ ಮೋರ್ ದೆನ್ ವಾಟ್ ಇಟ್ ಇಸ್, ಬಟ್ ದಟ್ ಇಸ್ ನಾಟ್ ದ ಸ್ಕೋಪ್ ಆಫ್ ದ ರಿವ್ಯೂ. ಐ ವಿಲ್ ನಾಟ್ ಗೆಟ್ ಇನ್ ಟು ದಟ್. ಯಾಕಂದ್ರೆ the land which is taken.
What are you seeking by this review?
My lord, for reopening of the writ petition, only for the purpose, my lord, generally what happens is when we have when the BDA utilizes the land, my lord, when either without acquisition. So when, my lord, we generally we give them 50% of developed land for the land of the land which has been utilized by us. So we give them 50% of the developed land. That is the just and equitable compensation that they are entitled to. Here, my lord, now 100% has been paid, but they are in fact asking for more. But the only question, limited question now is, my lord, the averment in the writ petition was that he is the owner of the land. My lord, in fact, he said that 3 acres has been taken, but subsequently it was found, my lord, that 2 acres and odd was taken, 2 acres and 30 guntas, for which, my lord, we had to compensate. That has been done. But the only aspect is, he is not the owner of the land which we have come to know now. So if, my lord, that fraud is played, and, my lord, FIR is also there. I do accept, my lord, that there may have been lapses on the part of the BDA, my lord. Let anything come out, my lord, that even if they have played into their hands or whatever. Look, all that I'm saying is, if only the writ petition is reopened.
That was the best ground for you in the writ appeal.
The appeal was not filed.
The very learned friend has given an opinion saying that it should not file writ appeal. No, not a fit case. Writ appeal is not filed.
But fit case for review.
That after 15 years.
12 years.
ಆಯ್ತು ಈಗ ಹಿಯರ್ ಆಗ್ಬೇಕಾದ್ರೆ 12 ಅಲ್ಲ 15 ಆಗಿದೆ ಈಗ 2011 ಪೆಟಿಷನ್
ಅಲ್ಲಲ್ಲ ಇದು 24 ಅಲ್ಲಿ 2012 ಆರ್ಡರ್ 2024 ಅಲ್ಲಿ ರಿವ್ಯೂ ಪೆಟಿಷನ್.
Contempt is posted for framing of charge after they had lost in the Supreme
Court.
Court.
My simple thing is
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಗೆ ಯಾಕೆ ಹೋಗಿದ್ದು?
ಅಲ್ಲ contempt. What happened is this. ಏನಾಗಿತ್ತು?
ಈಗ you are only on the ground that he is not the landowner.
He is not the landowner. That is the only point, my lord, that he is not a land. My lord, even if your lordship, my lord, I am not saying that the writ petition to be reopened.
Subsequent purchaser.
ಯಾರು?
ಇದೇ notification ಅಲ್ಲ. It is only
utilization. ಅಲ್ಲ ಏನು ಇಲ್ಲ. There is
only utilization of
only utilization of the land. Compensation ಯಾರಿಗೆ ಕೊಡಬೇಕಾಗಿತ್ತು ಅಂತ. My lord,
when did the landowner sell the land?
My lord, I just read out, my lord. 27/2/2004, I produced those sale deeds. 27/2/2004, 13/9/2005.
When did you utilize the land?
My lord, in the year 2008.
The utilized land was never sold, even according to their own service. It was never sold.
My lord, that has not been made clear. My lord, if the learned senior wants to say, my lord, that he had 10 acres of land and what has been utilized and what has been sold, they are two different. My lord, I have no case. All that I am saying is, my lord, I am not even saying.
ಹೇಳಿದ್ರಿ no case ಅಂತ. ಯಾವ್ದ್ರಲ್ಲಿ ಕೇಸ್ ಇದೆ ಹೇಳ್ಬಿಡಿ.
ಅಲ್ಲ ಇದರಲ್ಲೇ ಕೇಸ್ ಇರೋದು. ಇದ್ರಲ್ಲಿ ರಿವ್ಯೂ ಅಲ್ಲೇ, my lord, that is the why I am saying is this, my lord. I am not trying to prejudice my lord's mind with regard to the delay. ಅಲ್ಲ ಯಾಕಂದ್ರೆ
ಅಲ್ಲ delay I can't get prejudice at all. 103 page ಕಂಡೋನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ that is only to the limited extent that, my lord, if because, my lord, even earlier also, before that order was passed, even before the earlier two learned single judges also, my lord, the question that was put forth to them was it your land or not which has been utilized by them? This was the simple question that was posed to them. I'm only, my lord, that the order on delay is only to the limited extent that there is something in the matter. Your lordship may, my lord, hold otherwise. I'm not saying that, my lord. If we are not able to pursue your lordships.
Just because delay is condoned.
No, you need not. My lord, no, the learned single judges made it very clear.
There is something in the BDA. There is a problem in the BDA.
Could be, my lord. Could be. In fact, my lord, the learned single judge very categorically says that any observations made while condoning delay and granting stay, that shall not be looked into, and on merits the review has to be. That's normal, my lord. So I'm not on that. All that I'm saying is this, my lord. Now, if, my lord, we have brought it to the notice of this honorable court that this land was sold and he was not entitled for that compensation, my lord, then should it not be looked into?
Compensation ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
My lord, 95,941 square feet. My lord, generally what happens, my lord, is developed land.
TDR ಕೊಟ್ರಾ?
Illa, developed land. My lord, no, generally what happens is this. If, my lord, we acquire land, my lord, what happens is we generally give about 50%, my lord, of the developed land. Not the entire extent, my lord. 45%, 55%. Out of the 55%, 50% we give it to them.
All right.
So, my lord, here we have given them more than what they also actually deserve. They already have that land. So, my lord, but the only question is, I'm not even saying that the writ should be reopened even before this court. At least if your lordships, my lord, would see.
Writ should be reopened. Bedva?
Let me complete. All that I'm saying is, if your lordships, my lord, would look into it, and if your lordships are convinced that the sale, my lord, which is executed prior to the utilization of the land, my lord, is correct, my lord, then I have a
no case.
thing. No, if it has been, if, my lord, if your lordships were to hold that the land which he has sold or he has not sold the land, then I am out of the court. Because that is the only ground, my lord, which we are urging, that he has sold this land prior to that.
Yes, sir.
The first prayer in the writ petition, I have challenged.
Which writ petition? Writ petition, yes.
But the first prayer.
Resolution 21/5/2008.
Now please come to my statement of objections in this review petition. Page number 12. That is the resolution.
Elli objections.
Statement of objections.
ಹಾಕಿದೆ.
In this page number 12. Radhikarada Sabhege Tippani. Well, here the BDA goes through everything and says that I owned 5 acres. I have a joint venture for 15 acres. That they have utilized so much of acres. Some people had asked for some Some people had been allotted revenue sites. I had repaid all of them. They took an indemnity bond from me. These sites which he now talks about are not even part of the land which was used by the BDA. Please see. The resolution itself shows that much before the writ petition was filed, the BDA was aware. And we are talking of
Page 16.
page 6.
Yes.
This is
16 of
this
your.
was the decision. Against that decision, well, why I'm pointing out this is that the BDA was aware that I had 5 acres plus 15 acres joint venture with Chetan Tayal. I was developing that property and so much of land had been utilized by the BDA. Then they said, we'll give you only so much of compensation, against which we filed the writ petition. Because it said illegal use. It was not as well like my learned friends, we just came to know now there is fraud. There was no fraud. All this was before the committee of the BDA.
Why you did not challenge the orders? Why? Because BDA knew everything even before the issuance of the order that was subject matter of challenge. So you did not file it.
I'll submit. I'll make it clear to you. Lord, even prior to them filing the writ petition, we had allotted them 50%. So, my lord, what the learned senior is saying is right. My lord, we were, my lord, the entire premise on which we, my lord,
stay there.
Stay there.
Yen stay there.
Allah, stay of the order because contempt was
Yen
there.
stay agate. Ella agogide. What is this?
Allah, because they have filed contempt. Now, my lord,
The 2012 order ಈಗ stay ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಈ 103 ಪೇಜ್ ಅಲ್ಲಿ ಅದು ಇದೆಯಾ?
ಅದು ಇದೆ. ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಇತ್ತು ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ they are now asking for much more. Now what is going to happen is what we have utilized their land. Even assume
You have convinced the honorable judge that there is a fraud played prima facie.
My lord, now I cannot say anything more, my lord. That is what we have been able to show to him that it is there. That is the only reason. But now it is for us to, my lord, convince your lordships on this.
No, there appears to be a rivalry between two private entities where BDA is wanting to settle the score.
Illa.
Prima facie.
Illa. Ad ilve illa. No, my lord. That it may be so in other matters. But yes, your lordship may be right in saying whether the BDA, my lord, have not been totally diligent or some people have done something, my lord, because
BDA in all cases are not indolent. They are diligent. Some cases are terribly indolent. One is this. For obvious reasons.
I'll just make it clear to your lordship. Now what happens is this. The BDA, my lord, when that land utilized, my lord, they gave them 50% of the developed land. After that, my lord, they filed this writ petition. May I just submit, my lord?
Sir, ಇದೆಲ್ಲ ರಿಟ್ ಅಪೀಲ್ ಗೆ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. 12 ವರ್ಷ ರಿಟ್ ಅಪೀಲ್ ಹಾಕದೆ conveniently you file a review petition.
ಆಗ್ಲಿಲ್ಲ. The delay for why we are saying that is, well, now when we have issued them, I'll just point out.
If there is no error apparent on the face of the record of what the learned single judge in 2012 had passed, which even you say there is no error on the part of the.
Error only, my lord, to the extent that he claims to be the owner based on which the order is passed.
That is a fit ground for writ appeal.
Lord, it may not be, my lord.
Review hakakalla.
I'll just say this, my lord. Now, when we have issued notices, my lord, may I just make this submission? My lord, generally what happens is this, my lord. Now, when we utilize the land for the.
ಆಯ್ತು ಈಗೆಲ್ಲ ಆಗೋಗಿದೆ. ಈಗ ಸ್ಟೇ ಮಾಡಿ ಏನಾಗಬೇಕಾಗಿದೆ?
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬಿಟ್ಟು ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜಸ್ ಅಂದ್ರೆ ಫರ್ದರ್ ಕಾಂಪನ್ಸೇಷನ್ ದೇ ವರ್ ಕ್ಲೇಮಿಂಗ್. Because this order was coming in the way, they are again further compensation, more than 100% land. They have already got 100%, which is in our view, subject to what the learned senior has to say, my lord, in our view, my lord, is more than what we should have been given by BDA itself.
Special damages was awarded by the learned single judge. They first of all, when the contempt was, they first on 2 occasions, they said we'll comply in 2 weeks. Then they closed the contempt saying that we'll give you liberty to reopen. We reopened, against that they went to the Supreme Court.
Lord,
Then charge was ordered to be
1,25,000 we have
framed,
given them, 96,000 square feet we have given them.
All right. We'll hear it.
Yes.
List on 24th. Admission. I had not seen this. What is the issue? Yes.
My lord, 230 list.
Yeah, 230 other issuance. 24th.
Very good.
May I just request your lordships, my lord, whether the other writ petition, my lord, because
kodi other ella
writ petition number 3336 of 2022.
kodi ella tondre 333
336 of 2022,
Tag this petition along with 3336 of 2022 and list them both on 24th. ಇನ್ನೂ ಒಂದಿದೆಯಾ?
Special task force report ನಮ್ಮಲ್ಲಿ prosecution ಮಾಡಲ್ಲ.
ಅಲ್ಲ ಅದು ತಮ್ಗೆ
ಅದು stay ಆಗಿದೆಯಲ್ಲ?
Stay ಆಗಿದೆ. ಅಲ್ಲ that may not.
ಅದು ಬೇಡ ಇಲ್ಲಿ.
Can be, it may not be
That
necessary.
is also part of the same.
But that also can be clubbed, my lord, then if it is, we have no objection.
ಸಾಕು. This is land acquisition, right?
My lord, this
that is
should have been,
GMRS.
but it is,
Idi.
my lord, upfront we have to bring it to lordship. It is classified as GM restitutive, my lord, because it was a SPF task. Should have been BDM, my lord, but if it can be clubbed.
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಲಿಸ್ಟ್ ಬರೀ ಯಾವ ಲಿಂಕಿಂಗು ಬೇಡ. 336 of 2022. Don't write that order. List on 24th.
Yes.
Interim order.
Interim order subsisting will continue till the next date of hearing.
ಇಲ್ಲ ಸರ್ ಪ್ರತಿ ಸತಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ತದೆ.
Further hearing ತಗೊಳ್ಳಿ. ಬಿಗ್ ಗ್ರೂಪ್ ಇದಾವ? ನಿಮಿಷ ಇದೆ, ಎಷ್ಟಿದೆ ಬಿಗ್ ಗ್ರೂಪ್? ತುಂಬಾ ಇದೆ. ಕರೆದು ಬಿಡಿ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಯಾವ್ದಿದೆ ಮೇಡಮ್? ಶೀಲ.
Sixty-three.
2012 ಏನಿದೆ?
My lords, may kindly pass over the matter, my lords. Senior is on his feet.
On his way?
Indeed, my lord.
From where?
Yeah, he was engaged in Hoskote court.
ಹೊಸಕೋಟೆಯಿಂದ ಬರ್ತಾ ಇದ್ದಾರಾ? ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ. ಅಲ್ಲಿ ಹೊಸಕೋಟೆಯಲ್ಲಿ ಇರಕ್ಕೆ ಹೇಳಿ.
There is no, only the ground is about the scheme.
ಕೊಡಿ. We'll send this order to ಹೊಸಕೋಟೆ.
My lords, may kindly pass over the matter, my lords. He's reaching High Court.
He is reaching High Court. Who is your senior?
Last 3-4 occasions.
Allotment.
Yes, my lord.
ನೀವು ಇದು ಯಾವ್ದೋ ಯಾಕೆ ರಿಪೋರ್ಟ್ ಆಗಿಲ್ವಾ ಇದು?
ಆಗಿದೆ.
ಯಾಕೆ ಮತ್ತೆ ಯಾವ್ದು ಕೊಡ್ಬೇಕು ಯಾವ್ದು ಕೊಡಲ್ಲ? ಸ್ವಲ್ಪ ಹೋಮ್ ವರ್ಕ್ ಮಾಡಕ್ ತೊಂದ್ರೆನಾ? ಮತ್ತೆ ಅವ್ರ ಪಾಸ್ ಓವರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಪಾಸ್ ಓವರ್ ಅವ್ರು ಹೊಸಕೋಟೆಯಿಂದ ಬರ್ತಾ ಇದಾರೆ, ನೀವೇನು ವೇಟ್?
54.
ಇದನ್ನ ಮಾಡ್ತಾರಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಪೆಟಿಷನರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
65.
Lord's, Lordship's order dated 25/3/2025.
My order.
Lord's, that's by the coordinate bench. Lord, the coordinate bench had directed that they will have to indicate whether this forms an isolated piece of property. Just a prelude to this,
25/3/2025. One ನಿಮಿಷ.
this is pertaining to RMB second stage where there is a preliminary and final notification of 77, 78 respectively. Lord's, learned single judge of this honorable court has held that this scheme is lapsed, notwithstanding that there was an earlier decision, my lords, of the year 1995 that the scheme is not lapsed. Latest of the judgment by the learned single judge is it's lapsed. Lords, two contentions are raised. One is the scheme having been lapsed as held by the learned single judge, which is a later judgment. Lords, they cannot now implement the scheme number one.
25/3/25 affidavit ಏನು ಹಾಕಿದ್ದಾರೆ?
Affidavit has been filed where they say, my lords, if your lords were to take the affidavit filed on 16/4/25.
Yes.
Lords, there is one page number 4, my lords. I'll just take your lords to page 4 and then come to the contents of the affidavit. The second paragraph, I'm sorry. Page 4, my lord, second paragraph. ಸದರಿ ಬಾಬ್ತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಪ್ರಕರಣವು ಬಾಕಿ ಇದ್ದು ಸದರಿ ನಾಗಶೆಟ್ಟಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 24/3 ಜಮೀನಲ್ಲಿ ಪ್ರಾಧಿಕಾರವು ರಸ್ತೆ ನಿರ್ಮಾಣ ಮಾಡಿದ್ದು ಇದರ ವಿವರ ಕೆಳಗಂಟಂತೆ ಇರುತ್ತದೆ. ಪೂರ್ವಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 23/1, 23/2 ಅಧಿಸೂಚಿತ ಪ್ರದೇಶದಲ್ಲಿರುವ ಅನಧಿಕೃತ ಕಟ್ಟಡಗಳು. ಸಾರಿ
ಏನೇನು ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ನೋಡ್ತಾ ಇದ್ದೆ. ಬಿ ಗ್ರೂಪ್ ಆದ್ರೆ ಫೈಲ್ ಓದಿರಲ್ಲ ಅದಕ್ಕೆ.
Lies in this only narrow compass. And to this, my lords, the BDA came up with a proposition relying on a judgment of a learned single judge coordinate bench, which had said that it should not be treated as a precedent, saying that you should pay 90% of the guideline value. That is when the matter stood adjourned, my lords.
I did not come up with this.
That's the judgment which was produced
I
by
did
them.
not come up with this proposal, my lord. It is not a
Mike is
proposal.
I'll
It is
mention.
not a proposal from the BDA, my lord, that 38D is the only option which BDA wanted them to exercise. No, my lord. It was argued after this order, my lord, what my learned senior is referring to.
38D.
After this order,
38D also maximum is 50-80 site.
4,000.
Yes, only
square feet.
4,000
Lord,
square
what-
feet. That's now out of 20 guntas of property
Let me
which was
make this-
acquired. 10 guntas is utilized by them for formation of roads. On
That
all
is
the other three
admitted
sites.
utilization.
Pardon, lords?
Admitted utilization.
Admitted utilization. Now, on the remaining three sites, we said that all the three sites is not the layout formed by the BDA. Notes, they filed this affidavit saying that we have not formed any layout in respect of all the three sites, but what they say is that in respect of one of the sites, they have themselves approved a layout plan to NTI who have formed the layout. Other two sites, they admit that these are the lands which were subject matter of the acquisition, but unauthorized constructions are in existence. Only difference between those cases and my case is that I don't have an unauthorized construction which the BDA wants to recognize. Otherwise, I stand on the same footing as the other two neighboring owners. That is 23/1, 23/2, and 23/4. This is where it stands. 10 guntas they don't want to give up on this property, which cannot be now incorporated as a part of the scheme which they have already implemented. And now, lords may kindly see page 190 in the paper book, the writ petition papers. Page 84, the order starts. And at page number 190, para 56. To defend the actions on behalf of the state and the other respondents where it is contended by the learned counsel for them, the following figures have to be given, demonstrate that actual extent of the lands notified, actual extent of land which the state, the authority were able to take possession of, actual extent of land in respect of which the scheme is claimed to have been implemented, and the extent of land in respect of which the state government has issued notifications under section 48 releasing lands from acquisition proceedings itself, which in turn takes it out to the scheme as under. Its total extent is 1331. Total extent of land handed over to the engineering section is 629. Extent of land utilized by BDA for formation is 379. Extent of land allotted to private societies is 405 by way of bulk allotment. Extent denotified is 102. Extent of land unauthorized structure is so much. Notes, this having been considered, if your lordships were to see, notes at paragraph number 56, I'm sorry, there is a repetition at page 197. Internal page 114. A scheme per se on the face of the record, even as considered in the year 2011. Note the emphasis is in the year 2011 because 1995 this very scheme came up for consideration before a division bench which said scheme is substantially implemented. But the scheme was again tested in the year 2011. Therefore, note the learned single judge said this.
A BTM layout scheme.
Note RMB second stage.
RMB second stage.
Is a scheme which does not pass or meet the requirements of section 27 of the act as being held to be a scheme which is substantially implemented in the year 95 or 96 is a travesty of truth and fact and a distortion of the record and legal position. This is after considering what was said to be the division bench order. Then page number 201.
Right. This is under challenge and there's a before the division bench and there's a stay.
Which one?
This
Is
present.
order stay ಆಗಿದೆಯಾ?
Yes.
No, there is no stay.
There's a stay.
Appeal is pending.
Appeal is pending. But learned senior has argued in that appeal.
It appeal 6-6. No, I have not argued in that.
Argued
matter. 6. No, that is a different matter altogether. So far as RMB
Not
second
just-
stage.
Alla, ide anta ಹೇಳಿದೆ. And
No,
there is
that
an
is
order from
RMB
this court.
second stage is a
There is an
different
order from this honorable court saying that to post this matter after disposal of that writ appeal also.
Where is that?
That is there, my lord. Lord, that is why, my lord, everything was crossed. They wanted to argue something different. Learned single judge made an effort of seeing whether BDA can actually utilize this land, whether there is an adjacent lands are.
Where is the order directing posting the matter after the writ appeal?
Earlier, this was appearing in the cause list only. my lord.
Cause list
After
9/2/2023, my lords. In the cause list, it appears.
9/2/2023.
Yes.
ಅದಾದ್ಮೇಲೆ ಸುಮಾರು ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ.
ಅದಾದ್ಮೇಲೆ ಸುಮಾರು
But after that, the matter is argued substantially before my lords, the coordinate benches. Essentially, my lords,
Without
wherever we went, my lords, the BDA came up with the contention that 38D is the remedy. Lords, when we said that 38D is restricted to 4,000 square feet and not beyond, because we are claiming 10,000 square feet, They came up with the judgment which is noted in the order sheet if your lords were to see, my lords.
What 2023? 3823.
They filed a memo for disposal, my lord. That is the reason why the matter came up. On
Allah, there is already an order. Call this matter for disposal of writ appeal 663 of 2020.
after that, they filed a memo on 8/12/2023, serial number 2, my lords, in the cause list.
Yen memo.
They filed a memo for disposal,
Memo
saying
stating
that the property is sold. So
Disposal
therefore,
required.
they wanted this matter to be disposed of.
That is also 3/10/23, an order is passed on that memo.
Yes. Now, there are two writ petitions, my lords. One is by the
Subsequently.
erstwhile owners, one is by the present owners. Ultimately, it is 10,000 square feet of property.
So pendency of the writ appeal will not come in the way now?
Lords, I don't say that it will
Because
not
there is
come in the
already an
way.
order.
Lord, that's,
Why have you not submitted to the court after that?
Lord, I have submitted it after that, my lord. They
The
said, Lord,
latest, just
Lord,
the so detail
Lord,
order
let
ಮಾಡಿದ್ದಾರೆ.
me be little fair if they accept it, my lord. It was argued by the learned senior also, and the court indicated that we will not rely on these judgments and to independently establish whether the possession of the property is taken over or whether
In the writ appeal or the single?
in the writ petition itself.
Writ
Lord,
petition.
this was argued before, my lord, sorry to say, I have said it thrice now. This is the fourth before lordships. Fourth time,
writ
this
appeal
was
is-
argued before 4 different benches, and all the 4 different benches at the end gave them an option. See, 38D is the better option.
No,
It
ನಾನು
was not me.
beginning ಅಲ್ಲೇ ಹೇಳ್ದೆ
That's a-
38D.
that's a
I'm
wrong
sorry, my lord,
statement.
it was
No, no,
beginning
that's a wrong
ಅಲ್ಲಿ-
it
statement,
was
Mr. Sir.
38D,
It should
it
not-
says BDA came up with a proposal. Sorry, my lord, I
Is
beg to
utilized
Have a
as-
look at the order
I beg
sheet,
to
my lords.
differ. My lord, that's why.
But Ravi Shankar sir,
Lordships.
there is already an order
Lords,
directing
that I concede, my
posting
lords.
the matter after the writ appeal.
But the whole difficulty is
Who
BDA
the
came
writ
up with
appeal?
this memo for disposal after that. And they insisted, my lord, that the writ petition should be dismissed on the ground that the property is sold. We filed an impleading application. This honorable court observed that you file a separate writ petition. Separate writ petition is also filed. Both are before this honorable court. That is when the hearing took place. It is not that we moved the matter. It is the BDA who filed the memo for
ಯಾಕೆ
disposal.
why?
Lord, it was, he had sold the property, my lord, as on that day.
Orders.
That's why, and a
Then
memo was.
2024 lo writ petition ಹಾಕಿದ್ರೆ same party.
That is the
Adu,
same thing.
that is why, my
That
lord,
is by the purchasers.
Lord, after I filed this memo, impleading application came to be filed, which they were supposed to show it in 2013 that they had entered into an agreement to sell with that person in 2013. After that, my lord, they did not disclose it. I disclosed it to this court. And my lord, after that, my lord, after 3 hearings, they
ಈಗ
come up with this
ಅದಾದ್ಮೇಲೆ
application.
ಬರಲ್ಲ ಏನ್ ಮಾಡೋದು?
Lords, now that the factual.
662 of 2012, and it should be listed for hearing.
Yes, my lord, it was listed, my lord, because of this, some people had invoked this section 24, my lord, and the lapse, my lord, because of the honorable Supreme Court's order, my lord, it got deferred, my lord, for some
ನಾವು
time.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಎಲ್ಲ
ಮುಗಿದಿದೆ
ಆಗೋಗಿದೆ.
ಈಗ, ಬಟ್ ಅವಾಗ 2 ಸಲ ಹಿಯರಿಂಗ್ ಆಗಿ 1 ಸಲ ರಿಸರ್ವ್ ಆಗಿ then again it has come back.
Lords, now in view of the affidavit filed and the
We'll
orders
post it after
dated.
2 weeks, sir. Yes. ಅದನ್ನ ಆರ್ಡರ್ ಮಾಡೋದು ಬೇಡ because subsequent hearings have taken place.
I understand.
Writ appeal move ಮಾಡಿ.
But we are not parties in the writ appeal. BDA will have to take steps to do that. They can't keep this in a limbo, my lords, for 10, 12 years.
The learned
2011,
counsel appearing to
2012.
the respondent, Mortgage Charity, submits that there is already an order by the coordinate bench on 9/2/2023 to post the matter after the disposal of the writ appeal in 662 of 2012. The learned counsel further submits that the writ appeal would be listed for hearing. The learned therefore list this matter after 3 weeks. In the event no order is passed by the division bench, the court would take up the matter on its merit.
Lords, so great.
It is listed tomorrow. It is listed tomorrow.
ಪರವಾಗಿಲ್ಲ 3 weeks ಕೊಟ್ಟಿದ್ದೀವಿ.
Please.
Entry mode ಇದೆಯಾ? Entry mode subsisting will continue to the next date of hearing.
Please, Lord, this is pertaining to Banshankari phase 6, Lord. It's already covered.
ಯಾರು ಅವ್ರು ಹೇಳ್ಬೇಕು ಕವರ್ಡಾ ಮತ್ತೆ? Yes.
I can produce all of the judgments, Lord.
We'll take it on 24th.
May I just point, my lords?
Just on 24th.
10,
Entry mode ಇದೆಯಾ?
2023 ಇದೆ. For 10/10/2003, my lords may kindly see, because this is a very
24th,
short point.
Just on 24th.
67.
Entry mode
please.
subsisting will continue to the next date of hearing.
Please.
67.
Hearing on the petitioners, my lord.
67 in
67, my lord. My lord, senior is arguing before another court.
24th, yes.
I'm grateful.
8.
For respond number 3, my lord, but senior is held up in another court hall. It may be taken up on day after tomorrow, my lord.
24th, yes.
Entry mode may kindly.
Entry mode subsisting will continue to the next date of hearing.
My lords, appearing for the respondents, kind shorted.
29th.
My lord, and for the petitioner, my
Much
lord.
obliged.
70.
My lord, 2 times date has been taken.
Respondent ಕೇಳಿದೀಗ
PDA ಕೇಳಿ.
24th ಅಂದ್ರೆ, yes.
70.
My lord, next, I pray for next week, my lord. Next week, my lord.
24th, yes. Entry ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ. 71.
21.
Yes, Pradeep Kumar, stay ಇದೆಯಾ?
Stay there.
29th, entry model, yes, next.
22.
Yes, Clifton.
Lord, this matter, my lord, acquisition is under the VDA Act. The prayer, my lord, is that compensation should be given under the 2013 Act because the acquisition has been completed, both the preliminary notification and the final notification. Of course, my lord, the difficulty is the order of the Honorable Supreme Court, my lord, in regard to this. But my endeavor will be, my lord, that judgment, my lord, may have to be relooked.
Which judgment?
The Honorable Supreme Court, my lord, has held that in BDA 2013
So
Act,
Supreme Court judgment has to be relooked.
Allah, it will be per incurium because
Per incurium.
it doesn't take into offshore, basically, my lord, offshore, what offshore held, if I can just take my lord through this. The 1894 Act, my lord, held the field. BDA came out in 1976. In 1984, my lord, an amendment is brought to the Land Acquisition Act. This matter goes to the Honorable Supreme Court. Offshore holds that all the compensation that is there under the 1984 amendment, that will also have to be given under the BDA Act. But it stands to reason that, my lord, that any subsequent increase, that would also, my lord, fall in favor of the land user. That's in light of, my lord, the Constitution Bench judgment, my lord, Nagpur Improvement Trust,
We'll
that they
see.
cannot be.
Yes. Let the respondents come. 24th.
Lord,
Entry model, yeah?
illa, sir.
ಏನಿಲ್ಲ, ಸರಿ, yes.
Just one difficulty I'm having in this, my lord, under section 18, my lord, if I fail here, I'll have to go and reference. The time, my lord,
Let
is
him
passed
come.
for that.
That
On-
will protect.
On 24th, if it can be taken in fresh matters. if
No,
the
no
matter-
fresh matters. It will come, yes. 24th.
Grateful, my lord.
73.
But 24th. Entry model, yeah?
Intermediate, this is a small question, my lord. We have auctioned 258 square meters. Now there is available only 159 square feet. We have written, my lord, stating that we will execute
No,
the sale.
no representation. We have the petitioner 31st, yes.
74.
For the petitioner,
During for respond number 2 and 3, my lord, the paper is short accommodation. Senior is held up in an arbitration, my lord.
Arbitration.
you know,
The date given matter, maybe had
You know,
a
you
2
know.
weeks, my lord.
That submission should not.
They
be
have
made.
not, we have asked, we have sought for
Not
a
correct.
declaration that lapsing of the acquisition according to the indoor judgment.
24th. Heard the learned senior counsel Nayak appearing for the petitioner. Counsel for the respondent seeks time on the score that the arguing counsel has some inconvenience today. Lest the matter on 24th is made clear, no further adjournment would be granted in the matter.
Entry order.
Order subsisting would continue to the next date of hearing. Don't tell that next time. Yes.
Yeah, that.
My lord,
My lord, they have not even
Arbitration
filed a
pending.
statement, my lord, before your lordship.
Objection ಹಾಕಿಲ್ವಾ ಇನ್ನು?
ಇಲ್ಲ.
Objections if
Illa,
any
up to
by the
them,
next,
if they don't want to
objection if
file.
any by the next date, failing which it shall be construed that the respondent has no objections to be
objection,
filed.
yes. And the petition amendments will be taken as correct.
I appear for respondent, your lordship. Your lordship,
The earlier, my lord, the land belonging to the petitioners, my lord, was a subject matter of acquisition proceeding. That was challenged, my lord. And when the writ petition was pending, my lord, an order came to be passed on the basis of a submission made by the council, senior counsel for the BDA, my lord, which is at page number 57, my lord. And they stated that the land is no more required for their utilization, my lord. And
Where
they
is
would
that?
also- Kindly see page 57, my lord. Ink
No
page-
more required.
Yes, my lord. Ink page 57, my lord. And they also recommended, my lord, that for deletion from the proceedings. That is recorded and the state government, my lord, was directed to take, my lord, steps in terms of this submission. Then, my lord, this was not, my lord, implemented by the state government, my lord. Therefore, contempt proceedings were initiated. Then, my lord, the state government, by annexure P, my lord, page 69, my lord, rejected the contention.
Contempt
rejected and-
ಹಾಕಿದ್ಮೇಲೆ reject ಮಾಡಿದ್ರು.
Reject ಮಾಡಿದ್ರು. Then, my lord, this honorable court, my lord, in terms of annexure Q, in a similar petition, my lord, has passed the order, my lord, which is
Yes, sir.
at page number 73, my lord.
Yes, yes, sir.
lordship, they have not challenged acquisition proceedings.
You leave it, sir. First ಇದನ್ನ ಹೇಳಿ. the earlier writ petition was disposed on a statement made by you,
Yes, Your
correct?
Lordship. Yes, Your Lordship.
Have you challenged that order?
I'm not challenging.
Boss, our challenge bidi, nimd ಹೇಳಿ. Have you challenged this order?
I'm not challenging.
Then the order, the statement recorded in the order is become final.
Yes, I have already recommended, but the state has rejected this, Your Lordship.
48-1
ಅಲ್ಲ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವಾಗ?
Annexure P.
After I filed the contempt petition, my lord, that's on 7/12/2022.
That is that Annexure P.
And what is this identical order?
My lord, same, my lord, the submission made by the senior counsel, my lord. in
That
the-
is annexure Q.
My lord, kindly come to page 75, my lord, para 5. The same submission, my lord, has been extracted herein. And at paragraph number 6, my lord, by referring to an order, my lord, the impugned
We'll
endorsement.
pass this one.
State government has to, because it has rejected that.
Why was the learned advocate general waiting?
3:30
ಇಲ್ಲೇ
matter,
ಇದೆಯಾ?
my lord. Smart meter. my lord.
Smart meet. All right, on the
Please.
4:30 I'll take it.
Please.
Madam is not there, I guess.
Sitting outside.
Early, ಮುಗ್ಸಿ madam. Yes, will.
I'll take instructions.
What take instruction, madam?
Lord,
We'll post it tomorrow then.
please, madam.
Yes, ನಾಳೆ.
Day after tomorrow. Tomorrow.
Day after tomorrow?
My lord, I'm not in,
Tomorrow.
even that's one, my lord.
Tomorrow, yes. ನೀವು ಇರಲ್ವಾ ನಾಳೆ?
My lord, can it be for further hearing, my lord?
Personal inconvenience.
No, no, we'll wait. Post it on
Next week, any day.
31st.
Next week, ಅಲ್ಲೇ.
ಬೇಡ, let's on 31st, yes. We'll have it on 31st at 2:30 PM. Yes. ಇಲ್ದೆ ಇದಾರ? List the matter for preliminary hearing ಅಂತ ಇದೆ. List the matter for preliminary hearing on Thursday.
76 my lord.
76.
ಅಲ್ಲ ಇನ್ನೊಂದು 2 ವಾರ ಟೈಮ್ ಬೇಕು ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ
Fresh matter, 23 ಇದು. List the matter on 24th. Objections, if any, by the respondent by then. Yes, next.
77.
Jay Kumar.
This matter, my lords, we have filed writ petitions, my lords, challenging the awards that have been passed.
Numbers ಕೊಡಿ.
Please, it's at FR number stage.
FR stage. ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ?
BD has.
Award was passed in 2016.
First, the awards have been passed.
Comply ಮಾಡ್ಬಿಟ್ಟು numbers ಕೊಡಿ.
Please.
Tag all the petitions. The learned counsel Ajay, ಒಂದ್ ನಿಮಿಷ. Ajay Kumar submits. ಇದ್ರಲ್ಲಿ ಏನಿದೆ?
We have sought for mandamus to pay the award amount. Award was passed in 2016. They have
ಅದನ್ನ
not
challenge
even
ಮಾಡಿದ್ದೀರಾ ಈಗ?
They have not
Because
deposited.
they have been passed under 2013 Act. It could not have been done.
Awards are passed 2013 Act.
How?
Acquisition ಯಾವ್ದು?
Acquisition is of BD Act. my lords.
Annexure A is the final.
Acquisition is under the BD Act,
BD Act.
but the award has been passed under the 2013 Act. Annexure B, page 14 onwards, lords will find
Oh, these
5
are the awards, is it?
These are the awards.
The petitioner is before this court seeking implementation of the awards so passed. The learned counsel appearing for the BDA submits that all the awards are challenged before this court in separate writ petitions.
Yes.
Therefore, tag these petitions along with the subject petition, list them all on 24th.
31st must have comply with all the objections.
31st, yes.
It matters.
ಏನ್ 6 ವರ್ಷದಿಂದ ಇದ್ದೀರಾ wait?
ಅಲ್ಲ, ಅವ್ರು, they have not been paying.
2016 ಇಂದ ಇಲ್ಲ wait, ಒಂದು ವಾರದಲ್ಲಿ ಏನಾಯ್ತು?
Because of
Let's
some.
see if it is contrary to law, then ನೀವ್ ಯಾಕೆ ಇಷ್ಟು ವರ್ಷ ತಗೊಂಡಿದ್ದೀರಾ ಮಾಡಕ್ಕೆ?
That's what I am.
Their title itself was still under dispute. In 2022, in the SLP notes, they get the order before the Honorable Supreme
ಎಲ್ಲ
Court.
ಹಾಕಿ objections.
Please,
Everything in what you file, you file. Yes.
please.
Date.
31st. Yes.
78.
Lord, I pay for petition this case. This case, Lord, IA has been filed for production of additional document that has been returned with the office objection.
Right.
1 week.
A week's time is granted to comply with the objections. Quay the application. List on 31st. Intermort ಇದೆಯಾ? Yes. Next.
79.
Same order, 31st. Objections, if any, by the next date, 31st. Notice ಆದಂಗಿಲ್ಲ ಮೇಡಮ್ ಇದು? AGA for R1 to R8 ಆಗಿದೆ. 80, ರುದ್ರಪ್ಪ.
And my lord, this can be disposed of by
Why?
direct. This, my lord, in statement of objection filed before the trial court that they have admitted. In page number 38, may kindly be, this is AC order came to be passed in my
Test the
favor.
matter on 22nd in preliminary hearing. We'll dispose it. Yes, interim order subsisting will continue to the next date of hearing. Next.
81.
Appearing for the petitioner in this matter. In this matter, we have challenged the final notification and the order passed under.
Where is BB Patil? Stay there.
Stay, yes.
Yes. 31st IO.
And
Next.
also, may I make one more mention? That's with respect to serial number 39, interim order has to be.
Interim order will be extended in all the cases.
Deeply.
Yes.
82.
For the petitions.
For the respondent, madam.
CH Muda. Yeno?
When Devdas was allotted the incentive side. The petitioner Vendas Devdas was allotted the incentive side.
Incentive site?
Yes, but this land has been acquired for the permission of layout. Hence he was allotted the incentive site. He sold the properties in favor of me. So I have purchased a property and I am the constructed residential building. Now, Malad, they issued the public paper publication saying that illegally they allotted the site in favor of my vendor, for which they are trying to dispose me the land in question.
Yes, sir.
My lords, based on the paper publication they have come, my lords. VDA is not given that, my lords. And one more
Learned
thing.
counsel for the petition, respondent BDA submits that the apprehension of the petitioner based on the paper publication is irrational. And BDA has not issued any notification or passed any order of the kind that would lead to disposition of the petitioner. In that light, list the matter on 31st. In the event there is any precipitative action against the petitioner is at liberty to move the matter. Yes. Interim order illide.
Last case.
Idra continue. Yes.
In the next matter also very same.
Same. Yes, next. 82, 83.
Please, my lords.
Stay for the petitioner. 84.
Yes. 80? Yes, Ajay Kumar. Objections ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿ ಅಜಯ್ ಕುಮಾರ್?
Petitioner.
31st.
Please.
Objections, if list the matter on 5th August. Objections, if any, by then interim order subsisting will continue to the next date. Next. 85, Ajay Kumar.
Petitioner in this case, ma'am. Writ of mandamus may consider representation of the petitioner, my lord.
Yes.
Petitioner is
Please
the
to
revenue.
consider the representation, my lords.
Close it.
Please.
The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus to consider the representation submitted on 18/1/2025 for the purpose of allotment of alternate site in Sir M. Vishweshwaraya layout, 6th block. The learned counsel appearing for the respondent BDA submits that if reasonable time is granted, the representation of the petition would be considered and appropriate orders would be passed. In that light, without going into the merit of the matter or the claim of the petitioner, I deem it appropriate to dispose the petition, directing the respondent BDA to consider the representation strictly in consonance with law and pass necessary orders thereon, and further communicate the orders so passed by the BDA to the petitioner. It is made clear this court has not considered the issue on the merit or analyzed the claim of the petitioner on its merit. It is a direction simpliciter to consider the representation and pass necessary orders in accordance with law. The 8 weeks, 12 weeks?
8 weeks.
The representation shall be considered within 8 weeks and the 8 weeks, bearing in mind the observation made in the course of the order. Communication list. Next.
88 also same, my lord.
80?
Number 88.
Same order. K. Krishna. Same order.
Annexure Q, ma'am.
Whatever. 88 same order.
86.
Petition from the petitioner grandfather was allotted the land bearing survey number 67.
Grandfather was allotted a grand?
No.
Land.
Allotted the survey number 67.
2025 alva?
Yes.
Learned counsel Poonam Patil seeks 2 weeks time to file statement.
They are
ಏನು?
They are farming the, allotting the site to the allottees.
You move the matter if they
without-
pass any order.
Without initiating the acquisition proceedings, out of 4 acres, 2 acres,
But
25
we
guntas
have
has
to see
been
because
notified.
this layout is already complete, my lords. I have to seek instruction of possession, what he's submitting.
Right. List the matter on 31st, objections if any.
Not to
by
allot
then.
any site in favor of the allottees.
Which site,
in my-
sir?
No, because it is denotified. It's a first.
When it is, when is it
But
denotified,
out
sir?
of 4 acres, 2 acres, 15 guntas notified.
When is it denotified, sir?
It is left out from the acquisition proceedings.
When is it left out?
Yeah, as per the final notification. They will kindly appreciate final notification. First, initially the preliminary notification, entire 4 acres has been notified. In the final notification, 2 acres, 15 guntas left out from the acquisition proceedings. So I am in the possession. Now, my lord, without initially the acquisition proceedings.
Left out of the final notification ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ. So ಈಗ ಅವಾರ್ಡು ಮಾಡದೇನೆ, they are utilizing my properties and allotting to the somebody
ಈಗೇನ್
else.
ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ?
ಈಗ ನನ್ನ
ನಿಮ್
property-
possession
I'm-
ಏನಿಲ್ಲ ಅದು?
Yes, I am in the possession in respect of 2 acres, 15 guntas.
What
that-
he's saying is survey number 67 is mentioned in the final notification, but what portion? His portion has to be identified, my lords. En mass, he cannot say that I'm.
Anyway, now
entitled.
don't allot that to someone else.
Yes, my lord, that's
It's-
so-
I will, if that is the urgency, not could be had on Monday, but not so far. I'll.
List the matter on 22nd, yes.
Yes.
The respondent to secure instructions and make submissions.
Yes.
22nd preliminary hearing.
Yes.
Yes, next.
87 is also same.
Same, huh?
Same.
Same, my lord.
It may be tagged along with.
22nd, yes.
It may be tagged along with.
Tag and but
Much.
89 same, huh?
18 ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾನೆ. They are issued an endorsement saying that the land has been, the land not been
Objections, sir.
utilized.
I appear on behalf of Mr. Gopi, some time. for
Learned
filing
counsel Gopi GA 6, 2 weeks time to file statement, 3 weeks time to file statement of objections. List on 5th August, interim order subsisting will continue to the next date.
90.
90, my lord, 28A, they have filed application petition on my lord.
Writ of mandamus seeking direction to
Section
respond.
A, my lord, application was filed under section 28A for redetermination of the
Consider representation.
8 weeks.
The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus to consider the representation submitted by him on 9/12, representation/application dated 9/12/2022 for redetermining compensation in respect of the acquired land. The learned counsel for the learned HCGP would on instruction submit that if reasonable time is granted, the application of the petitioner would be considered in terms of law, i.e. 28A of the LA Act, and appropriate orders would be passed thereon. In that light, without going into the merit of the matter, I deem it appropriate to dispose the petition with a direction to the respondent to consider the representation of the petitioner and application of the petitioner and pass necessary orders in accordance with law within an outer limit of 8 weeks, 12 weeks, if not earlier.
Much.
Ordered accordingly.
91.
Appearing for the petition in this matter, my lord, writ of mandamus, change of land is concerned.
Yes, sir.
But I seek some inspection, Lord, this shows. my lord,
29th Hakla,
good.
list on 29th in preliminary hearing.
Sure.
At the request of the learned counsel Murugesh Charati. Next,
My lord, 24.
22nd,
22nd.
Agata, 22nd.
Obliged.
92.
I will take notice for respond number 1, my lord, respond number 2 and 3 are.
92 ಅಲ್ಲ
92 minutes.
learned ಆಗ್ಲೇ ಆಗಿದೆಯಲ್ಲ
Notice. This is
learned
covered,
AGA HCGP is directed to accept notice for the first respondent. Yes, Vivekanand.
this is covered by decision against me, my lords.
Page
Page 18, annexure D, my lords.
will pass the same order. The counsel for the petitioner submits that the issue in the list is answered by judgment rendered by the coordinate bench in so and so annexure D, page 18. The learned counsel for the respondent TB Vivekanand would is not in a position to dispute the position of law as is laid down by the coordinate bench. In that light, I deem it appropriate to dispose the petition on the same grounds that is led to disposal of the petition by the coordinate bench, so and so disposed. Until
93 minutes, review and record. It's the same covered by lordship judgment, but only one submission, my lord, what I want. Lords, after the land is deleted. Same, my lords, but.
Same.
Lords, I will not
Not
argue.
fair.
Lords, after land is deleted, no school has been constructed, my lord. With this observation, my lord, the honorable committee may be consider the constructions.
ಅದು ಮಾಡ್ಕೊಳ್ಳಿ ಬೇಕಾದ್ರೆ.
Lords, no, the honorable committee, what was.
Which, where is my order?
Let's see if it's in my.
4114 of 2025.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಅಜಯ್ ಕುಮಾರ್? ಕೊಡಿ. Why you don't get the orders?
Apologies, my lords. Mistake. I got the entire order, my lords, of this legal judge. It's got missed. Apologies.
My lord,
The-
two submission, my lords. Lordship may consider. Lords, there
I
are.
will direct them to consider if there any grievance is left out.
No, my lords, the honorable committee has to decide, my lord, because honorable
Which
committee.
committee?
The
Justice
Justice
Keshav Narayana
Keshav Narayana
committee.
committee.
Justice Keshav Narayana committee, my lords.
Committee is still in,
Please,
is
my lords,
still
is-
functioning?
Yes, my
Please, my lords.
Right, we'll
No,
see.
my lords,
We'll dispose this. If they want, let them vent their grievance there.
So I'll just, my lord, so what the honorable committee is saying is, my lord, its lordships only want to decide whether the deletion is right or wrong. My lord, what is the developments after the deletion is not being considered? My lords, after the land is
Oh,
deleted.
I will, if you have any right left after this order,
Please.
you can vent your grievance before the committee. That's all.
But
The
my lord,
petitioner
Committee
is,
may be directed to consider that.
one minute.
So-
The petitioner is before this court seeking the following prayer. The identically placed persons had approached this court in writ petition 4114 of 2025 on the same grievance. This court on 12th June 2025 by the following order rejected the petition. The learned counsel for the petitioner would submit that the issue no doubt stands covered by the order passed by this court as quoted supra, but would submit that his grievance would still remain to be considered before the Justice Keshav Narayan committee. If that be so by the committee, as what is not indicated in any of the orders is what would happen to the existing,
After deletion, my lord,
what would happen after the deletion? Deletion ಎಲ್ಲಾಗಿದೆ ನಿಮ್ದು?
this land is deleted from the accusation. After
Illi-
deletion, my
What
lord,
would happen in the aftermath of the order passed by the division bench which is followed in the order quoted supra? If that be so, it is for the petitioners to avail of such remedy, including the remedy of approaching the committee, approaching Justice Keshav Narayan committee if they have any, if permitted in law.
we
With
approach,
their,
my lord.
in,
We approach, my lord, we requested the honorable committee after deletion, school has been come up. My lord, the school is.
ಅದು
been
ಮಾಡಿದ್ರೆ
constructed.
whatever,
My lord,
we will, then the court in direction ಇದೆ ಅಂತಾರೆ.
My lord, so only with regard to the after deletion, my lord, the construction is come up, that has to be considered. Adonde observation, my lord, because my lord, the land was deleted, I constructed a school now.
No.
If the honorable committee says deletion is wrong, my lord, the every school, my lord.
Committee will take a decision.
Lord,
You already approached the committee?
So already approached, my lord, we
The
requested
learned counsel for the petitioner would further add that he has already approached the committee. If that be so, the committee shall consider the grievance of the petitioner in accordance with law. That's all.
regarding constructions, my lord.
ಅದು ಗೊತ್ತು. In accordance with law.
That's
Ordered accordingly. Yes. Both.
both.
Same order, common order.
94.
ರಮೇಶ್ ಚಂದ್ರ ಅವರು ಯಾವ್ದು ಕಾಯ್ತಾ ಇದ್ದೀರಾ?
My lords.
ಬರ್ತಾ ಇದೆ. ಬರ್ತಾ.
My lords, it's covered by, I produced a judgment in page
ಬಿಗ್
number
ರೀಚ್
48.
ಆಗಿಲ್ಲ
my
ಅಂತ
lords.
ಆಗ್ತಾ ಇರಲಿಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ತಗೊಂತ. ಎಸ್.
My lords, it's covered by, my lords, I've produced the judgment in page number 48.
Page 40, yes.
At 51, let's 51 annexure E. That this particular land was a subject matter of preliminary notification.
Covered ಆಯ್ತು.
Covered by annexure E, page 51, let's.
Page 51.
My lords, similar placed matter, my lords, I've tried moving it several times. my lords. If it
Move
may be posted
it on
tomorrow.
Monday, we'll take it on Tuesday.
Much obliged.
95.
Numbers ಕೊಟ್ಬಿಡಿ ಅದು. Covered matters ಎಷ್ಟಿದೆ?
One matter.
ಒಂದೇ.
Yes,
Vasant Kumar.
My land is secured for the formation of Nadaprabhu Kempadal level.
Huh?
Nadaprabhu
Kempegowda layout.
Yes, for which my lord the consent award came to be passed. Annexure B kindly be.
What's an objections ಹಾಕ್ಬೇಕಾ?
Meanwhile, my lord.
No, meanwhile, yes.
ಅಲ್ಲಲ್ಲ ಇವಾಗ they are going to allot the site which were already earmarked to me as an incentive site. Now they are going to create the third party rights.
Incentive.
Yes, my lord.
Yes.
2023 is the report that they are relying upon. After that, my lords, it may have been allotted. I am not aware of this.
Well,
But
we'll see.
Anand,
Wait.
Yes.
The learned counsel B. Vachan seeks 3 weeks time to file statement of objections. objections, if any, by the 5th of August. The learned counsel for the petitioner submits that the sites that were allotted under the incentive scheme to the petitioner is likely to be re-allotted to someone else. The learned counsel for the respondent submits that the petitioners are relying on a document of the year 2023. The sites may have been allotted as on today. He would require time to secure instructions. Therefore, if the sites are not allotted as on today, they shall not be allotted to any person till the next date of hearing.
Statement.
Yes.
96, hearing on IA.
Appearing for the petitioner, my lord, 1985 acquisition,
The
now possession has not been
interlocutory
taken.
law,
It is
next week
covered,
we'll
my
take.
lords.
Covered?
Yes.
Covered ಅಂತ ಅವ್ರು ಹೇಳಿ, covered?
I have, there is a history to it, Lord. This
then
court has.
History to it, yes.
Sir, there was a resolution passed to drop it.
List on 24th. Yes, next.
Hearing
Lord, I
lords.
filed my
No,
statement. of-
24th, yes. ಹಾಕಿದ್ದೀರಾ?
Hakid,
List on 24th.
please.
97.
Same, 24th.
This petitioners are members of the housing society.
24th, sir. 98 also 24th.
99.
99,
my lord, I filed an IA for
Then
impleading.
98 covered, Vivek?
For 2 weeks time to file.
Yes. Counsel TP Vivekanand seeks 2 weeks time to file statement of objections. List the matter on 5th August. Objections, if any, by then. 99.
99, my lord, I filed an IA for impleading. My lord,
Who are you?
I am the, my lord, adjacent landowner.
What's the problem?
My lord, problem is, my lord, land is acquired. My lord, they have taken compensation. My lord, he is sitting on the same land, obstructing the others.
For respondent number 3, I need
No,
to
there's
file
no
objection to the main, my lord.
No representation on behalf of the petitioner. List the matter on 24th. Yes.
My name may be shown.
Name, registry to print the name of
M.A. Subramanian.
M.A. Subramani as appearing for the counsel for the, as appearing for the impleading applicant.
Please.
Final hearing.
For the petition. Next.
24th. Ajay Kumar, 24. ನೀವೇನ್ ಈ ಕಡೆ ಇದ್ದೀರಾ?
Not one of the respondent, because already I was allotted and said it was executed in my
Got
favor.
point, yes.
Now they are challenging the sale in March.
All right, now go to further hearing. ಇದೇನಿದೆ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡಿ.
101.
2:30 PM.
My lord, copy says.
Yes, executive officer. ಯಾವ ಕಂಡೀಷನ್ ಇದೆ ಅದು? ಪೂರ್ ಕಂಡೀಷನ್ ಇದೆಯಾ? ಕೊಡಿ. ಎಲ್ಲಿದು ಘಾಟಿ ಸುಬ್ರಹ್ಮಣ್ಯನ?
No, no, but.
Temple ಇಲ್ಲೇ ಚಾಮರಾಜಪೇಟೆ, correct,
Anjaneya
correct.
Swami temple, my lords. Building stability certificate also produced, my lord, on that basis, order has.
ಜಸ್ಟಿಸ್
been
ಸೂರಜ್
passed.
ಸಾಹೇಬ್ರ ಮುಂದೆ ಯಾವ್ದಿರೋದು ಮ್ಯಾಟ್ರ್?
ಅದು ಇನ್ನ ಎರಡಿದೆ.
ಅದಕ್ಕೆ ಟ್ಯಾಗ್ ಮಾಡ್ಬೇಡ ಆಯ್ತು.
ಆಯ್ತು. ಅಲ್ಲ ಇದರಲ್ಲಿ
ನಂಬರ್ ಕೊಡಿ ಅದು.
12,182 and
Tag this petition along with WP
1,001,12812
ಬರ್ಕೊಡಿ.
21.
ಬರ್ಕೊಡಿ. Yes. List them all on 22nd.
ಅಲ್ಲ ಅಲ್ಲಿ ತಾವು ಒಂದ್ ತಿಂಗಳು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದಿರಿ, ಇವತ್ತೇ ಬೆಳಿಗ್ಗೆ ಬಂದಿದ್ರು ಎಲ್ಲ ಬ್ಲಾಕ್ ಆಗ್ತಿಲ್ಲ.
List them all on 22nd. Till the next date, the petitioner's possession shall not be disturbed. Yes.
Lordship's executive officer has to next date.
May not necessary.
My-
ಈಗೇನ್ ಇವ್ರಿಗೆ ಇರಕ್ ತೊಂದ್ರೆನಾ ಅಲ್ಲಿ?
ಅವರು ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಈಗ ಬಿಸ್ನೆಸ್ ಮಾಡಕ್ ಅವ್ರಿಗೆ ತೊಂದ್ರೆನಾ?
ಅವ್ರಿಗೆ ಸುಮಾರು ನಮ್ಗೆ 6 years ಇಂದ ಯಾವ್ದೋ ಇದು ಕೊಡ್ತಾ ಇಲ್ಲ, ಇದು
ಅದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್. ಅವ್ರು
ಏನ್ ಕೊಡ್ತಾ ಇಲ್ಲ?
ಕೊಡ್ತಾ ಇಲ್ಲ ಸರ್. ಒಂದು
ಹಾ.
ಜೊತೆಗೆ ಅದು ಯಾವಾಗ ಬೀಳುತ್ತೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಮಳೆ ಬಂದ ತೋರ್ಬಿಡೋ ಸಮಸ್ಯೆ ಆಗಿದ್ರೆ ಅವ್ರಿಗೆ ಸಮಸ್ಯೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು
No, ಮುಂದೆ ಮಿಸ್ಹ್ಯಾಪ್ ಆದ್ರೆ ನೀವು ಜವಾಬ್ದಾರಿ ಅದಕ್ಕೆ.
ಇಲ್ಲ ಇಲ್ಲ ಆತರ
Innocent people die, who's responsible?
ಇಲ್ಲ, ಅದು ಅವ್ರು ಹೇಳ್ತಾ ಇರೋಂಗ್ ಇಲ್ಲ ಅದು.
You are for private interest. Yes, we'll see. But tag that petition 22nd.
Then two.
102 may not be over.
Lordship,
Difficult. There's one smart meter also. Parted ಇದೆ.
Lordship, tomorrow, Lordship.
Tomorrow ಆಗಲ್ಲ, day after tomorrow.
24th ಆಗ್ಬೋದಾ?
20 next week ಆಗ್ಬೋದು ಅಂದ್ರೆ.
We will commence our arguments. We will commence our arguments, Lordship, day after they can.
we'll see. Oh, day after tomorrow, the Twitter matter is there. No. 22nd or 24th? 24th. 24th at 2:30 PM. I'll start at 2:30
Very
itself.
well. I'll be.
103.
A smart meter ತಗೊಂಬಿಡಿ first.
110.
103 appearing for the petitioner.
110.
103.
Madam, 103 covered alwa, earlier order. Before I start. 100 adu next week. That smart meter is, I'll finish it. One by one, let me finish.
My lords, except for a bundle of facts.
Aurda?
It has not been completed.
When he has to rebundle. No, but he has to rebundle.
Kannada or English? That it is in English and in Kannada.
That's all right. Yes, madam.
Lordship,
Nimdalla.
107, a date
Latif.
may kindly be given.
Latif is not here. Madam, wait, Madi. If he comes, we'll close it because it's covered by the earlier order that I have passed.
Lordship, serial number 107, Safai Karmachari matter.
I'll
Any
take-
date, any date?
I'll
may
take
kindly-
it, wait. You're in a hurry to leave. Yes, wait. ಹೊಳೆ ಸರ್ ಯಾವುದಕ್ಕೆ?
ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಅಲ್ಲಿ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್
ನೀವಿದ್ದೀರಾ?
ಬರ್ಬೇಕಾಯ್ತು, ಐ ಗಾಟ್ ಸ್ಟಕ್. ಹೌದು,
ಹಾ.
ಅದರಲ್ಲಿ ಫಾರ್ ಬೆಸ್ಕಾಮ್, ಐ ಮೀನ್ ಒನ್ ಆಫ್ ದ ಮ್ಯಾಟರ್ಸ್ ಐ ವಾಸ್ ಅಪಿಯರಿಂಗ್, ಐ ಗಾಟ್ ಸ್ಟಕ್ ಇನ್ ದಿ ಅದರ್ ಕೋರ್ಟ್, ಸೊ ಐ ಕೇಮ್. ಅಷ್ಟೇ, ಏನಿಲ್ಲ, ನಾನು ಮೂರು ಸೆಂಟೆನ್ಸ್ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ.
ಆಯ್ತು.
ಒಂದ್ ಸೆಕ್ಷನ್ ಅಂಡ್ ಒನ್ ಜಡ್ಮೆಂಟ್ ನಾನು ತೋರಿಸ್ತೀನಿ.
ಆಯ್ತು. Madam, you finished? Not yet begun, Anbedi.
No. Only if there any response to what they have to say. That's all.
My lord, can I request your lords look at my lord section 73 of the 70 and 73 of the electricity act for a minute.
You are appearing for Bescom, is it?
There are two matters.
Oh, one the AG appears and.
ನಾನು appear ಆಗ್ತಾ ಇದ್ದೆ. Last time my lord I got stuck in the
Right.
court which was going on.
No, ಇದೇನ್ ಸ್ಮಾರ್ಟ್ ಮೂವ್ ಯಾವುದು ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ. ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಅಲ್ಲಿ ಏನೇನೋ ಸ್ಮಾರ್ಟ್ ಮೂವ್ಸ್ ಆಗ್ತಾ ಇದೆ.
Please come to my lord section 70.
Yes.
70. It provides for
70, sir.
It provides for my
Sir,
lord
one moment.
electricity act.
Electricity Act.
Sorry, my apologies. I
No,
thought
no.
you-
You're appearing in the other petition. Yes.
Section 70, my lord, if you are not.
Section?
It provides for my lord constitution the central electricity authority. Then please come to 73.
73.
70. So
Yes.
regulations and my lord, regulations which were read out are my lord preempted in terms of section 73. Please come.
Correct.
ಅದು ಒಂದು. ಎರಡನೇದಾಗಿ my lord, what used to happen was earlier we had my lord those meters which had my lord that rotating disc.
Correct.
That my lord with the magnet my lord it could be stopped. If they remove my lord the wires my lord it will stop, and nobody can my lord the electricity officials will come only once in a month to my lord find the reading, record the reading. So my lord, now the smart meters enable my lord an online connectivity. Therefore my lord, they can monitor it my lord. If they my lord disconnect the wires, immediately they come to know of it. I believe my lord, I did not have my lord the full statistics. Nearly my lord about 20% my lord theft used to happen with this, 20 to 30%. Sorry.
I was telling
Sorry.
Rajendra.
I thought my lord my voice was loud enough.
Yes.
Then my lord, the what happened was, we my lord had to my lord go in for my lord smart meter because of the regulations my lord which the CE itself my lord has come up with my lord, which was already pointed out here lordship. One judgment I'll point out, and more than that my lord I will not. 2008 1 ESC similar 341. (163) my lord, also my lord the Electricity Act entitles my lord the Bescom to my lord change the meters. 163.
So it is statutorily permissible.
Yes. Please come to 163.
ಮತ್ತೆ ಅದು ಹೇಳಲೇ ಇಲ್ಲ.
Oh, sorry. 163 ತಾವು ಬಂದ್ರೆ.
Section 163.
Yes, madam. Power of the licensee to sorry.
Power of the licensee to enter premise, remove fittings and other
Or other
apparatus.
apparatus of the licensee. Licensee or any person duly authorized by a license may by at any reasonable time, on informing the occupier of his intention, enter any premises to which the electricity is or has been supplied by him, off any premises or land, under, over, along, across, in or upon the electricity supply lines or other work lawfully placed by him for the purpose of inspecting, testing, repairing, ascertaining the amount of electricity supplied, removing where the supply, enter the premises or land for any purpose mentioned therein, etc., etc. So, my lord, I am entitled to, my lord, Bescom is entitled to remove. Because they may say, all right, you remove my haki, free akodi anteli. That's, my lord, maybe one of the.
ಕೇಳ್ತಿರೋದು free ಆಗಿ ಕೊಡಿ ಅಂತ.
My submission to your lordship is, my lord, please have a look at one judgment. I'll give you your lordships.
ಇಲ್ಲೇ ಕಾಪಿ ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಾ ಯಾವ್ದು?
2007, 8, 1 SCC. Please come to my lord.
2008 1 SCC.
Yes, my lord. Paragraph 45.
Yes, sir.
Section 20 operates in one field, namely by conferring a power of entry on the licensee. Said provision empowers the licensee inter-alia to alter the meter, which could include replacement of a meter. It's that old act, 163, which I
new,
now,
yes.
yes. It is an independent general provision. In the absence of any statutory provision, we do not see any reason to put a restrictive meaning thereto. Even under the general clauses act, a statutory authority, while exercising statutory power, may do all things which are necessary for giving effect thereto. There does not exist any provision in any of the statutes referred to therein which precludes or prohibits the licensee to replace one set of meter by another. If such a provision is read into the statute, same would come in the way of giving effect to the benefits of the new technological development. Creative interpretation of the provisions of a statute demand that with the advance in science and technology, court should read the provisions of a statute in such a manner as to give effect there. Therefore, my lord, smart meters, my lord, today, my lord, what also happens is mobile phones. This is, my lord, something like the mobile phone only. We, my lord, either have a prepaid or the postpaid. If, my lord, we don't pay the money, then, my lord, the phone is disconnected. Here, they'll have to go physically, my lord, cut the wire. All that is not needed, my lord, sitting
So
in
it is sitting there. If there is any breach, that's
correct.
taken care
Then
of.
we'll have to go, my lord, 15 days notice. All that, my lord, we'll have to follow, my lord, the regulations and the Electricity Act and the rules and the regulations. That is why, my lord, my submission to your lordship is that, my lord, and here, what is it that we have done? We have said only, my lord, the new, my lord,
Yes, sir.
consumers, not, my lord, somebody else old. And
No, there is some ambiguity with regard to the regulations.
correct.
Last time I pointed out the learned advocate.
Three-phase and two-phase, my lord.
Three-phase and two-phase alla.
Prepaid and postpaid.
Prepaid and
Now,
postpaid.
if you come to the guidelines.
Correct. It's a prepaid.
No, guidelines alli,
Huh.
there's some confusion there.
KERC guidelines. Your
KERC guidelines, my lord, says prepaid.
No, KERC alla. Yes, madam, which page was that?
Operational guidelines.
Operational guidelines. That is Annexure B, page 39.
Correct.
Come, if you see page 40, sir.
Yes, my lord.
All new installations.
Obliged to
So it is new installations.
Correct.
Are obliged to install smart prepaid, postpaid energy meter at their cost. Correct? Provided availing power supply through the smart prepaid meter shall be option. Now it is mandatory to install the meter, but not to take power supply through the meter.
My lord, no. Smart prepaid, my lord, please mark this.
Through smart prepaid meter.
Prepaid, postpaid adra agatte. My lord, what happens is the regulations, my lord, I mean, they see, my lord, if your lordship recollects, my lord, the Central Electricity Authorities regulations and the rules, it says prepaid only.
Correct. Alli prepaid matra iradu.
Happens is prepaid.
But why did you use this slash and say postpaid?
Reason is just to, my lord, help the consumer ashtene.
ಅಂದ್ರೆ ಅದನ್ನ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೊಡಕ ಆಮೇಲೆ ಅಥವಾ ಆಮೇಲೆ ಕೊಡೋದ ವಾಟ್ ಇಸ್
postpaid ಈಗ ಏನಾಗುತ್ತೆ ಬಿಲ್ ಮಾಡಿದ್ಮೇಲೆ ದುಡ್ಡು ಕೊಡುವಂತದ್ದು ಮುಂಚೆನೆ ಕೊಡಬೇಕಿದು ಪ್ರೀಪೇಡ್ ಆದ್ರೆ ಮುಂಚೆನೆ ಕೊಡಬೇಕು
ಕರೆಕ್ಟ್ ಪ್ರೀಪೇಡ್
ಮುಂಚೆನೆ ಕೊಡಬೇಕು that my lord ಇದಕ್ಕೆ postpaid ಅಂತ ಮಾಡಿದ್ರು
So we'll
tweak that and say,
we'll take it as it is restrictive only to prepaid meters.
no my lord, please permit me to read it. Provided that availing of such supply through smart prepaid meter, postpaid my lord is permissible, prepaid ಮಾತ್ರ ನಿಮಗೆ
ಅಲ್ಲ availing such power shall be at the option. Prepaid meter ಗೆ option.
correct my lord.
Postpaid ಗೆ no option.
Would you like to look at that again? Let me read it aloud.
This is where we got stuck on the last time.
But I tell you,
Yes.
Lord, all new installations are obligated to install with smart prepaid or postpaid energy meter at their cost. So, my lord, either they'll have to, my lord, this is a mandatory requirement.
Yes.
Either prepaid or postpaid.
Correct. Installation is mandatory.
Correct. Proviso now, proviso.
Yes, sir.
Provided that availing supply through the smart prepaid meter shall be at the option. That means if, my lord, I install it, they can say, I will only take postpaid, not prepaid. Option is given to them.
Consumption charge.
Provided that availing of the power supply through smart prepaid meter. Adu yenagate ದುಡ್ಡು ಕೊಡೋದು ಕಷ್ಟನೇ. It is not, my lord, that ನನಗೆ ಪವರೇ ಬೇಡ ಅಂತ ಹೇಳಿ ಯಾರು ಹೇಳೋದಿಲ್ಲ ಇವತ್ತಿನ ದಿವಸ. Without the power, my lord, we can't exist. There were times, my lord, I remember as a kid, we have read it, my lord, read under the lantern lamps also. ನಾವೆಲ್ಲ ನೋಡಿರ್ಲಿಕ್ಕಿಲ್ಲ. Now, my lord, 1950s.
Yes.
Lantern ಹಿಡ್ಕೊಂಡು, in fact, ಅಲ್ಲಿ ಒಂದು ಆ ಗ್ಯಾಸ್ ಇದ್ದು ಒಂದು ಬರ್ತಾ
ಇಲ್ಲ ಈ ಲ್ಯಾಂಪ್. Yes.
Therefore, my lord, this is prepaid, my lord, is optional. But if you look at the top, first line, post or prepaid, my lord, is mandatory. Therefore, my lord, that will have to be, proviso will have to be, my lord, only restricted to that, my lord, thing. Ultimately, my lord, as was pointed out by, my lord, the Supreme Court, Justice Sinha in that judgment, innovative approach, my lord, is not, it is absolutely needed. Ultimately,
even the last occasion.
There is also, my lord, a clarification issued
by
on 19.5 by the Electricity Regulatory Commission itself.
Page?
R6, page 41. Your Worship.
No, I am at 41, page 41.
That is statement of objections.
Objections 41.
Statement of objections, my lord. Is present, my lord, one aspect what my lord is saying, operational guidelines is only for internal purpose, my lord. The question is ultimately.
But you are now charging the customers on your internal operative
No,
guidelines.
we are not charging. There's no such thing, my lord. Your Worship may kindly see
41.
R8 in my learned friend's petition, my lord.
No, page 41 ಏನು clarification ಏನು ಹೇಳ್ತಾರೆ.
R8, my lord, is page
129.
129.
In the, that is WP number, my lord. 12987. Your Lordships, I got WP number 12987, my lord.
129. R8.
R8, my lord. No, R8, my lord.
Correct. 129, I am there.
Please, my lord, your Lordship may kindly see in the light of the above reference, the commission
The
hereby.
billing of temporary installation shall be in prepaid mode only.
Correct, my lord. Then in the middle of the paragraph, my lord, after serial number 4.
In the light of the above reference.
In the light of the above reference, my lord. In the light of the above reference, the commission hereby informs the following. All new connections except IP set shall be serviced with smart meters, and the billing of all temporary installation shall be through smart meters, brackets, my lord, Central Electricity Authority installation. So then last sentence import, the billing for temporary installation shall be in prepaid mode only. The existing customers who opt for prepaid billing shall replace the existing energy meter with smart. So therefore, my lord, insofar as existing is concerned, is optional, and only insofar as new installation is concerned.
Yes, sir.
My submission to your lordship says, ultimately, my lord, point is only this. Smart meters is absolutely essential. Question is, my lord, whether it is postpaid or prepaid. Even, my lord, mobile phones, when your lordships, my lord, we are all, my lord, today so addicted to mobile phone. Without it, my lord, we feel we are lost. There is either postpaid or prepaid. So is, my lord, here. The mobile phone is mandatory. My lord, I'll put it that way. Electricity, my lord, smart meter is mandatory. Either, my lord, postpaid or prepaid. The proviso, my lord, would, as I was pointing out, my lord, in page 40, proviso says prepaid meter, my lord, or postpaid option is given to them. So, my lord, they can have, my lord, a smart prepaid meter at their option, which means, my lord, out of the two, they choose only, my lord, the prepaid, not the postpaid. That's how, my lord, I would say. And that's why, my lord, I would say, ultimately, my lord.
This is statutorily permissible.
Yes. Statutorily permissible, Allah. Innovative, my lord, ultimately, my lord, it is this. Today, we are at a stage, my lord, where electronically, my lord, that's what, my lord, the Honorable Supreme Court also has held. We have to, my lord, travel with the time. The technological innovations, my lord, must be adopted by us. We can't, my lord, be in the old era, my lord.
So you say you should innovate and renovate.
And if your lordship sees, we have, my lord, we invited, my lord, bids. ಅದು ಇನ್ನೊಂದು ಇವರು AG ಅವರೆಲ್ಲ ಕೊಡ್ತಾರೆ ಅಲ್ಲ ಅವ್ರು ಕೊಡ್ತಾರೆ ಅಲ್ಲ ಅವ್ರು ಕೊಡ್ತಾರೆ ಬಟ್ ವಿ my lord, please look at my lord, ನೋಡಿ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟರೆ These are the, my lord, the bids were this. Actually, my lord, it will come to, my lord, 5,192, but we are, my lord, giving them at 4,000 and odd. All these are, my lord, OEMs, original manufacturers, not, my lord, somebody else. Would your lordship look at, my lord, Genus, HPL, Inkwell and Snyder?
Snyder, that's there. Yes.
They are all, my lord, original manufacturers.
Meters from all these
Yes, we
companies.
got, my lord, because ultimately, my lord, we also did not want, my lord, to saddle, my lord, consumers with something else. And, my lord, somebody, my lord, offers a higher amount. So we wanted to know, my lord, what was the actual, my lord, manufacturer's cost. This is what it is. Therefore, my lord, note 60 in the same, my lord, please come to, my lord, page 3. Sorry, 16 already. Page, my lord, 1, 2, 3, 4. My lord, andre second, my lord, sheet. Last page. 16 anta barutte tamge. Manager SGL and AGM SG anta barutte.
Ellello.
Sorry.
Ellotade.
Ade ನಾನು ಈಗ ಕೊಟ್ಟನಲ್ಲ.
ಈ ಕೊಟ್ಟಿದ್ದೆ.
ಅದರಲ್ಲಿ my lord, please come to ಇದಕ್ಕೆಲ್ಲ page number ಹಾಕಬೇಕು.
Which page,
Page
sir?
4. Sorry, my lord. My apologies.
Breakup of ಎಲ್ಲಿದೆ page 4.
Manager ನೋಡಿ second page ತಗೊಳ್ಳಿ.
ಹಾ.
Second sheet.
Yes.
ಅದರದ್ದು back side of second sheet. Manager SG and AGM SG ಅಂತ ಬರುತ್ತೆ. ಟಾಪ್ ಅಲ್ಲಿ my lord. ಎಲ್ಲ page number. ಅದಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಈಗ small ಅಂತ ಕೊಟ್ಟೆ. ಅದನ್ನೇ correct.
Page 4 of that.
Page 4 ಹಾಕಲಿಲ್ಲ. ಹಾಕಬೇಕು ಇದನ್ನೆಲ್ಲ.
ಅಂದ್ರೆ page I am at the 4th page literally.
Correct my lord.
Not
As per the
figuratively.
kind approval accorded ಅಂತ ಬರುತ್ತೆ ನೋಡಿ ಟಾಪ್ ಅಲ್ಲಿ.
Manager SG and AGM SG.
As per the kind approval accorded, comparison the price quoted by the bidders with the average market price is shown. Then, my lord, 5,193, 5,949, 6,000.
This is not a part of the earlier records produced?
ಇಲ್ಲ.
Why not placed on record?
ಇಲ್ಲ. ನಾನು ನನ್ನ ಹತ್ರ ಇವ್ರು ಕೊಟ್ಟಿದ್ರು, ಇವ್ರು ಇಟ್ಕೊಂಡಿದ್ರು. ನಾನು ಅಲ್ಲಿ ಸ್ಟಕ್ ಅಪ್ ಆದೆ. AG ಅವರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
Yes.
Therefore, my lord, my apologies to your lordships and to my learned friends also.
Now, the average market price 5913 quoted by L2.
Correct. At the beginning ಅಲ್ಲಿ ಬರುತ್ತೆ.
L1 bidder after negotiation comes down to 4998.
4998. This is what, my lord, we have and my lord, please look at it. More important is this gentleman, my lord, the petitioner Harish. He is, my lord, his house is, my lord, new house.
That they told, yes. No house at all.
Old house is there.
Then is this the same petitioner before the division bench? Different petitioner. Al division bench on PL pending.
Pleadings alla same adane alli delli hakidare.
No, it's a different petitioner.
Petitioner ಬೇರೆ.
Yes.
But pleadings are the same.
Yes, Panindra sir.
Grateful to you.
Just take five
ಮುಗಿತಲ್ಲ?
Just take 2 minutes, Madam. I'll just take 2 minutes to just conclude, Madam. Apart from the fact in both the petition, we have filed an objection saying, Madam, they are existing meters, so no new smart meter is required. So therefore, Madam, in spite of that, the fact that they're seeking to say that I want to put the smart meter is only goes to show, Madam, the intention is not that they are aggrieved person at all, Madam. Second aspect, Madam, to show that is abuse of process, the fact that the pleadings, again I want to point out, Madam, saying that they're not able to get an interim order before the division bench. Similar petition.
It's a PIL, right?
It's a PIL. And the fact that the pleadings and the prayer are identical, Madam, and before
PIL interim order. Generally.
No, the point is this, my lords. It rarely does a pleading in a, therefore, what is the question the petitioner is aggrieved by? In a petition, when we file a statement of objection saying that the petitioner is not required because he is an existing customer, as per the central government regulations as well as the KESC direction, my lords, what it says that is insofar as all new connections are concerned, my lords. So therefore, my lord, the petitioner is not a new connection, my lord, is an existing connection. Then what
so he is not aggrieved at all.
Is not aggrieved or not affected by this at all, my lord. Then coming to what is sought to be challenged is the operational guidelines, my lord. By operational guidelines, my lord, there is, as what your lordships are pointing out, it is only for internal governance, my lord. Your lordship I'm making a statement and I filed my affidavit. Also,
so based upon those internal
guidelines,
you are not going to charge the customer.
Not charge what is being sought to be charged pursuant to a tender which was sought to be issued, my lords.
But this statutorily thing was not never brought to my notice. Why? Yes, we'll see.
Please, my lords, we should have bought. Your lordship, may kindly see the affidavit which we have filed before your lordships, my lords, on dated.
My apologies. I should have been there.
No,
on that
that's-
day.
that's all right.
I should have been here. Got stuck in the other court.
If you have divided your arguments, I didn't know that. Because first time I'm saying you in this case, at least 10-15 hearings have happened now. That's why, yes.
My lord, the two important documents is, my lords, Annexure R7 in WP number 12987 of 2025. Annexure R7 is the letter dated 6 February 2024, my lords, which clearly says, I'll just read that, my lords. From 1st April 2024, distribution shall license shall provide smart meters to all new installation. That is one document, my lord. The second document is 9th May 2025, which clearly says that all new collection except IP sets shall be serviced by smart meters. So therefore, my lords, we are speaking only about all new connections. Then what is important, what your lordship asked us, my lords, whether we are the 75 rupees which we are transmitting, my lords, what we have stated in our petition is, I state that I state that the charges to be paid on monthly basis amounting to rupees 75 is not being passed on to the consumer, irrespective of the fact that the consumer has availed of the smart meter or not. What was thought to be stated that they are agreed.
Whether you avail of it or not, you have to pay.
No, we are saying that the BESCOM is bearing this. That is because the respondent will save money on infrastructure and logistics such as meter reading instrument, battery on meter reading instrument, paper for meter reading instrument, errors in meter reading which results in financial loss, increase in cash flow.
This I saw. This
affidavit.
This affidavit you have shown. But hold on, sir, there was one argument saying that what the learned advocate general is now trying to answer, that whatever the case, you want to install smart meter, no, don't install, consumer will have to end up paying up.
No,
money
that is what I have stated.
No, that's the affidavit, but the effect is that.
No, my lords, we are saying that we are not charging them. There's no effect. My lords, we are saying on affidavit before your lordship, what was read out to your lordship in that notification page, para 16, apart from para 16, my lord.
We'll continue on Friday. Yes. Thursday, Twitter is there. In the Mugitala, response to response.
That's only one. Pass madla. Lords, may I just pass on before, let me finish.
Judgment idre kotbidi.
Judgment alla.
Wait, Pandindra sir has not started even. Yes. Lush, that had to be part of the document. What Holder sir has now given ought to have been part of the statement of objections at least. That clinches the entire issue.
Lords.
Allah doesn't even Allah. Now see, that shows that it is the process of tender, and pursuant to the tender it is awarded. Decision is taken by the tender scrutiny committee. All right, you respond. That is why I'll take it on Friday. But that ought to have been why you did not produce it.
Last week.
What are all the documents in your command? Why you did not produce it?
No, this was not in their command. They said they would want to produce it and they had to manufacture it. The reason being, your lordship,
how can proceedings of the government be manufactured, madam?
Genus is the same distributor for Rajasthan. He cannot have different rates in Karnataka and different rates in Rajasthan. Genus is the very same manufacturer.
What is the rate in Rajasthan?
Rajasthan, the rate is the 900 rupees and that balance small 60 rupees is paid per month. How can Genus be selling it here at 5,000 rupees and in Rajasthan that 900 plus another 1,000 rupees?
I will hear Pandindra sir on this and then get back to you.
Please take this.
No, that is central government scheme. Alinda you get.
For the court.
And for them. That you should have collected everything that is due from the government by the BESCOM and the electricity companies. ನಮ್ಮ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ, ಅವ್ರ ಹತ್ರನೂ ದುಡ್ಡಿಲ್ಲ, ಇವ್ರ ಹತ್ರನೂ ದುಡ್ಡಿಲ್ಲ, ಎಲ್ಲ ನಾವು ಬಸ್ಸು ಇದು ಎಲ್ಲ ಫ್ರೀ ಕೊಟ್ಬಿಟ್ಟು ನಮ್ಮ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ. Therefore, we could opt for that RSDS scheme. RSDS scheme ಅಲ್ಲಿ 900 rupees is what is being
subsidy.
Subsidy only 900, nothing more.
So in those states, the states have not availed of the scheme. Not availed of the scheme,
No, no,
correct?
if they have availed, my lords, RDSS scheme, the subsidy given is between 900 to 1,200, 1,700.
ಈಗ ಸಬ್ಸಿಡಿ ನೀವು ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ
Because
ತಗೊಂಡಿಲ್ಲ.
Government of Karnataka has not taken?
ಇಲ್ಲ, ಅವ್ರ ಹತ್ರ ದುಡ್ಡು ಇಲ್ಲ.
Yes, I
ಆದ್ರೂನು
think if my
Westcom will not
One
collect
minute,
from them.
one minute, madam. That's not,
RSDS scheme, my lord, we can't avail because, my lord, that's RDSS. We have to, my lord, ensure that, my lord, every penny, last penny that is owed by the state government to the, my lord, we give subsidies for the farmer. Everything should be paid back. Nam hatra ದುಡ್ಡು ಇಲ್ಲ. Therefore, we did not opt for it. There are 2 other states, 3 other.
so this has to be paid back.
ಎಲ್ಲ ಇದೆ.
No, they did not.
My
They were
lords.
eligible.
ಈಗ ತಾವು
They had to show, my lord, zero debts.
Delhi.
They brought
Lords,
it to
if
zero
your
debt.
lordship
They
takes
were
the
to
table
take
for
it.
a moment, the color graph,
No, on Friday.
based on, yes,
Friday you complete.
very well.
Yes.
That's
Take it
based
at-
on their documents. I'm not traversed any other document.
Continue on Friday if there's anything, yes. Any of you on anything. But there appears to be some clarity today.
And it would be back to again
No,
a foggy
no.
area. Your lordship, we shall clarify that also.
If,
There is no
if
clarity.
changing of, sorry, that is what, you innovate and renovate.
No.
So
Innovate, renovate.
innovation
from that
has
end.
taken place in technology, renovation has to take place in the meters.
From the very beginning, we are trying to say that we would not have any problem with smart meters. In fact, we would welcome it, even if it is
Then-
not the RDSS scheme, even if it is not the RDSS
That's all right,
scheme.
then what is
Comes down to
unwelcoming here?
The pricing. Why should we as citizens have to pay thrice the amount of anybody all over India, irrespective of
PIL.
RDSS? No.
That isn't
I as a
PIL.
consumer, that is not part of PIL. PIL is part of the entire process of tender, which is
So
a
why
very
should
fraudulent.
every consumer pay is PIL?
No. Why should I pay?
Then
And-
no problem, we'll consider your payment.
Yes, and your lordship, the letters that they refer to cannot be given any kind of statutory meaning. Ultimately, are the guidelines in violation or not is the issue. Next is whether they are in conformity with the pricing according to their very own documents. If KRC says the price of a
Right,
smart
Friday.
meter is 2,000 rupees. it
Friday,
cannot
first
be-
I will hear
We
Panindra
get
sir.
a chance.
Why?
ಹೇಳಿದೆ.
ಇಲ್ಲ,
Friday.
ಏನಾರ ಮಾಡಿ. Friday 2:30 I will start.
Please.
You finish it.
You are so kind and considerate. ಯಾರ್ ಬಂದ್ರು ಇಲ್ಲ ಅಂತ ಹೇಳೋದಿಲ್ಲ.
ಇಲ್ಲ, ತಗೋಬೇಕಲ್ಲ.
First ಬೆಳಿಗ್ಗೆ ಎದ್ದು ನಿಂತ್ಕೊತೀನಿ.
ನಮ್ಮ ಹತ್ರ ಸ್ಟಾಪ್ ವಾಚ್ ಇರುತ್ತೆ.
ನಿಮ್ ಯಾವಾಗ ನಿಲ್ಸಿದೀನಿ ಮೇಡಮ್? ನಿಮಗ್ ಯಾವಾಗ ಸ್ಟಾಪ್ ಮಾಡಿದೀನಿ ಹೇಳಿ? ಇದು I think 15th time we are arguing the matter.
Your lordship, they keep coming up with new papers.
What, no,
But we have to keep
15th time
covering
we are
them.
arguing the matter. Where stopwatch is
They
there?
should stop with their papers, your
Then
lordship.
here, then henceforth we'll put a clock.
Yes, if the manufacturing stops, we shall stop too.
Smart meter.
Please.
Yes.
Grateful.
So that more matter.
230 more matters. Order seal number 1, Prithvi Shankar.
Enough, madam.
The office of Section 14 not paid, it's paid.
Yes, Prithvish.
Objection is court fee is not paid, my lord. They have paid the court fee. I have
Court
the
fees
receipt.
not paid will not grant
My lord,
any.
they have paid the court fee, my lord. I have the receipt. Before, my lord, the objection was raised, I have paid the court fee. my lord.
ಏನ್ charge taken na?
ಇಲ್ಲ charge, my lord, I have aided school teachers, my lord. I am due for retirement this month. My lord, the
Transfer ಮಾಡಿದಾರ ಈಗ?
transfer ಮಾಡಿದ್ದಾರೆ. At the instance of a school authority, my lord, the society, of which I am no more a part of, my lord. The school in which I was working closed, my lord. I was transferred to.
Pursuant to counseling?
No, my lord. No counseling is conducted.
Yes. Hmm.
My lord, I
ನಿಮ್ separate
granted-
guidelines ಇದೆಲ್ಲ ಎಲ್ಲಿ?
My lord, the guidelines, I've taken that contention, my lord. I have not annexed the guidelines because it's a part of the rule book itself. my lord.
Where is the rule?
My lord, rule book alliತ್ತು.
ಏನು
Therefore, I'm
ಪ್ಯಾಡು
sorry.
ಬ್ಯಾಟು ಇಲ್ಲದೆ ಕ್ರಿಕೆಟ್ ಮ್ಯಾಚ್ ಬಂದ್ರೆ?
The counseling is not conducted, my lord. They have taken that specific contention. But in the first petition, my lord,
Ken, what has happened now?
I'm transferred, my lords, to another school in Bangalore when I'm working, my lords, in Srirangpatna under a different society. One, without conducting counseling. Second, at the instance of the transferee management. When I'm working, my lords, in another school, the commissioner, my lord, would pass an order
Where
without hearing.
respondent? Spurti, court all 8 no yarilva?
I will take notice.
Take Leonard, HCGP is directed to accept notice for respondent 1, 2, 3. Emergent notice to the 4th respondent. The 4th respondent be served by the petitioner by way of hand summons. 4th and 5th respondent. The
Very well.
petitioner shall not be relieved if not relieved as on today.
Leave. Oblige. I'm sorry, my lord, I didn't come.
Ella tagom barbek. Prithvishan coming like
I'm
this.
sorry, my lord.
What
I-
is this?
I'm sorry, my lord.
Yes.
Bill number 2. Dhananjay.
GMCPC. Yes, sir.
I have to respond it. I was on
Caveat
caveat.
without knowing that.
I've been served at 11:30.
KVA ಇದ್ರೆ 2:30 ಮೂವ್ ಮಾಡ್ಬೋದು.
2:30, that is not correct. My
ಏನ್
colleagues have
urgency
not
ಏನು?
noticed.
Tomorrow, my lord.
Hello, tomorrowನೇ. What is the urgency?
Urgency is, my lord, the court has permitted to amend the suit.
ಅಷ್ಟೇನಾ? ಅದಕ್ಕೆ ಯಾಕೆ 2:30 ಮೂವ್ ಮಾಡಿದ್ರಿ?
Arises out of the same cause of action. It is only adding additional amounts.
No, but why 2:30 ಮೂವ್ ಮಾಡಿದ್ರಿ ಅದು?
Yes, sir. That's not, actually, I wanted it tomorrow.
My lords,
List on Friday. When is the next date there?
next date is on 18th, my lord.
17th.
17th, 18th?
18th is the
18th
next,
is a
18th
case.
is Friday.
18th ಇರ್ಲಿ. List this on 18th.
Please.
Objections ಏನಿದ್ರೆ ಹಾಕಿ.
2:30 or.
Why 2:30?
Will it
You want to
come?
finish
It
civil
will be
court
the
and come,
normal
is it? Come here first, yes.
My lords, oblige.
Number 3.
Same matter. Same matter. I'm due for retirement in April 25th. That's
Same,
the-
serial number 1 ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದೆ ಅದು?
Oblige.
Office objections to be complied with in the meantime ಅಂತ ಮಾಡಿ.
Very well.
Yes,
ಇದ್ರಲ್ಲಿ
next.
ಏನಿಲ್ಲ. Only
ಅಲ್ಲ,
first
first one ಅಲ್ಲಿ.
Very well.
Next. Sagar,
Number 4. Withdrawal.
Sagar Shastri. Withdrawal in terms of memo, yes. Ashana? Yes. What happened to those Dharwad? ಎಲ್ಲಿದ್ರಿ ನೀವು? 2:30ಗೆ ತಗರ್ದೆ ನಾನು. Wait, I'll finish off the further hearing and call out the list. All further hearing matters will be on 1st August. I don't know about the planetary position later. So 1st August will take.
Serial number 109, please.
Adonದು wait, CBI ದು wait.
Yes, please. Oblige.
Other matters.
30th.
ಅದು 1st August. ಎಲ್ಲ. ಈಗ ದುಡ್ಡು ಬಂದಿದೆ ಅಲ್ವಾ ಈಗ? ಎಲ್ಲ ಅನಿತಾ ಮೇಡಮ್, ಎಸ್.
He's here.
93 government orders ಅವ್ರಿಗೆ ಬಂದಿದೆ, 150 government orders.
ಆಯ್ತು, ಈಗ 93 ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಲ್ವಾ? ಇನ್ ಮಿಕ್ಕವ್ರಿಗೆ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ಫಾರ್ ದಿ ಪ್ರೆಸೆಂಟ್ ಯು ಹ್ಯಾವ್ ಗಾಟ್, ಜಸ್ಟ್ ಕೀಪ್. ವಿಲ್ ಟೇಕ್.
115 ನಲ್ಲೇ ಸುಮಾರು ಜನ ಇದ್ದಾರೆ petitioners.
ಆಯ್ತು, 1st August ವಿಲ್ ಡಿಸೈಡ್ ಇಟ್. ಬಿಕಾಸ್ ಇದು ನೆಕ್ಸ್ಟ್ ರಾಸ್ಟರ್ ಗೊತ್ತಿಲ್ಲ, 28 ಚೇಂಜ್ ಆಗುತ್ತೆ. ಸೊ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ ಫಸ್ಟ್.
There is one more batch petition, I'll give the number.
ನಂಬರ್ ಕೊಡಿ.
ಅದ್ರಲ್ಲಿ ಎಲ್ಲ 115 ಅವ್ರು ಬಂದ್ರು.
ನಂಬರ್ ಕೊಡಿ, ವಿಲ್ ಸಿ.
Highly grateful.
30, that dental college matter.
We will see, sir. You are not there.
I was here. 3:30, your lordship said that you would take.
3:30ಗೂ ಕರೆದ್ನಲ್ಲ.
3:30.
ಹಾ.
3:30, list was continued, therefore we.
Yes. ಅಲ್ಲ, ಇದು ತಗೊಳ್ಳಿ. All other further hearing matters on 1st August. Interim orders will continue. Except that CBI one and yes.
Matter pertaining to Dharwad bench.
Forward, yes. Yes, Rahul. You wait, madam, 1 minute. If you find Latif, get him. Do you know Latif? If you find, get him, or I'll post it on Friday. We'll post it on Friday. Yes.
Lords, yesterday, my lords, I brought your lordship's attention the relevant rule in the 1994 rules frame.
In one ನಿಮಿಷ, ಬೇರೆ ಯಾವ್ದು ಬಾಕಿ? Yes.
Lordship may kindly see rule 42.
Rule?
42 of the 1994 rules.
Lords. Transport of minor minerals. Yes.
the entire controversy surrounds around this, my lords. Is in this rule where we find may be permitted to be, no person shall transport or cause to be transported any mineral except in accordance with a computerized mineral dispatch permit. This MDP has been extensively referred both by the respondent and by the petitioner, my lords. Lords, the allegation leveled against the petitioners is this, my lords. There are two agencies who are the mine owners, from which the petitioners have transported mine and thereafter exported. The two agencies in question pertinently to the petitioners are one Amalgiris, two Priyanka
Correct.
agencies. The allegation leveled is that, my lords, without mineral dispatch permits, they have transported. Though contrary, there is a mineral dispatch permit, but, my lords, the contention of the respondent is that they were fake. My lords, to substantiate that contention, my lords, had produced memo along with documents dated 7/7/2025. Lords, I have also extracted the chart indicating the permit number, the name of the parties, the amount of quantity which is transported, and the relevant evidence indicating the non-supply of it. The lordship sees page 4 of my memo. Lords, there are certain statements which I would like to bring to your lordship's attention. If your lordship sees page 16 of my memo, which learned senior counsel referred to as clause 7. In various other agreements, it's clause 7, clause 8, clause 9.
Memo. ಇದಲ್ಲ ಮೆಮೊನ ಇದು ಪೆಟಿಷನ್ ಇವರು ಹಾಕಿರೋ ಮೆಮೊ ಅಂತ ನೀವು ಕೊಟ್ಟಿರೋ ಮೆಮೊ ಅಲ್ಲ.
Yesterday, my lords, I was.
Yesterday you've given.
Yesterday I had given. The lordships.
Oh, that memo. Yes, yes. All right. Wait. You continue, madam.
Let's have another. I have another copy if your lordship.
Kodi. Yes, better. It's on my table. I was reading it.
Please.
Yes.
There is no memo, my lords, an office call.
It's all right.
Please see page 16, my lords.
Page 16.
Yes, my lords. The numbering is done on the right hand corner because there is overlap.
Yes, yes.
As if your lordship sees clause 9.
Seller to furnish valid DMG.
That is the crux of the case, my lord, saying we have exercised diligence on the paper, saying only if there is a permit, we would take iron ore from it. That is the main case.
So you mean KVA tempter.
Yes. If your lordship sees.
So ultimately on KVA tempter.
Yes, my lord, the thing is, all these mineral dispatch permits were forced. They were fake, to be honest.
No, mineral dispatch permits is not by the transporter.
Please.
Oh, this transporter is forced all this and transported iron ore is your case.
Please.
All right. Yes.
Please, to substantiate that, my lords, I'd produce certain documents. If your lordship sees page 57, though the chart indicates extensively which are the witnesses who point out to that, I will point out 4 to 5 statements, my lords. If your lordship sees.
To be supplied along with the invoice. All right.
Page 57, my lords. The statement starts at page 55, who's CW 59, who's proprietor of SV Traders. The relevant portion is at page 57. On further being asked by the IO, I state that Shri Philip Jacob, partner of Mrs. Amalgiris, the two agencies in question which have supplied to the petitioners. One is Amalgiris and the other is Prem. Mrs. Amalgiris has claimed that I have supplied about 54,000 metric tons of iron ores under 4 DMG permits, so and so, which is not correct, as the material were supplied to various other traders through Mrs. SMSK Minerals Trading Company, Hospet. The contention of Shri Philip Jacob is totally false, and I have never supplied any iron ore to his company, and I never received any payments from his company. Lords, further, if your lordship sees page 68, my lords. My lords, this is in connection with the accused, who is also one of the petitioner named Eriswamy.
Yes.
This statement is relevant to his case, my lords. If your lordship sees page 68 of my memo,
Iron ore was moved without MDP and payment was made so and so.
Sri Gangadhar Vedamurthy and Vishwanath,
Yes.
through Sri Tahir broker, purchased around so and so iron ore from Eriswamy and Manjunath.
Mm.
Eriswamy JSW insisted that payment is to be made through cash and no invoice will be given. Sri Eriswamy, Manjunath and Tahir were having good rapport with so and so, having iron ore mines at called as SB Minerals so and so, were procuring iron ore without invoice and selling it to others without invoice after receiving the money in cash. This is the iron ore moved without MDPS and sold off record. As if your lordship sees page 71, my lords.
No MDP will be obtained with the
Please.
minerals, supply of minerals. Yes.
Lords, the next
Same at page 72.
76, please.
Yes.
Lords, this would prima facie indicate, cast a cloud of conspiracy. Lords, this is not a case of 1 metric ton or 2 metric ton. This is
The
a-
allegation against them is conspiracy.
Please.
Yes.
And receiving of stolen property.
That is
Lords, because the rule
379.
says the minute a mineral is extracted from the earth without a permit or without a permission, that falls under the clutches of theft under the penal code. Lords, the moment I receive some stolen property, ex facie indicates attracts 411 on me. So the prime contention is 120B read with 411. Lords, to substantiate the claim, Lords. Lords, I'll produce one judgment indicating conspiracies, which is pretty well settled. Your lordship may kindly see. Lords, para 74. I'll just Lords, para 74 at page 767, if your lordship.
I'm there.
Please. The courts, however, while drawing an inference from the materials brought on record to arrive at a finding as to whether the charges of the criminal conspiracy have been proved or not, must always bear in mind that a conspiracy is hatched in secrecy, and it is thus difficult, if not impossible, to obtain direct evidence to establish the same. The manner and circumstances in which the offences have been committed and the level of involvement of the accused persons therein are relevant factors. Please note this, my lords. The level of involvement of the accused persons herein are relevant factors and the way they have committed. But for the said purpose, it is necessary to prove that the propounders had expressly agreed to or caused to be done the illegal act, but it may also prove otherwise by adduction of circumstantial evidence or by necessary implication. Lords, though there exists an agreement, Lords, just by insertion of a clause and not following it in letter and spirit indicates, Lords, by adduction and the subsequent conduct of conspiracy. Lords, with respect to caveat emptor, Lords, because there is an agreement, I would like to produce one citation.
Sorry. And third.
Please. Though my lords, learned senior counsel was right in indicating this is a common law doctrine,
yes,
which I also agree, but it has been consistently followed by both the apex court and honorable courts, even till date, in spite of legislative enactments. This is one such instance, my lords. I'll bring to your lordships. Let's kindly see para 13 and 14.
1-3.
Please, ma'am. Your lordship will find that at page 26.
It is for the buyer to establish.
My lord, please. It is for the buyer to establish that he had no knowledge about the genuineness or otherwise of the SIL. My lords, your lordship kindly see the facts of this case, my lords, for a moment. Let's kindly see para 3. The case of the department herein is customs department, was that the special import license was purchased by the importer from the brokers for clearance of gold and silver was forged and therefore was not valid for the consignments in question. More or less the same stand taken by the petitioner. Milords, in that case, invoking both Customs Act and Sale of Goods Act, the apex court was pleased to hold at para 13, it was for the buyer to establish that he had no knowledge about the genuineness or otherwise of the SIL in question. The maxim caveat emptor is clearly applicable to a case of this nature.
Yes.
Lordship may kindly permit me to read the next paragraph. As per so and so, caveat emptor means let the purchaser beware.
Correct.
It is one of the settled maxims applying to a purchaser who is bound by actual as well as constructive knowledge of any defect in the thing purchased, which is obvious or which might have been known by proper diligence. This is exactly where I'm banking my case upon, my lords. Caveat emptor does not mean either in law or in Latin that the buyer must take chances. It means that the buyer must take care. Lords, your lordship may kindly see para 18 as well, the same judge.
1-8.
Please. Whether the buyer had made any inquiry as to the genuineness of the license within his special knowledge, he has to establish that he had made inquiry and took requisite precautions to find out about the genuineness of the special import license which he was purchasing. Milords, it is one thing to say I have imparted a clause and there exists a clause and there was a mineral dispatch permit. Milords, this is a very niche area, Milords, where there are limited players and they, in fact, more than investigating agencies, they have specific domain knowledge and expertise.
So they should have taken note of
Basic due diligence, if it would have been done, the cost of criminal conspiracy would have not been come. Milords, the very fact that thousands of metric tons were being exported on mineral dispatch permits, knowing there are so many, Milords, consistently throughout the charge sheet, witnesses have spoken that we have never supplied it. In fact, Milords, the petitioner...
That's the public servants. Public servants.
Public servant would say the reason why public servant statement was relied upon by the petitioner was that it is not in the domain of my control. The port, in fact, Milords, there's one thing I would like to bring to your lordship's attention. Milords, the port, though, is controlled by the port conservator. The port conservators had entered into agreement with Adani, who were the stevedores. Therefore, the inlet, outlet, the cargo carrying in was controlled by Adani, which is a private entity. And in fact, the petitioners and Adani also had an agreement to that effect. Therefore,
if my lords permit, my lords, with great respect, my lords, I just would like to know the citation. But just to I missed it.
This is on caveat emptors, 2009 11
Yes.
SEC 18.
2009
11 SEC
No.
page 18.
Apologies, I should have furnished
It's
advance
not
copy.
down.
ಅವರು ಕೊಟ್ಟಿಲ್ವಾ?
I've given them, but
2009 11 SCC.
Page
My lords, page number. Page
18.
number.
18.
18. Thank you. Grateful.
Plus, there was one more question posed that there was a averment in the charge sheet that there is no role of public servants. Lords, the reason there is no role of public servants is because of this agreement entered. It is the Adani, which is the stevedore, who controls it. Therefore, public servant has a role in issuing the mineral dispatch permit to an extent, but not in verifying when it is entered into the port to verify whether there exists a mineral dispatch.
So he is going to issue MDPs without looking into anything?
No, he does not issue MDPs. The Department of Mines and Geologies issues MDP. The same is verified at the port before exporting. But that port is being controlled by Adani.
That's all right. Those MDPs are issued how without verification?
No, the MDPs are issued with verification. That is exactly they have forced it.
Yes.
MDPs were there. These witnesses to whom I have referred, those are the very MDPs which were issued to them by Mines and Geologies, have been forced to say that I have bought from them, whereas they would come on record and say I have never sold it.
All right, we'll see. Ashtananda,
please.
Yes. Sir, we'll continue tomorrow.
Please.
Naidu, sir.
Millets, can I finish that, Millets, if my lords permit?
You can finish it and finish it, sir. Yes.
Apologies, Millets. One more point which they addressed regarding delay. Millets, this was a case which was taken up to Supreme
No,
Court.
that
and
delay in other cases we have considered.
Please, that. Grateful, my lords.
Yes.
Today that matter was there, Gali Anjana temple, therefore I was unable.
All right, no problem.
Kindly pardon.
Yes, sir.
Millets. First things first, Millets.
Yes.
My learned friend has made a valiant effort with good articulation. And
Yes.
Millets, let me answer that very briefly.
Yes.
Millets, I've been facing one particular allegation that I've conspired with them.
Yes.
And
That's
my
the
lords
crux
have-
of his submission also.
Yes, Millets. And my lords have very pertinently put a question to the learned Standing Counsel for CBI. What does it amount? What amounts to conspiracy? And your lordships have also queried whether an allegation in itself becomes a conspiracy, or a conduct on my part which is express and imbued with a mens rea. For that, their justification is, look, he has exactly forged it with sort of some expertise, and that's why poor port officials could not decipher which is right, which is wrong, or which is rather fabricated, which is original. So please have a generous heart and leave them. Whereas uninitiated, a simple businessman should possess the expertise to know with the naked eye, after it passes through many echelons of checks and balances, that it had been forged. So that's why they have not added the officials, but added somebody who has been no expert in that field and who has not been cost any responsibility. Now, Millets, I'll come to a very favorite subject, that is caveat emptor. And the question is that, Millets, if somebody has been negligent, let me put it this way so that I can borrow his argument, Millets, my friend's argument. If somebody has been negligent, does it amount to a criminal conspiracy? Suppose, Millets, I don't verify a title of my vendor, I purchase the property, I take the consequences. If my vendor had a sale deed forged in his favor from the true owner who never sold it, and he in turn sells it to me,
So you'll
just
be
because I've not verified the antecedent, does it amount, my lords?
bona fide purchaser.
Yes.
Yes.
Once bona fide, even in terms of civil litigation, section 19 of special fact says that one, if you're a bona fide purchaser, even a sale deed will not defeat your right.
Yes.
And indeed, Millets, I knew my limitations. So I put the onus on the supplier that you please bring that to the doorstep. That is the port. And in the port, I purchase it from your own godown. And Millet, that's why, Millets, all through checkposts, all sorts of revenue authorities and road authorities, transport authorities, I may say, then at the threshold of the port, all the people, in fact, Millets, all the depositions of those persons and their statements, and also we have given, for my lord's kind consideration, the RTI answers we have got, what are the checks and balances in this process. All that's been said, that the responsibility has been cast on them. And once it has come, in terms of the old Indian Evidence Act 114, Millets, I have every right to presume that an official act has been done in accordance with law, with due process, and I have taken it. And Millets, my lords may kindly appreciate one thing. Can they show anywhere except an allegation in what manner to demonstrate that I've conspired with them, I myself being a victim? Had it been a case of, Millets, having a wrongful gain at the expense of someone else, I mined a lot of material, I sold it after transporting myself. I could have done the same thing there too. And I have purchased from many other sources which they have acknowledged. There too, that is not there. And these are the two renegade suppliers. And perhaps you can go after them and have them, if at all the prosecution wants them. Somebody, a victim, should they prosecute a victim in the whole process? That's all my humble submission, Millets.
Yes. Heard the learned Barkonte. Reserved, sir.
Just one point.
Yes, Rahul.
It's regarding the citations given by learned senior counsel. Lots, two citations latest of the Supreme Court has been given of a bench consisting of two judges. Lots, I had also produced a citation, which is a coordinate bench of two judges. Lots, Article 141 says If,
Oh, subsequent should be followed.
no,
Then
the earlier should be followed.
who said?
Look,
Yes.
I'll just produce along. The earlier should
Yes.
follow if the subsequent is passed without considered.
If a larger strength,
No,
bench of larger strength is not considered in a subsequent judgment, the larger bench of larger strength will hold the field. That's all right. If it is coordinate benches,
Correct.
the later will follow.
no.
The earlier will follow. Yes.
I'll produce a citation.
ಉಲ್ಟಾ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
I'll
Yes.
just.
All right.
Millets, there's been lot of judicial cleavage on this point, as my lords may can appreciate. If your lordship check full courts of each high court, my lords could see each high court rendered at least one judgment of a full court, full bench rather, Millets,
Yes.
saying which one should prevail. Is it the previous one or the later one? And
It's a later
90% of the high courts have held, Millets, that the later one. Then Millets in 1990s, an
As
interesting
far as I knew,
development.
yes.
Millets, I'm just submitting. Millets. It's only for the sake of record, Millets. It's only for the sake
Yes,
of
yes,
record.
we'll see. Yes.
In 1990s, Millets, one interesting case came up before Madhya Pradesh High Court. That is Jabalpur bus operators case, Millets. In that
Yes.
one, a full bench has rendered the same judgment after following Bombay High Court and the Punjab and Haryana High Court, that the later one should prevail. Then
Correct.
Millets, some other bench has doubted that and placed that before 5-judge bench, a larger bench of the Honorable High Court. Then
The later
Millets,
one
they
will
have said, and later Millets, the 5-judge bench has said, once a judgment has been rendered, in ignorance of that, a co-equal bench later renders another judgment. In ignorance, if it refers to that one, the later judgment prevails. But if it's not been referred to, the previous judgment prevails. This is one judgment, Millets. And recently, in Sandeep Bafna's case, Millets, in Supreme Court, that's about 5-7 years ago, Millets, Sandeep Bafna's case for the first time has clarified to the extent that they've used their expression, Millets, the case of old vintage should prevail. This is the expression they have used that, Millets. Thereafterwards, now the Honorable Supreme Court has started the practice, but my lords, when your lordship see the statutory settled position of law as rendered by various high courts, Millets, and the commentaries on that one, including Professor Lakshmikant's law of precedent,
Yes,
Millets, it has
precedents.
been endorsed that the later one should prevail. But Sandeep Bafna now has changed the position, it seems.
We'll
Millets.
see.
It's purely academic discussions
no?
I've submitted
In
since that's
fact, I
been
had
raised.
taken a cue from Sir's book on Vepapi Sarathis on iOS. So that is where I also got this. So therefore I used that.
Millets, in fact, I had the occasion to revise that one. I remember
Yes,
these
yes.
things.
I had taken a cue from his book.
Yes.
Grateful for the opportunity.
Yes.
Please. Great.
Rahul, give that judgment.
Millets,
Yes,
Millets,
Kumar.
could my lords permit us to file a 3-page, 4-page written submission
Yes, yes,
to help
please do.
to
Please
aid
do,
your
sir.
lordship's adjudication?
ನೀವು
We will.
ಹಾಕೊಂಡಿದ್ದೀರಾ? Yes.
In fact, in that note only in starting.
Ah, sorry. You should file. Yes. Yes, sir.
Grateful. Deeply obliged.
Great.
Yes.
Great.
ಇದ್ಯಾವ್ದು ಅಷ್ಟೇ ಅಲ್ಲ?
ನೋಡಿ entry modus.
ಅಷ್ಟು ಬರ ಅದೆಲ್ಲ ಆಗುತ್ತೆ. ಚಿದಾನಂದ ಸರ್ ಇದ್ದಾರೆ. ನಿಮ್ದೇನ್ ಮುಗಿಯಲ್ಲ ಬಿಡಿ.
Student matter ಸ್ವಲ್ಪ ಏನಾದ್ರು.
2 ವರ್ಷದಿಂದ ಸ್ಟೂಡೆಂಟ್ ಮ್ಯಾಟರ್ ಇರಲಿಲ್ವಾ?
There is an interim order now.
I will
because
post
of
it
the-
on 29th. ಅವಾಗ ಬೆಂಚ್ ಚೇಂಜ್ ಆಗಿರುತ್ತೆ. It will go to the roster bench.
Right.
2 years ಇಂದ no urgency. Now you have urgency.
There is an interim order granted by this court.
That will continue.
Right, that will continue, but the university, my lad, even if the Dental Council of India, Union of India grants me the permission, without LIC and the
We'll see.
affiliation by the
I'll post it
university.
on 28th.
Earlier,
ಇದೇನಾಗಲ್ಲ. So we are seeing where is the time, and arguments will have to be made for 1 hour. Can't. No time. Because it has come before me as not because the roster bench is now disabled. 28th change ಆಗುತ್ತೆ. 28th change ಆಗುತ್ತೆ.
25th, your lordship may hear at least on this thing. 23rd or.
No, ಎರಡು ಆಗಲ್ಲ. ಸುಮ್ಮನೆ I'll be making you wait unnecessarily. Look at the list. It's difficult. 28ಕ್ಕೆ ಹಾಕ್ತೇನೆ. Take chance. Because if you are agreeable to the thing that they would, you would comply with it and close it.
Now, compliance is because of the 2006 regulations.
So that is why it's not a small matter, sir.
Fact, my lord, if I take your lordship. my
It
lord, I
requires
have
at
a
least
short
2
note.
hours to hear and to
Tomorrow day
dictate.
after. I'll not take more than 10-15 minutes, my lord. I have given the short notes to that, my lord.
No time
Now,
at all,
all
sir.
these, the compliances, my lord, 2006, my lord. One is, my lord, now they say that boys' hostel should be there within the college premises. That time there was no requirement in 1983 regulation.
And that's why it requires hearing in depth. We'll take it on 28th. List on 28th. 1-1?
Under 9. No. Under 9.
Interim order to be continued.
That will continue, sir. Interim order will not second.
May please, my lord. My lord, in this, CBI has filed its objection also, please, my lord.
You are appearing for the CBI, madam?
Yes.
CBI, then if you hand it over to the CBI, they'll investigate. That's all. If you have any objection,
So we didn't have a manpower to investigate the case.
You don't
No
have?
infrastructure. Last time also this honorable court has ordered to investigate the Srinivas case in Vaidehi Medical College. Court has ordered infrastructure also. They are not at all cooperating with the state.
that
state.
Supreme Court has now affirmed it and
Yes, it is
directed.
affirmed and now investigation
Now you
is
should tell
on.
the apex
State is
court.
not at all.
My order there handing over to CBI is affirmed.
Investigation is in progress, Your Honor, but no cooperation from the state, sir.
State should
So in
do
this case
some,
also,
pass some
we had a
order.
lot of cases. If this case is also
Okay.
allotted, we didn't have infrastructure.
CBI gadre cooperate madalva. What will cooperate?
No.
That's why they're objecting to every transfer because
Yes.
state won't cooperate.
State won't cooperate. In spite of this case also come, they won't cooperate because we need a manpower, infrastructures, vehicles, nothing will be given by them. And we are shortage of all those things.
Has a point.
The complexity.
That doesn't mean we
I
should not
fully
transfer.
understand, please, my lord. I fully understand.
SIT is constituted.
If that
in
is
this-
the case, please, my lord, an officer who is from outside Karnataka has to be appointed, please, my lord. Otherwise, the reason is that, my lord,
No,
even
because
ACP is
I-
involved.
Constituted a unique team, one CBI and 2 other state officers.
Certainly, please.
Our cooperation is complete.
Yes, please, my lord. That would serve the purpose also, please, my lord.
We'll
The
see.
reason is that, my lord, ACP is also involved in destruction of evidence, please, my lord, in causing destruction, please, my lord. And he allowed the prime accused, please, my lord, to run away from the scene of occurrence for about 15 hours. After 15 hours, please, my lord, he was asked to come back and surrender. Then, my lord, a suicide note was tendered before him, please, my lord.
The accused is the husband.
Yes, please, my lord. First accused is the husband, please, my lord.
All right.
And he served in the same police station.
We'll have to.
And ACP is the immediate supervising
We'll have to
officer.
resolve
please, my lord.
something with madam's submission.
Certainly,
Not-
please.
Not to send it to CBI, but constitute some team. We'll see, madam. Yes,
Publish, please, my lord.
yes.
Grateful.
You're not from this place?
No, from Kerala, sir.
All right, yes. So we'll pass that order. We'll see. If you're here, you can come.
I'm posted here in Bangalore itself.
Oh, you're here itself. Then you come on Friday.
Yes.
Yes. Friday.
Publish.
ಆಮೇಲೆ ಹಾಕ್ತೀನಿ. ಇನ್ಯಾವುದಿಲ್ಲಲ್ಲ?
Pass over ಮಾಡಿ.